ರೂಮ್ ಇನ್ನ ಇದೆ. Lavanya, you must start.
Yes.
Yes, sir. Some days are better than others, but every day has the potential to be the best day of your life. Hoping that today is such a blissful day, I wish you all a very good morning. I, Lavanya A. Udupi, student, KSLU's Law School, welcome you all to the national webinar on Evolving Constitutional Relations between the Legislature, the Executive and the Judiciary, organized by the Department of Law and Parliamentary Affairs, Government of Karnataka, in association with Research Center in Democracy and Constitutional Government, Karnataka State Law University, Hubballi. Welcome you all. It is said that a day without prayer is a day without blessings, and that is why it is our tradition to commence any auspicious occasion by praying the Lord Almighty. So I call upon Ms. Pramati, student, KSLU's Law School, to invoke the blessings of Lord Almighty.
वीणापाणि विश्वकल्याणी, वीणापाणि विश्वकल्याणी, गायन नर्तन नन्दप्रदायिनी, वीणापाणि विश्वकल्याणी, युग युगदली जगಕ್ಕೆ ನಿನ್ನೊಲವಿನ ಸೊಗಸು ನೀ ಸೂಸುತೆ ನಗುತ್ತನಿಂದಿಹೆ, ಮುಗುದನಿ ಕೇಳೋಳ್ಪ ಸೊಗಸಿನಿ ಕೇಶವಂ, ಮುಗುದನಿ ಕೇಳೋಳ್ಪ ಸೊಗಸಿನಿ ಕೇಶವಂ, ಮುಗಿಯದೆ ಸರಸವ ನಲಿವರಧಾರೆ, ಮುಗಿಯದೆ ಸರಸವನಲೆ ವರಧಾರೆ, ವೀಣಾಪಾಣಿ ವಿಶ್ವಕಲ್ಯಾಣಿ, ವೀಣಾಪಾಣಿ 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 ವಿಶ್ವಕಲ್ಯಾಣಿ. Thank you.
Thank you, Pramati. Now I would like to call upon Professor G.B. Patil, Registrar Evaluation, Karnataka State Law University, to welcome the gathering. Please, sir.
G.B. Patil, sir.
ಸರ್ ಅವ್ರೇನೋ ಲಾಗೌಟ್ ಆದಂಗೆ ಕಾಣಿಸುತ್ತೆ ಸರ್. ಆಮೇಲೆ ಲಾ ಮಿನಿಸ್ಟರ್ ಸರ್ ಪ್ರಿನ್ಸಿಪಲ್ ಸೆಕ್ರೆಟರಿನೂ ಜಾಯಿನ್ ಆಗಿಲ್ಲ ಸರ್ ಇಲ್ಲಿ.
ಇದ್ದಾರೆ?
ಇಲ್ಲ ಸರ್, ದೇವರ್ ಇನ್ ದ ಬ್ರೇಕ್ಔಟ್ ರೂಮ್, ಬಟ್ ಇಲ್ಲಿ ಜಾಯಿನ್ ಆಗಿಲ್ಲ ಸರ್.
ಓ, ಇನ್ನು ಅವ್ರ ರೂಮಲ್ಲಿ ಇದ್ದಾರೆ. ಅಭ್ಯುದಯ್
ಸರ್ ಇಲ್ಲಿ ಹೋಸ್ಟ್ ಮಾಡ್ಬೇಕು ಸರ್, ಇವನ್ ವಿ ಸಿ ಸರ್ ಕೂಡ.
ಅಭ್ಯುದಯ್,
Yes, sir.
ಅದು ಬ್ರೇಕ್ಔಟ್ ರೂಮ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ.
No, sir. We have removed the breakout room, sir.
ಇನ್ನೊಂದು ರೂಮ್ ನಂಬರ್ 1 ತೋರಿಸ್ತಾ ಇದೆ ನೋಡಿ.
ಏನಂತಿದೆ ಹೆಸರು, ಏನಂತಿದೆ ಸರ್? G.B. ಪಾಟೀಲ್ ಅಷ್ಟೇ.
ಲೀವ್ ರೂಮ್ ಅಂತ ಮಾಡಬೇಕು. ಬರಂಗೌಡ್ರದ್ದು
ಇಲ್ಲ ಅವ್ರು ಮಾತಾಡಲಿ, ನಾನೇ
GB Patil sir. GB Patil.
ಆ ಮನುಷ್ಯನ ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
Sir, everyone are co-host now, sir.
Lavanya, you can begin the program once again.
Beginning you can continue.
Yes, sir.
One
Yes.
sentence ಅಲ್ಲಿ welcome ಮಾಡ್ಲಿಕ್ಕೆ ಹೇಳಿ start ಮಾಡಿ.
I welcome you all. So I now call upon Professor GB Patil, Registrar Evaluation, Karnataka State Law University, to welcome the gathering. Please, sir.
ಅವ್ರು ಕನೆಕ್ಟ್ ಆಗ್ತಾ ಇಲ್ಲಪ್ಪ.
Good morning, everyone. On behalf of the Karnataka State Law University, I extend a very cordial welcome with all the respect at my command to Honorable Pro-Chancellor of the University, Shri J.C. Madhuswamy, Minister for Law and Parliamentary Affairs. I extend a very cordial welcome to Professor Vijay Kumar, Vice Chancellor, National Law University, Goa. I extend a welcome to our Honorable Vice Chancellor, Professor P. Ishwarbhat, and our Honorable Law Secretary, Shri Nayak Sir, and Shri Tirlapur Sir, our Registrar Evaluation, Dean, and all the invitees who are present here on the platform. I extend a very cordial welcome to each and everyone. Thank you very much.
Thank you, sir. I now request Shri J.C. Madhuswamy, Honorable Minister for Law and Parliamentary Affairs and Legislation, Minister for Minor Irrigation, and also the Pro-Chancellor of Karnataka State Law University, Hubballi, to take over the forum for the inaugural address. Please, sir.
Mr. Sri Vijay Kumar, Mr. Sri Venkatesh Nayak, Sri Ishwarbhat, and all the important persons in the webinar. Hello.
Yes, sir. You are audible, sir.
Audible. KSLU ಇವತ್ತು ಒಂದು ಒಳ್ಳೆ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ನನಗೆ ಕರೆದು ಇದನ್ನ ಉದ್ಘಾಟನೆ ಮಾಡ್ಲಿಕ್ಕೆ ಕೇಳ್ಕೊಂಡೋದಕ್ಕೆ ನಾನು ನಿಮ್ಗೆ ಬಹಳ ಆಭಾರಿಯಾಗಿದ್ದೀನಿ. ಇತ್ತೀಚಿನ ದಿನಗಳಲ್ಲಿ ಬಹಳ ಪ್ರಾಮುಖ್ಯತೆ ವಹಿಸಿರೋ ವಿಷಯನ ಇವತ್ತು ಕಾನೂನು ವಿದ್ಯಾರ್ಥಿಗಳ ಮಧ್ಯೆ ಚರ್ಚೆಗೆ ತಂದಿರೋದು ನಿಜವಾಗ್ಲೂ ಒಳ್ಳೇದು ಅಂತ ಹೇಳ್ತಾ, ಪವರ್ ಇಸ್ ದಿ ಸೆಂಟರ್ ಫಾರ್ ಆಲ್ ಕರಪ್ಷನ್ಸ್ ಅಂಡ್ ಡಿಕ್ಟೇಟರ್ಶಿಪ್ ಅಂತ ನಮಗ್ ಗೊತ್ತಿದೆ. ಪವರ್ನ ಹೇಗೆ ಡಿವ್ಯಾಲ್ವ್ ಮಾಡಬೇಕು, ಪವರ್ನ ಹೇಗೆ ಶೇರ್ ಮಾಡಬೇಕು ಅನ್ನೋದು ಕೂಡ ನಮ್ಮ ಕಾನ್ಸ್ಟಿಟ್ಯೂಯೆಂಟ್ ಅಸೆಂಬ್ಲಿನಲ್ಲಿ ಬಹಳ ಚರ್ಚೆ ಆಗಿದೆ. ಒಂದ್ಸಲ ಪವರ್ ಬಂದ್ರೆ ಮನುಷ್ಯ ಹೇಗೆ ವರ್ತಿಸ್ಬಲ್ಲ, ಏನ್ ಮಾಡಬಲ್ಲ, ಅದನ್ನ ಹಿಡಿತದಲ್ಲಿ ಇಡ್ಲಿಕ್ಕೆ ಏನ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋ ಚರ್ಚೆಗಳು ಕೂಡ ಅನೇಕ ಆಗಿ ನಾವು ಆದ್ಯದಲ್ಲಿ ಅಮೆರಿಕನ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅನ್ನ ಸ್ಟಡಿ ಮಾಡಿ ಸಪರೇಷನ್ ಆಫ್ ಪವರ್ಸ್ ವಿತ್ ಫಿಕ್ಸ್ಡ್ ಫೀಚರ್ಸ್ ಇರೋ ಒಂದು ಸಂವಿಧಾನನ ಓದಿದ್ವಿ. ಅದೇ ರೀತಿ ಇಂಡಿಯಾನಲ್ಲೂ ಆಗ್ಬೇಕು ಅಂತ ಹೇಳಿ ಸನ್ಮಾನ್ಯ ಪ್ರೊಫೆಸರ್ KT ಶಾ ಅವರು ಕಾನ್ಸ್ಟಿಟ್ಯೂಯೆಂಟ್ ಅಸೆಂಬ್ಲಿನಲ್ಲಿ ಮೂವ್ ಮಾಡಿದಾಗ ಕೆಂಗಲ್ ಹನುಮಂತೇನವರಿಂದ ಹಿಡಿದು ಅನೇಕ ಜನ ಅದನ್ನ ಪ್ರತಿಭಟಿಸಿ ಅಥವಾ ವಿರೋಧ ಮಾಡಿ ಯು ಆರ್ ಅಗೇನ್ ಮೂವಿಂಗ್ ಇಂಡಿಯಾ ಟು ಪ್ರೆಸಿಡೆನ್ಷಿಯಲ್ ಫೋರಮ್ ಆಫ್ ಗವರ್ಮೆಂಟ್. ಇಲ್ಲೂ ಕೂಡ ಡೆಮೋಕ್ರಸಿಗೆ ಬದಲು ಪ್ರೆಸಿಡೆನ್ಷಿಯಲ್ ಫೋರಮ್ ಬರೋ ಸ್ಥಿತಿ ತಂದು ವೀಟೋ ಮಾಡುವಂತ ಪರಿಸ್ಥಿತಿ ತರೋದು ಬೇಡ ಅಂತೇಳಿ ನಾವು ಅಧಿಕಾರ ವಿಕೇಂದ್ರೀಕರಣ ಆಗೋ ಕಡೆ ಮೂರು ಭಾಗಗಳನ್ನ ಮಾಡ್ಕೊಂಡ್ವಿ. ಲೆಜಿಸ್ಲೇಚರ್, ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಅಂಡ್ ಜುಡಿಷಿಯರಿ. ಬಿಕಾಸ್ ವಿ ಆರ್ ಇನ್ ಎ ಡೆಮೋಕ್ರಸಿ, ಸರ್ಟನ್ಲಿ ಲೆಜಿಸ್ಲೇಚರ್ ವಿಲ್ ಪ್ರಿವೇಲ್ ಓವರ್ ಅದರ್ಸ್ ಅನ್ನೋದು ನಮ್ಮ ಭಾವನೆ. ಯಾಕೆಂದ್ರೆ ಲೆಜಿಸ್ಲೇಚರ್ಸ್ ವಿಲ್ ಹ್ಯಾವ್ ದಿ ಮ್ಯಾಂಡೇಟ್ ಆಫ್ ದಿ ಪೀಪಲ್. ಜನಗಳಿಂದ ಆಯ್ಕೆಯಾಗಿ ಜನಗಳ ಪ್ರಾತಿನಿಧಿಕ ಹಕ್ಕನ್ನು ಪಡೆದು ಬಂದಿರ್ತಾರಾದ್ರಿಂದ ರಾಜ್ಯವನ್ನ ಆಳ್ಲಿಕ್ಕೆ ಏನು ಕಾನೂನು ನಿಯಮ ಮತ್ತು ನೀತಿ ಮಾಡ್ಬೋದು, ಅದು ಲೆಜಿಸ್ಲೇಚರ್ಗೆ ದತ್ತವಾಗಿರುವಂತ ಶ್ರೇಷ್ಠ ಅಧಿಕಾರ. ಹಾಗಾಗಿ ಲೆಜಿಸ್ಲೇಚರ್ಸು ಬಹಳ ಉತ್ತಮವಾಗಿ ಕೆಲಸ ಮಾಡಬೇಕಾಗತ್ತೆ, ವಿಷನ್ ಬೇಕಾಗುತ್ತೆ, ಫೋರ್ಥಾಟ್ ಬೇಕಾಗುತ್ತೆ, ಪ್ರೋಸ್ ಅಂಡ್ ಕಾನ್ಸ್ ಆಫ್ ಎ ಲಾ ಅವ್ರಿಗೆ ಗೊತ್ತಿರ್ಬೇಕಾಗುತ್ತೆ. ನಾನು ಅನೇಕ ಸಲ ಮಾತಾಡ್ತಾ ವಿಧಾನಸಭೆಯಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ, ಬಿಕಾಸ್ ದೇ ಹ್ಯಾವ್ ಕಮ್ ಫ್ರಮ್ ಆಲ್ ಕಾರ್ನರ್ಸ್ ಆಫ್ ದಿ ಲೈಫ್. ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಕೌಂಟ್ಸ್ ಇನ್ ಎನಾಕ್ಟಿಂಗ್ ಲಾಸ್ ಅಂತ. ಅವರ ಅನುಭವಗಳೇನಿರುತ್ತೆ ಅದು ಶಾಸನ ಮಾಡುವಾಗ ನಮ್ಗೆ ಹೆಚ್ಚು ಶಕ್ತಿಯನ್ನ ಮತ್ತು ಜ್ಞಾನವನ್ನ ಕೊಡುತ್ತೆ. ಅದ್ರ ಮುಖಾಂತರ ರಾಜ್ಯದ ಆಡಳಿತಕ್ಕೆ ಒಂದು ನೀತಿ ರೂಪಿಸ್ಲಿಕ್ಕೆ ಆಗತ್ತೆ. ನೀತಿ ರೂಪ ಆದ ನಂತರ ನಮ್ಗೆ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ವಿಲ್ ಹ್ಯಾವ್ ಟು ಕ್ಯಾರಿ ಔಟ್ ದಿ ಪ್ರೋಗ್ರಾಮ್ಸ್ ಅಂಡ್ ದಿ ಲಾ ಅಂಡ್ ಆರ್ಡರ್ ಅಂಡ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ಆಫ್ ದಿ ಸ್ಟೇಟ್ ಅಥವಾ ರಾಷ್ಟ್ರ. ಈ ನಾವು ಮಾಡಿದ ಶಾಸನದ ಕೆಳಗೆ, ನೀತಿ ಕೆಳಗೆ ಆಡಳಿತ ಮಾಡೋದು ಎಕ್ಸಿಕ್ಯೂಟಿವ್ಸ್ ಕೆಲಸ ಆಗತ್ತೆ. ಇದರ ಮೇಲೆ ಎಲ್ಲಾದ್ರೂ ಚೆಕ್ ಅಂಡ್ ಬ್ಯಾಲೆನ್ಸ್ ಇರಬೇಕಾಗುತ್ತೆ. ಬಿಕಾಸ್ ಐ ಆಲ್ರೆಡಿ ಟೋಲ್ಡ್ ಪವರ್ ಕರಪ್ಟ್ಸ್ ಅಬ್ಸಲ್ಯೂಟ್ಲಿ ಅಂತೇಳಿ. ಯಾರಿಗಾದ್ರೂ ಅಧಿಕಾರ ಬಂದ್ರೆ ಅವ್ರಿಗೆ ಇದು ನನಗೆ ಶಾಶ್ವತ, ನಾನು ಸರ್ವಶ್ರೇಷ್ಠ ಅನ್ನೋ ಭಾವನೆ ಬರೋದು ಸ್ವಾಭಾವಿಕ. ಅಂತ ಕಡೆ ಎಲ್ಲಾರು ಚೆಕ್ಸ್ ಅಂಡ್ ಬ್ಯಾಲೆನ್ಸಸ್ ಇರಬೇಕಾಗತ್ತೆ. ಯಾರಾದ್ರೂ ಗೈಡ್ ಮಾಡೋರು ಬೇಕಾಗತ್ತೆ. ಆ ಗೈಡ್ ಮಾಡೋ ಅಧಿಕಾರನ, ಚೆಕ್ಸ್ ಬ್ಯಾಲೆನ್ಸ್ ಇಟ್ಕೊಳೋ ಅಧಿಕಾರನ ನಾವು ಇವತ್ತು ಜುಡಿಷಿಯರಿಗೆ ಕೊಟ್ಟಿದ್ದೇವೆ. ಎಲ್ಲಾದ್ರೂ ಸಣ್ಣ ಪುಟ್ಟ ತಪ್ಪುಗಳಾದ್ರೆ, ಎಲ್ಲಾದ್ರೂ ನಾವು ಮಾಡೋ ಶಾಸನಗಳಲ್ಲಿ ಜನ ವಿರೋಧಿ ಆಗುವಂತ ಭಾವನೆಗಳಿದ್ರೆ, ಅಥವಾ ಸಂವಿಧಾನಕ್ಕೆ ವಿರೋಧ ಅಥವಾ ಅಡಚಣೆ ತರುವಂತ ಶಾಸನಗಳಿದ್ರೆ, ಅದನ್ನ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ನಾವು ನ್ಯಾಯಾಲಯಗಳು ಮತ್ತು ಜುಡಿಷಿಯರಿಯನ್ನ ಬಹಳ ಶಕ್ತಿಯುತವಾಗಿ ಸ್ಥಾಪನೆ ಮಾಡಿ ಇವತ್ತು ರಾಷ್ಟ್ರದಲ್ಲಿ ಮೂರೂ ಘಟಕಗಳು, ಮೂರು ಅಂಗಗಳು ಸಮರ್ಪಕವಾಗಿ ಕೆಲಸ ಮಾಡ್ಲಿಕ್ಕೆ ನಾವು ಸಂವಿಧಾನದ ಆಡಳಿತನ, ಸಂವಿಧಾನದ ಮೂಲಕ ಆಡಳಿತನ, ದಟ್ ಈಸ್ ರೂಲ್ ಆಫ್ ಲಾ, ನಾವು ಒಪ್ಕೊಂಡಿದ್ದೀವಿ. ಇವತ್ತು ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಇಂಡಿವಿಜುವಲ್ಸ್, ನಾನು ಕಾನ್ಸ್ಟಿಟ್ಯೂಯೆಂಟ್ ಅಸೆಂಬ್ಲಿ ಬಗ್ಗೆ ಮಾತಾಡ್ತಾ ವಿಧಾನಸಭೆನಲ್ಲಿ ಹೇಳಿದೆ, ಎಲ್ಲರಿಗೂ ಇವತ್ತು ಆಡಳಿತ ಮಾಡಬೇಕು ಅನ್ನೋ ಚಟ ಬಾಧಿಸಕ್ ಶುರು ಮಾಡ್ಬಿಟ್ಟಿದೆ. ಎವರಿ ವಾಂಟ್ಸ್ ಟು ಬಿ ಎಕ್ಸಿಕ್ಯೂಟಿವ್, ಆಲ್ ಲೆಜಿಸ್ಲೇಚರ್ಸ್, ಜಡ್ಜಸ್ ಅಂಡ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ಸ್ ದೆಮ್ಸೆಲ್ವ್ಸ್, ಎಲ್ಲರಿಗೂ ನಾನು ಆಡಳಿತ ಮಾಡಬೇಕು, ಆಡಳಿತದಲ್ಲಿ ಇನ್ವಾಲ್ವ್ ಆಗ್ಬೇಕು, ಆಡಳಿತನೇ ಶ್ರೇಷ್ಠ ಅನ್ನೋ ಭಾವನೆ ಬಂದು ಒಬ್ಬೊಬ್ರು ಮೇಲೆ ಆಕ್ರಮಣ ಮಾಡೋದು, ಒಬ್ಬೊಬ್ರು ಇನ್ನೊಬ್ಬೊಬ್ಬರ ಮೇಲೆ ಅತಿಕ್ರಮಣ ಮಾಡುವಂತ ಪರಿಸ್ಥಿತಿ ನಾವಲ್ಲೇ ಕಾಣ್ತಾ ಇದೀವಿ. ನಾವು ಶಾಸಕರು ಹೋಗೋದು ಎಕ್ಸಿಕ್ಯೂಟಿವ್ಸ್ ಮೇಲೆ ಬಿಡೋದು, ಎಕ್ಸಿಕ್ಯೂಟಿವ್ಸ್ ಬರೋದು ಶಾಸಕಾಂಗದಲ್ಲಿ ಪ್ರವೇಶ ಮಾಡೋದು, ಇದೆರಡರ ಮಧ್ಯೆ ಕೋರ್ಟು ಎಲ್ಲಾ ವಿಷಯದಲ್ಲೂ ಇವತ್ತು ತಂತನ ಕೂಡ ಪ್ರದರ್ಶನ ಮಾಡ್ಲಿಕ್ಕೆ ಸೃಷ್ಟಿ ಆಗಿರೋದು. ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ರಿಲೇಷನ್ಸ್ ಅಷ್ಟು ಚೆನ್ನಾಗಿ ಉಳಿತಾ ಇಲ್ವೇನೋ ಅನ್ನೋ ಭಾವನೆ ಬರ್ತಾ ಇದೆ. ಯಾಕೆಂದ್ರೆ ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಭಯ ಭೀತಿ ಸೃಷ್ಟಿ ಆಗ್ಬಿಟ್ರೆ ಶಾಸನಗಳ ಮಾಡೋದು, ಲೆಜಿಸ್ಲೇಚರ್ ಅನ್ನ ಸಮರ್ಪಕವಾಗಿ ನಡೆಸ್ಕೊಂಡು ಹೋಗೋದು ಕಷ್ಟ ಆಗುತ್ತೆ. ಈಚ್ ಅಂಡ್ ಎವ್ರಿ ಲಾ ಇನ್ ದಿ ಐ ಆಫ್ ಕೋರ್ಟ್ಸ್ ಕೆನಾಟ್ ಬಿ ಫಾರ್ಮುಲೇಟೆಡ್. ನಾವು ಮಾಡ್ಬೇಕಾದ್ರೆ ಕೋರ್ಟ್ಗೆ ಹೋದ್ರೆ ಏನಾಗುತ್ತೆ, ಕೋರ್ಟ್ ಏನ್ ಹೇಳುತ್ತೆ, ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ರ ಪರಿಸ್ಥಿತಿ ಏನಾಗ್ಬೇಕು ಅನ್ನೋದು ಇವತ್ತು ಸಾಮಾನ್ಯವಾದ ಪರಿಸ್ಥಿತಿ ನಿರ್ಮಾಣ ಆಗ್ಬಿಟ್ಟಿದೆ. ಯಾವುದೋ ಒಂದು ಇನ್ಸ್ಟೆನ್ಸ್ ತಗೊಳೋದು, ನೇರವಾಗಿ ಜಡ್ಜ್ಗಳೇ ಆಡಳಿತದಲ್ಲಿ ಭಾಗ ಆಗೋದು, ನೇರವಾಗಿ ಜಡ್ಜ್ಗಳೇ ಸೂಪರ್ವೈಸರಿ ಅಂಡ್ ಮಾನಿಟರಿಂಗ್ ಪವರ್ ತಗೊಳೋದು, ನೇರವಾಗಿ ಜಡ್ಜ್ಗಳೇ ಪ್ಯಾರಲಲ್ ಆಗಿ ಆಫೀಸರ್ಸ್ ವಿರುದ್ಧವಾಗಿ ಅಥವಾ ಅವರ ಸಮಾನಾಂತರವಾಗಿ ಆಡಳಿತದಲ್ಲಿ ಭಾಗವಹಿಸೋದು ಕೂಡ ನಾವು ನೋಡ್ತಾ ಇದ್ವಿ. ಲೀಗಲ್ ಸಿಲ್ ಅಥಾರಿಟಿ ಮಾಡಿದ್ವಿ. ಯಾವುದೋ ಒಂದು ಕೇಸ್ ಬರ್ಬೋದು ಅವ್ರ ಮುಂದೆ. ಹಾಗಂತ ಆರ್ ದೇ ಸಪೋಸ್ ಟು ಇಂಟರ್ಫಿಯರ್ ಇನ್ ಆಲ್ ದಿ ಆಸ್ಪೆಕ್ಟ್ಸ್ ಆಫ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ಅನ್ನೋ ಭಾವನೆ ಬರ್ತಾ ಇದೆ. ಮತ್ತೆ ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಯಾರೋ ಶ್ರೇಷ್ಠ ಇನ್ಯಾರೋ ಅಲ್ಲ ಅಂತ. ಇಟ್ಸ್ ಅ ಹ್ಯೂಮಿಲಿಯೇಟಿಂಗ್ ಸಿಚುವೇಶನ್ ವಿ ಆರ್ ಫೇಸಿಂಗ್. ಅನೇಕ ಸಲ ಜಡ್ಜ್ಗಳು ಕೂತ್ಕೊಳ್ಳೋ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಶಾಸಕರು ಬರಬಾರ್ದು, ಮಿನಿಸ್ಟರ್ಗಳು ಬರಬಾರ್ದು, ದೇ ಕೆನಾಟ್ ಶೇರ್ ದಿ ಡಯಾಸ್. ಇದೆಲ್ಲ ಎಂತ ಜಿಜ್ಞಾಸೆಗಳು ಸ್ಟಾರ್ಟ್ ಮಾಡಿದೆ ಅಂದ್ರೆ, ಸಂವಿಧಾನನ ನಾವೇನ್ ಮಾಡ್ಕೊಂಡು ನಮ್ಮ ಮಧ್ಯೆ ಬಾಂಧವ್ಯಗಳು ಇರ್ಬೇಕಾಗಿತ್ತು, ಅದಕ್ಕೆ ಸ್ಪಷ್ಟ ರಚನೆಗಳು ಆಗ್ಲಿಕ್ಕೆ ಆರಂಭ ಆಗಿದೆ. ಆಕ್ಟಿವಿಸಮೇ ಬೇರೆ, ಓವರ್ ಆಕ್ಟ್ ಮಾಡೋದೇ ಬೇರೆ. ಜುಡಿಷಿಯರಿ ಆಕ್ಟಿವಿಸಮ್ ಹ್ಯಾಸ್ ಟು ಬಿ ದೇರ್, ಬಟ್ ಜುಡಿಷಿಯರಿ ಓವರ್ ಆಕ್ಟಿವಿಸಮ್ ಓವರ್ ಆಕ್ಷನ್ ನೀಡ್ ನಾಟ್ ಬಿ ದೇರ್. ಯಾರಾದ್ರೂ ಅಷ್ಟೇ, ನಾವು ಕೂಡ ಕೋರ್ಟ್ ಅನ್ನ ಟೀಕೆ ಮಾಡೋದು, ಜಡ್ಜ್ ಅನ್ನ ಟೀಕೆ ಮಾಡೋದು ಶಾಸನಸಭೆನಲ್ಲಿ ಅಥವಾ ಶಾಸಕರಿಗೂ ಗೌರವ ತರೋದಲ್ಲ ಅಂತ ನಾನು ಅನೇಕ ಸಾರಿ ಹೇಳಿದ್ದೀನಿ. ಈ ಮಧ್ಯೆ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ಸ್ ಫ್ರೀಯಾಗಿ ಕೆಲಸ ಮಾಡುವಂತ ಒಂದು ವಾತಾವರಣನ ನಾವು ಸೃಷ್ಟಿ ಮಾಡಬೇಕು. ನಾವೇನು ಕಾನೂನುಗಳನ್ನ ಮಾಡಿರ್ತೀವಿ, ನಾವೇನು ನೇಮ್ಗಳು ಅಥವಾ ನೀತಿ ಮಾಡಿರ್ತೀವಿ, ಅದ್ರ ಕೆಳಗಡೆ ಅವರು ಕಾನೂನನ್ನ ಪಾಲನೆ ಮಾಡಿ ಕಾರ್ಯಕ್ರಮಗಳನ್ನ ಮತ್ತೆ ಪ್ರಾಜೆಕ್ಟ್ಸ್ ಅನ್ನ ಮಾಡುವಂತ ಒಂದು ಒಳ್ಳೆ ಸ್ಥಿತಿಯನ್ನ ನಿರ್ಮಾಣ ಮಾಡಿದ್ರೆ ರಾಜ್ಯದ ಅಭಿವೃದ್ಧಿ ಸುಗಮವಾಗ್ಲಿಕ್ಕಾಗುತ್ತೆ. ಎಕ್ಸಿಕ್ಯೂಟಿವ್ಸ್ ಕೂಡ ಇವತ್ತು ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಎಲ್ಲದಕ್ಕೂ ರಾಜಕಾರಣಿಗಳ ಹತ್ರ ಅಥವಾ ಲೆಜಿಸ್ಲೇಚರ್ಸ್ ಕಡೆ, ಮಿನಿಸ್ಟರ್ಗಳ ಕಡೆ ನೋಡುವಂತ ಪರಿಸ್ಥಿತಿನ ನಾವು ರಾಜ್ಯದಲ್ಲಿ ನಿರ್ಮಾಣ ಮಾಡಿಬಿಟ್ಟಿದ್ದೀವಿ. ಇದು ಎಲ್ಲಾದ್ರೂ ಒಂದ್ ಕಡೆ ಕಡಿಮೆ ಆಗ್ಬೇಕು. ನಾವು ಪಾಲಿಸಿ ಲೇ ಡೌನ್ ಮಾಡ್ಬೇಕು, ಅವ್ರದನ್ನ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಬೇಕು. ಇಫ್ ಸಮಥಿಂಗ್ ಗೋಸ್ ರಾಂಗ್, ಲೆಟ್ ದಿ ಜುಡಿಷಿಯರಿ ಇಂಟರ್ಫಿಯರ್. ಅವರು ನಮ್ಗೆ ಆಗಾಗ ಗೈಡ್ ಮಾಡ್ಬೇಕು. ಈ ಭಾವನೆಗೆ ನಾವು ಬಂದು ಒಬ್ರಲ್ಲ ನಾವು ಒಬ್ಬೊಬ್ಬರನ್ನ ಅರ್ಥ ಮಾಡ್ಕೊಂಡು ಕೆಲಸ ಮಾಡುವಂತ ಒಳ್ಳೆ ವಾತಾವರಣ ಸೃಷ್ಟಿ ಆದ್ರೆ ಸಂವಿಧಾನದ ಆಚರಣೆ ಮತ್ತು ರಾಜ್ಯದ ಅಭಿವೃದ್ಧಿ ಸಮರ್ಪಕವಾಗುತ್ತೆ ಅನ್ನೋ ಭಾವನೆ ನಮ್ದು. ಅದ್ರ ಬದಲಾಗಿ ಎಲ್ಲಾರು ಎಲ್ಲದಕ್ಕೂ ಬಾಯ್ ಹಾಕೋದು, ಎಲ್ಲಾರು ಎಲ್ಲದನ್ನ ಮಾಡಕ್ ಹೋಗೋದು, ಜುಡಿಷಿಯರಿ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ಬರೋದು, ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ಕ್ವಾಸಿ ಜುಡಿಷಿಯರಿ, ಸೆಮಿ ಜುಡಿಷಿಯರಿ ಹೆಸರಿನಲ್ಲಿ ಪೂರಾ ಜುಡಿಷಿಯರಿ ಪವರೇ ತಗೊಳೋದು. ಈ ಮಧ್ಯೆ ಲೆಜಿಸ್ಲೇಟರ್ಸ್ ಎಲ್ಲರಿಗೂ ನಾವು ಸುಪ್ರೀಂ ಅಂತ ಒದಿಸೋದು ಬಹುಶಃ ಈ ರಿಲೇಶನ್ಶಿಪ್ಗೆ ಅಡಚಣೆ ಆಗ್ತಾ ಇದೆ. ಅನೇಕ ಕೇಸ್ಗಳು, ಅನೇಕ ನಿದರ್ಶನಗಳು ನಮ್ಮ ಮುಂದೆ ಇದೆ. ಈ ಓವರ್ ಆಕ್ಟಿವಿಸಮ್ ಅನ್ನ ನಾವೆಲ್ಲಾದ್ರೂ ತಡಿಬೇಕಾಗುತ್ತೆ. ಮತ್ತೆ ಒಬ್ಬೊಬ್ರು ಅವರ ವ್ಯಾಪ್ತಿಯನ್ನ ಅರ್ಥ ಮಾಡ್ಕೊಂಡು ವಾಟ್ ಈಸ್ ಮೈ ಪವರ್ ಅಂಡ್ ಜೂರಿಸ್ಡಿಕ್ಷನ್ ಅಂತ ಯೋಚನೆ ಮಾಡಿ ನಮ್ಮ ಲಿಮಿಟ್ ಅಲ್ಲಿ, ನಮ್ಮ ಇತಿಮಿತಿ ಒಳಗೆ ನಾವು ಕೆಲಸ ಕಾರ್ಯ ಮಾಡುವಂತ ಪರಿಸ್ಥಿತಿ ನಿರ್ಮಾಣ ಆದ್ರೆ ಸಂವಿಧಾನಾತ್ಮಕವಾದ ಅಂಗಗಳೇನಿವತ್ತು ರಾಷ್ಟ್ರದಲ್ಲಿ, ರಾಜ್ಯದಲ್ಲಿ ಇದೆ, ಸಮರ್ಪಕವಾಗಿ ಕೆಲಸನ ನಿರ್ವಹಿಸ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ. ಒಬ್ರಿಗೊಬ್ರು ಅಡಚಣೆ ಮಾಡೋದು, ಪ್ರಶ್ನೆ ಮಾಡೋದು, ಒಬ್ರನ್ನೊಬ್ರು ಅಲ್ಲಲ್ಲೇ ತಡೆಯೋದೇ ಕೆಲಸ ಆದ್ರೆ ಕಾರ್ಯ ಸಾಧು ಆಗೋದಿಲ್ಲ. ಅನೇಕ ಸಲ ನಮಗೆ ಲೆಜಿಸ್ಲೇಚರ್ಸ್ ಆಗಿ ಕೆಲಸ ಮಾಡುವಾಗ ಇರಸುಮುರ್ಸಾಗುತ್ತೆ. ಎಲ್ಲದಕ್ಕೂ ಯಾರನ್ನ ನೋಡ್ಕೊಂಡು ಶಾಸನ ಮಾಡ್ಬೇಕು. ವಿ ಆರ್ ವರ್ಕಿಂಗ್ ಅಂಡರ್ ಸಂಬಡಿ ಎಲ್ಸ್ ಹೂ ಇಸ್ ಅವರ್ ಮಾಸ್ಟರ್ಸ್. ಅದಕ್ಕಾಗಿ ಡೆಮೋಕ್ರಸಿನಲ್ಲಿ ನಾವಿರ್ಬೇಕಾಗಿತ್ತಂತ ಅನ್ಸುತ್ತೆ. ಅಂತ ಸ್ಥಿತಿ ಲೆಜಿಸ್ಲೇಟರ್ಸ್ಗೆ ಅಥವಾ ಪಾರ್ಲಿಮೆಂಟ್ಗೆ ಬರಬಾರದು. ದೇ ಮಸ್ಟ್ ಬಿ ಫ್ರೀ ಟು ಎನಾಕ್ಟ್ ಲಾಸ್. ದೇ ಮಸ್ಟ್ ಫ್ರೀ ಟು ನೋ what has to be done for the country, what should be the vision for our parliament or assembly. ಇದನ್ನ ನೋಡ್ಕೊಂಡು ಮಾಡ್ಬೇಕು. ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಅಷ್ಟೇ. ಇವತ್ತು ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲ, ಕಾರ್ಯಾಂಗ ಒಂದು 50-60% ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಬರೀ ಕೋರ್ಟ್ ಕಡೆ ನೋಡ್ಕೊಂಡು ಕೆಲಸ ಮಾಡೋ ಪರಿಸ್ಥಿತಿ ಇದೆ. ಅದರಲ್ಲೂ ನಾನು ನಿಮ್ಗೆ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳ್ತೇನೆ. ನಾನು ಅನೇಕ ಸಲ ಮಾತಾಡ್ತೀನಿ. ಫಾರೆಸ್ಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, ಫಾರೆಸ್ಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಈಸ್ ನಾಟ್ ಅಟ್ ಆಲ್ ವಿತ್ ಇನ್ ದಿ ಕಂಟ್ರೋಲ್ ಆಫ್ ದಿ ಸ್ಟೇಟ್. ದೇ ಆರ್ ವರ್ಕಿಂಗ್ ಅಂಡರ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಂತಲೇ ನಾನೊಂದು ಭಾಷಣದಲ್ಲಿ ಹೇಳ್ಬಿಟ್ಟೆ. ಮಾತಾಡಿದ್ರೆ ಸರ್ ಕೋರ್ಟ್ ಡಿಸಿಷನ್ ಆಗಿದೆ, ಕೋರ್ಟ್ ಡಿಸಿಷನ್ ಇದೆ, ಕೋರ್ಟ್ ಹಾಗೆ ಹೇಳ್ಬೋದು, ಕೋರ್ಟ್ ಹೀಗೆ ಹೇಳ್ಬೋದು. ಈ ಚರ್ಚೆಗಳೇ ಆಗ್ತಾ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಸ್ಟ್ಯಾಂಡ್ ಸ್ಟಿಲ್ ಪೊಸಿಷನ್ ಬಂದಿದೆ. ಅದು ಅವ್ರಿಗೆ ಕಾಲ ಕಳೀಲಿಕ್ಕೂ ಆಗುತ್ತೆ, ಅವ್ರು ಬೇಕಾದ ಇಶ್ಯೂಸ್ ತಗೊಳ್ಲಿಕ್ಕೂ ಆಗುತ್ತೆ. ನಮ್ಮ ಮೇಲೆ ಕೋರ್ಟ್ ಹೇಳೋದು, ಕೋರ್ಟ್ ಮೇಲೆ ನಮ್ಗೆ ಹೇಳೋದು. ಹಾಗಾಗಿ ಮತ್ತೆ ಆರಾಮಾಗಿ ಅವರು ಟೈಮ್ ಪಾಸ್ ಮಾಡ್ಕೊಂಡು ಹೋಗೋ ಪರಿಸ್ಥಿತಿ ಬಂದ್ರೆ ರಾಜ್ಯದ ಅಭಿವೃದ್ಧಿ ನಾವು ನಿರೀಕ್ಷೆ ಮಾಡಿದಂತ ಸ್ಥಿತಿಗೆ ತಲುಪೋಕ್ ಆಗೋದಿಲ್ಲ. ಹಾಗಾಗಿ ಮೈ ಪರ್ಸನಲ್ ವ್ಯೂ, ಮೂರೂ ಅಂಗಗಳು ಅವ್ರವ್ರ ವ್ಯಾಪ್ತಿನ ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು. ನಾನು ಹೇಳಿದೆ ಅಸೆಂಬ್ಲಿ ನಿಂತ್ಕೊಂಡು, ಅನ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಅವರ ಪೊಸಿಷನ್ ಅಲ್ಲಿ ನಿಂತ್ಕೊಂಡು ನೋ ಅಂತ ಹೇಳೋದಕ್ಕೂ ಕೂಡ ತಯಾರಾಗ್ಬೇಕು. ಅಟ್ ಟೈಮ್ಸ್ ನೋ, ಇಟ್ ಈಸ್ ನಾಟ್ ಅಂಡರ್ ಲಾ, ಇಟ್ ಈಸ್ ನಾಟ್ ಅಂಡರ್ ಪ್ರೊಸೀಜರ್. ಹಾಗಾದ್ರೂ ಒಬ್ರು ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಹೇಳುವಂತ ಕಾಲ ಬಂದಿದ್ರೆ ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಲೆಜಿಸ್ಲೇಟರು ಅವ್ರ ಪರಿಮಿತಿನ ತಿಳ್ಕೊಂಡವ್ರು. ಈಗಿಲ್ಲ, ಯಾರು ಹೇಳ್ತಾರೆ, ಮಂತ್ರಿನೋ ಅಥವಾ ಶಾಸಕರು ಹೇಳ್ತಾರೆ, ಅದೇ ಅವರ ನೇಮ ಆಗ್ಬಿಡುತ್ತೆ, ಅದೇ ಅವರ ಪ್ರಾಕ್ಟೀಸಸ್ ಆಗಿ ಸ್ವಲ್ಪ ಸಡ್ಲ ಆಗ್ಬಿಟ್ಟಿದೆ ಆಡಳಿತ. ಇದು ಸರಿಯಾಗ್ಬೇಕಂದ್ರೆ ಆಲ್ ದೀಸ್ ತ್ರೀ ವಿಂಗ್ಸ್ ಹ್ಯಾಸ್ ಟು ಕೊಲಾಬರೇಟ್ ಬಿಟ್ವೀನ್ ಈಚ್ ಅದರ್. ಒಬ್ರಿಗೊಬ್ರು ಸಹ ಬಾಳ್ವನ್ನ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ. ಈ ಸಹಯೋಗ ಇಟ್ಕೊಂಡು ಕೆಲಸ ಮಾಡಿ ಎಲ್ಲಿ ನ್ಯಾಯಾಲಯ ಇಂಟರ್ಫಿಯರ್ ಆಗೋದು ಸೂಕ್ತ. ಯಾಕೆ ನಿಮಗೆ ಗೊತ್ತು, ಅನೇಕ PAL, ನಾಚಿಕೆ ಆಗುತ್ತೆ ನಮ್ಗೆ ಇವೆಲ್ಲ ಮಾತಾಡ್ಲಿಕ್ಕೆ. ಈ PAL ಪ್ರಾವಿಷನ್ ತಂದಿದ್ದು, ಕಂಟೆಂಪ್ಟ್ ಆಫ್ ಕೋರ್ಟ್ ಪ್ರಾವಿಷನ್ ತಂದಿದ್ದು ಹಿಂಸೆ ಕೊಡೋಕ ಅನ್ನೋ ಪರಿಸ್ಥಿತಿ ಬಂದ್ಬಿಟ್ಟಿದೆ. ಪಬ್ಲಿಕ್ ಇಂಟ್ರೆಸ್ಟ್ ಲಿಟಿಗೇಷನ್ ಅಲ್ಲಿ ಎನಿಬಡಿ ಹೂ ಇಸ್ ರಿಲೇಟೆಡ್ ಆರ್ ನಾಟ್, ಹೂ ಇಸ್ ಇನ್ ಎನಿ ವೇ ಕನ್ಸರ್ನ್ಡ್ ಆರ್ ನಾಟ್, ಕ್ಯಾನ್ ಗೋ ಬಿಫೋರ್ ಎ ಕೋರ್ಟ್ ಅಂಡ್ ಆಸ್ಕ್ ಸಮ್ ರಿಲೀಫ್ ಅಥವಾ ಏನೋ ಒಂದು ಡೈರೆಕ್ಷನ್ ಕೊಡಿ, ಮತ್ತೊಂದು ಮಾಡಿ ಅಂತ ಹೇಳಿ ಎಲ್ಲದಕ್ಕೆ ಇವತ್ತು PAL ಅನ್ನ ಅಸ್ತ್ರ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟು PIL ಬಳಸೋದು. ಮತ್ ಕೋರ್ಟ್ಗಳು ಕೂಡ ಸಣ್ಣ ಪುಟ್ಟಕ್ಕೆಲ್ಲ ಕಂಟೆಂಪ್ಟ್ ಅವ್ರು ಹೇಳಿದ ಮಾತನ್ನ ಒಂದು ಚೂರು ಡಿಲೇ ಆದ್ರೂ ಕಂಟೆಂಪ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ ಅನ್ನೋದು ಈ 2 ಬ್ರಹ್ಮಾಸ್ತ್ರಗಳಿಗೆ ಇವತ್ತು ಕೋರ್ಟ್ ಯಥೇಚ್ಛವಾಗಿ ಬಳಸ್ತಿರೋದು ಕಡಿಮೆ ಆಗ್ಬೇಕು. ನಾನು ಪರ್ಸನಲಿ ಫೀಲ್ ನಂಬರ್ ಆಫ್ PILs has to be scrutinized. PIL ಯಾತಕ್ಕೆ ಆಗ್ತಾರೆ ಏಕಾಗ್ತಾರೆ ನೋಡ್ಬೇಕು. ಆ PILಗಳ ಪ್ರಾಮುಖ್ಯತೆ ಪಾಲಿಸಿ ಮ್ಯಾಟರ್ಗಳಿಗೆಲ್ಲ ಕೋರ್ಟ್ ಇಂಟರ್ಫಿಯರ್ ಆಗೋದು, ಕೋರ್ಟ್ ಗೋಶಾಲೆ ಮಾಡಿ ಅನ್ನೋದು, ಕೋರ್ಟ್ ಮತ್ತೊಂದು ಮಾಡಿ ಅನ್ನೋದು, ಮಗದೊಂದು ಮಾಡಿ ಅನ್ನೋದು, ಗೌರ್ಮೆಂಟ್ಗೆ ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ ಇದೆಯಾ ಇಲ್ಲ ಅಂತ ನೋಡಂಗಿಲ್ಲ, ಗೌರ್ಮೆಂಟ್ ರಿಸೋರ್ಸಸ್ ಏನು ಅಂತ ಗೊತ್ತಿಲ್ಲದೆ ಕೂತ್ಕೊಂಡು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ರೆ ಯಾವತ್ತಾರ ಒಂದ್ ದಿವಸ ಇವೆಲ್ಲ ಇನ್ಫ್ರಕ್ಚುಯಸ್ ಡಿಸಿಷನ್ಸ್ ಆಗ್ಬಿಡ್ತವೆ. ಆಗ ಗೌರವ ಎಲ್ಲಾರ್ದು ಹೋಗುತ್ತೆ. ಇಫ್ ಎ ಡಿಸಿಷನ್ ಬಿಕಮ್ಸ್ ಇನ್ಫ್ರಕ್ಚುಯಸ್ ವಿ ಕೆನಾಟ್ ಇಂಪ್ಲಿಮೆಂಟ್. ನಾನೊಂದು ಸಣ್ಣ ಘಟನೆ ನಿಮ್ಗೆ ಹೇಳ್ಬಿಟ್ಟು ನನ್ನ ಮಾತು ಮುಗಿಸ್ತೀನಿ. ಕೋವಿಡ್ ಕೇರ್ದಲ್ಲಿ ಯು ಹ್ಯಾವ್ ಟು ಸಪ್ಲೈ ಸೋ ಮಚ್ ಆಫ್ ಆಕ್ಸಿಜನ್ ಅಂದ್ರು. ವೇರ್ ವಾಸ್ ಆಕ್ಸಿಜನ್? Where was the generation of oxygen? How could anybody see that oxygen is distributed to that extent? ಹೋಯ್ತು ಈ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಆಗೋ ಆಕ್ಸಿಜನ್ ಬರಲಿಲ್ಲ ಅಂತ ಹಳ್ಳಿಯವ್ರು ನನ್ ಕೇಳೋ ಸ್ಥಿತಿ ಬಂತು. ಕೋರ್ಟ್ ಶುಡ್ ಹ್ಯಾವ್ ಬಿನ್, ಕೋರ್ಟ್ಗೆ ಬೇಕಾಗಿತ್ತು ಅದು ಆಕ್ಸಿಜನ್ಸ್ ಇದೆಯಾ ಇಲ್ವಾ, ಸ್ಟ್ರೆಚ್ ಆಕ್ಸಿಜನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಕ್ಕಾಗತ್ತ, ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಬಿಟ್ಟು ಇಷ್ಟು ಕಿಲೋಲೀಟರ್ಸ್ ಆಫ್ ಆಕ್ಸಿಜನ್ ಸಪ್ಲೈ ಮಾಡಿ ಅನ್ನೋಂತ ಆರ್ಡರ್ಗಳು ಮಾಡ್ಬಿಟ್ಟು ನಾಳೆ ಯಾರು ಅದನ್ನ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡ್ಲಿಲ್ಲ, ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ ಗತಿಯನ್ನು ಸರ್ಕಾರ ನಡೆಸೋದು. ಇಂಥವೆಲ್ಲ ನೋಡ್ಕೊಂಡು ಸ್ವಲ್ಪ ಜುಡಿಷಿಯರಿ ಸ್ವಲ್ಪ ಸೆನ್ಸಿಬಲ್ ಆಗ್ಬಿಟ್ರೆ ನಿಜವಾಗ್ಲೂ ದೇಶಕ್ಕೆ ಒಳ್ಳೇದಾಗುತ್ತೆ. ನಾವು ಅಷ್ಟೇ, ನಾವೇನ್ ಶಾಸಕರಿದ್ದೀವಿ, ಲಾಗಳ ಮಾಡ್ಬೇಕಾದ್ರೆ ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ದಿ ಇಂಟ್ರೆಸ್ಟ್ ಆಫ್ ಪಬ್ಲಿಕ್ ಅಟ್ ಲಾರ್ಜ್. ಯಾರನ್ನೋ ಇಬ್ಬರನ್ನ ನಾವು ಫಲಾನುಭವಿಗಳನ್ನ ದೃಷ್ಟಿಲಿ ಇಟ್ಕೊಂಡು ಲಾಗಳೆಲ್ಲ ಮಾಡಿ ಕೋರ್ಟ್ ಮುಂದೆ ನಿಂತ್ಕೊಳ್ಳೋ ಪರಿಸ್ಥಿತಿಗಳನ್ನ ನಾವು ಮಾಡಬಾರ್ದು. ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಜಸ್ಟಿಫೈಡ್ ಬಿಫೋರ್ ದಿ ಐಸ್ ಆಫ್ ಪಬ್ಲಿಕ್. ಹಾಗಾಗಿ ಕಾನೂನು ಮಾಡೋರು ಅದನ್ನ ಕಾರ್ಯಗತ ಮಾಡೋ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಮತ್ತೆ ಕೋರ್ಟ್ ಮೂರನ್ನು ಒಂದಕ್ಕೊಂದು ಪೂರಕವಾಗಿ ಕೆಲಸ ಮಾಡೋದು ಉತ್ತಮವಾದಂತ ನಿರೀಕ್ಷೆ ಸಂವಿಧಾನದ ಕರ್ತೃಗಳು ನಮ್ಮಿಂದ ಮಾಡಿದ್ದು. ಅದನ್ನ ಮತ್ತೆ ನಾವೆಲ್ಲಾದ್ರೂ ಸ್ಥಿತಿ ಮಾಡ್ಬೇಕು, ಅದನ್ನ ಸ್ಥಾಪಿತ ಮಾಡಿದ್ರೆ ನಿಜವಾಗ್ಲೂ ರಾಜ್ಯಕ್ಕೆ ರಾಷ್ಟ್ರಕ್ಕೆ ಒಳ್ಳೇದಾಗತ್ತೆ. ಇದೆಲ್ಲ ನಮ್ಗೆ ಕ್ವಶನ್ ಆಫ್ ಆಪರ್ಚುನಿಟಿ, ನಮ್ಗೆಲ್ಲೋ ಸಿಕ್ಕಿರೋ ಅವಕಾಶ. Maybe a minister, maybe a judge, maybe a deputy commissioner. Question of an opportunity. ನಮ್ಗೆ ಅವಕಾಶ ಸಿಕ್ಕಿದೆ, ಮತ್ತೊಬ್ರಿಗೆ ಸಿಕ್ಲಿಲ್ಲ. ಸಿಕ್ಕಿದ ಅವಕಾಶನ ನಾವು ಸರ್ವಶ್ರೇಷ್ಠ ಅಂತ ಬಳಸೋದ್ರ ಬದಲು ಇಟ್ ಈಸ್ ಫಾರ್ ದಿ ವೆಲ್ಫೇರ್ ಆಫ್ ದಿ ಸ್ಟೇಟ್ ಅಂತ ತಿಳ್ಕೊಂಡು ನನಗೆ ಒಂದು ಒಳ್ಳೆ ಸುಯೋಗ ಭಗವಂತ ಕೊಟ್ಟಿದ್ದಾನೆ, ಇದನ್ನ ನಾನು ಬೇರೆಯವ್ರ ಕೆಲ್ಸಕ್ಕೆ ಬಳಸ್ತೀನಿ, ಬೇರೆಯವರ ಸೇವೆಗೆ ಬಳಸ್ತೀವಿ ಅಂತ ತಿಳ್ಕೊಂಡು ಎಲ್ಲಾರು ಕೆಲಸ ಮಾಡೋಕೆ ಆರಂಭ ಮಾಡ್ಬಿಟ್ರೆ ನಿಜವಾಗ್ಲೂ ಒಳ್ಳೇದಾಗುತ್ತೆ. ಲೆಜಿಸ್ಲೇಚರ್ ಅಂಡ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಅಂಡ್ ಜುಡಿಷಿಯರಿ ಒಬ್ಬರನ್ನೊಂದು ಅವರವರ ವ್ಯಾಪ್ತಿನ, ಅವರವ್ರ ಇತಿಮಿತಿನ, ಅವರು ಎಲ್ಲಿ ಯಾವ ವಿಷಯಕ್ಕೆ ಭಾಗಿಯಾಗಬಾರ್ದು, ಯಾವ್ದಕ್ ಭಾಗಿಯಾಗಬಾರ್ದು ಅಂತ ಅರ್ಥ ಮಾಡ್ಕೊಂಡು ಕೆಲಸ ಮಾಡುವಂತ ಪರಿಸ್ಥಿತಿ ರಾಜ್ಯದಲ್ಲಿ ನಿರ್ಮಾಣ ಆಗ್ಲಿ. ಮತ್ತೆ ಇವ್ರ ಇತಿಮಿತಿಗಳು ಏನು ಅನ್ನೋ ಚರ್ಚೆ ನಿಮ್ಮ ಅಕಾಡೆಮಿಕ್ ಸೆಂಟರ್ಸ್ ಇಂದ ಆಗ್ಬೇಕು. ಲಾ ಯೂನಿವರ್ಸಿಟಿ, ಲಾ ಕಾಲೇಜ್, ಸ್ಟೂಡೆಂಟ್ಸ್ ಆಫ್ ಲಾ, ಇಲ್ಲಿಂದಾನೇ ಸ್ಟಾರ್ಟ್ ಆಗ್ಬೇಕು. ವಾಟ್ ಈಸ್ ದಿ power and jurisdiction of the legislature, what is the power and jurisdiction of the executive, then judiciary. ಇವೆಲ್ಲವನ್ನು ಈಗಿಂದಾನೆ ಮಕ್ಕಳ ಮಧ್ಯೆ ನಾವು ಚರ್ಚೆ ಮಾಡ್ತಾ ಬಂದ್ರೆ they will be able to understand who is wrong and what is wrong and where we are going in a wrong direction ಅಂತ. ಆ ದಿಕ್ಕಲ್ಲಿ ಈ ಚರ್ಚೆ ಆಗ್ಲಿ. ಉತ್ತಮವಾದ ಆಯ್ಕೆನ ನೀವು ಮಾಡಿದ್ರಿ. ಇವತ್ತು ಸಂವಿಧಾನ ಅರ್ಥ ಮಾಡ್ಕೊಂಡು ಒಂದಾದ್ರೆ ಸಂವಿಧಾನದ ಬೇರೆ ಬೇರೆ ಮುಖಗಳನ್ನು ನಾವು ಇವತ್ತು ಅವಲೋಕನ ಮಾಡಿ ಆ ದಿಕ್ಕಲ್ಲಿ ಕೆಲಸ ಕಾರ್ಯ ಮಾಡುವಂತ ಪರಿಸ್ಥಿತಿನ ಕಲ್ತ್ಕೋಬೇಕು. ಆ ಕಾಲ ಹತ್ರ ಆಗ್ಲಿ ಅಂತ ಆಶಿಸ್ಬಿಟ್ಟು ನಾನು ಕರೆದಿದ್ದಕ್ಕೆ ನಿಮ್ಗೆಲ್ಲ ನಾನು ಭಾರಿ ಆಭಾರಿ. ನಿಮ್ಗೆ ಗೊತ್ತು, ನನಗೆ 10:30 ಇವತ್ತು ಸೆಷನ್ ಇದೆ. ಐ ಆಮ್ ಎ ಪಾರ್ಲಿಮೆಂಟರಿ ಅಫೇರ್ಸ್ ಮಿನಿಸ್ಟರ್. ಐ ಆಮ್ ಸಪೋಸ್ ಟು ಬಿ ದೇರ್ ಟಿಲ್ ಸ್ಟಾರ್ಟ್ ಅಂಡ್ ಎಂಡ್. ಹಾಗಾಗಿ ಲೇಟ್ ಆಗಿ ಹೋಗಕ್ ಆಗೋದಿಲ್ಲ ಅಂತ ಹೇಳಿ ಸ್ವಲ್ಪ ಈ ಕಾರ್ಯಕ್ರಮನ ಪ್ರೀಪೋನ್ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದೀನಿ. ಇಫ್ ಏನಾದ್ರು ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಆಗಿದ್ರೆ ದಯಮಾಡಿ ನನಗೆ ಕ್ಷಮಿಸ್ಬೇಕು. ಬಟ್ ಐ ಆಮ್ ಥ್ಯಾಂಕ್ಫುಲ್ ಟು ಅಂತ ಹೇಳಿ ನನ್ನ ಮಾತು ಮುಗಿಸ್ತೀನಿ. ನಮಸ್ಕಾರ.
Thank you, sir.
Thank you very much, sir.
Thank you, sir, for your insightful words. I now call upon Professor C.S. Patil, Head of the Research Center in Democracy and Constitutional Government, to give us a brief introduction of this webinar.
No. Before that, can I take a minute?
Please, sir. Please, sir.
If you allow me, I will take exist.
Sir, please.
I'm sorry. ನಾನು ಇದು ಮಾಡಬಾರ್ದು, ಬಟ್ ಐ ಹ್ಯಾವ್ ಟು ರೀಚ್ ಅಸೆಂಬ್ಲಿ. ಓಕೆ, ನಮಸ್ಕಾರ ವಿಶ್ವ ಭಟ್ರೆ.
ನಮಸ್ಕಾರ.
Hello.
Good morning, everyone. The Karnataka State Law University has started Karnataka State Law University, Hubballi has started this research center in democracy and constitutional government with a very concrete objective. The primary objective of the research center is to provide knowledge base to the government through interdisciplinary research so that it can evolve good policies and programs to ensure good governance with the following specific purposes. The first purpose is to undertake detailed research in the areas of democratic politics and institutional building with a view to make them responsible and responsive to the will of the people, to direct research towards institutional reforms, to undertake studies relating to evaluation of government policies and programs, to study the effectiveness of the service delivery system, to evaluate role of governmental agencies involved in program implementation, to ascertain and evaluate the reasons the ineffective role of political other agencies in ensuring good governance, to create awareness and sensitivity towards constitutional values and principles, which is essential for good governance, to study the performance of various governmental and private agencies and instrumentalities, ensuring good governance and accountability. Through research, provide various alternatives to the government and policymakers to ensure highly civilized, people-friendly, and proactive government in the state of Karnataka. In this direction, keeping in these objectives in view, the Karnataka State Law University, in association with the Department of Law, Parliamentary Affairs, and Human Rights, Government of Karnataka, has organized this national webinar on evolving constitutional relations between the legislature, the executive, and the judiciary. The Constitution has created a sort of controlling system. The power centers are structured and everything should go in accordance with the values and principles that are ordained in the Constitution. The Constitution has catered to the nation over a period of 7 decades. In the words of Granville Austin, when considering the effectiveness of a Constitution, it must be understood that it has a real existence only in the way it is used. By looking into the working of the Constitution, one has to decipher whether the relationship between different wings of the government are maintained as contemplated in the Constitution, or whether they have crossed the subtle boundary of checks and balances and intruded into the domain of others so as to attract retaliation. We are going to be guided by the keynote address by our Honorable Professor Vijay Kumar, followed by discourses by various resource persons. I thank everyone for this opportunity of introducing to the objectives of the research center and also the theme of the seminar. Thank you very much.
Thank you, sir. I request Professor G.B. Patil, Registrar Karnataka State Law University, to introduce our beloved chief guest. Please, sir.
Good morning to all. Is it audible?
Yes.
Yeah. Good morning to all. Distinguished invitees, learned resource persons, esteemed members of the syndicate and academic council, delegates, ladies and gentlemen. It gives me immense pleasure and satisfaction to introduce Professor V. Vijay Kumar, Vice Chancellor, Honorable Vice Chancellor, Bhopal National Law University, Bhopal, for accepting our invitation to deliver keynote address in this national webinar on evolving constitutional relations between the legislature, the executive, and the judiciary. Sir has obtained his MA in political science in 1975, BL in 1978, MPhil in political science in 1984, MA in public administration in 1984, ML in International and Constitutional Law in 1986, PhD in Law in 1996 from the University of Madras. He has specialized in international and constitutional law. Sir has served as the Assistant Professor in Law in 1988, Associate Professor in 1992, Professor in 1997. He was Registrar of National Law School of India, University, Bangalore between 2005 and 2008. Chair Professor on Refugee Law between April 1997 and April 1918. Sir was a visiting scholar with New York University, Toronto, Canada during 2000 to 2003. Exchange visitor at National University of Singapore during 2004 to 2005. Visited USA in 1988 under International Visitors Program of the USIS on Living Constitution. He was a member and vice chairman of the Board of Governors of Asian Law Institute located in Singapore National University till 2009. He was the chairperson, undergraduate. He was the chairman of the Undergraduate Council, Postgraduate Council of National Law School of India, University, Bangalore. He was also a member of Karnataka State Higher Education Council between 2012 to 2016. Sir presently is serving as the Honorable Vice Chancellor of Bhopal National Law University. Sir is an erudite scholar and a humanist of exceptional mobility. Sir, we are overwhelmed by your gracious presence to deliver the keynote address. On behalf of the staff and students of Karnataka State Law University and the statutory officers, I once again welcome you, and it is over to you, sir. Thank you, sir.
Thank you. Thank you very much, Mr. Patil. Can you hear me now?
Yes, sir. Yes, sir.
Okay. Thank you.
Thank you, sir. It is now time to call upon the chief guest of today's function, that is Professor V. Vijay Kumar, Vice Chancellor, Bhopal National Law University, Bhopal, to address the gathering. Please, sir.
Thank you. Thank you, Lavanya. Dr. Ishwar Bhatt, the Vice Chancellor of KSLU, Sri Venkatesh Nayak, the Principal Secretary, Government of Karnataka, Department of Law and Parliamentary Affairs, Dr. C.S. Patil, Center Head, Dr. G.B. Patil, Dr. Ratna, my learned colleagues, participants, ladies and gentlemen. Good morning to everyone present here. I had the pleasure of listening to the minister saying something which I also wanted to say. It is these people who were responsible initially to concentrate the power in the hands of the cabinet. And now when the power is taken over by somebody, they are not able to stand the test. So it is in this regard, the theme of today's presentation, evolving constitutional relations between the legislature, the executive and the judiciary. We have to start with the question, is there any relationship at all? In two ways. Whether there are relationships identified in the Constitution, number one. Whether there are relationship outside these parameters specified in the Constitution. And I think the Law Minister's speech precisely falls under the second one. If there are certain practices which go against the written provisions, that needs to be checked or looked into. Before I say something about the relationship, I would like to start with this observation, which I do in almost all these constitutional law debates, that we have committed 3 Himalayan blunders. And I think that should be the basis of our understanding of this particular issue as well. The first Himalayan blunder is that we wrote the lengthiest constitution in the world. Right, 395 articles. Today there are about 12 schedules, and the Constitution has been frequently amended 105 times. The 42nd Amendment itself is lengthier than the American Constitution, so on and so forth. So we have drafted and adopted the lengthiest constitution in the world. Is it a mistake by itself? Is it a blunder by itself? I would rather say it is not a blunder by itself. But when you try to understand the second Himalayan blunder, then the first one becomes a blunder, right? So standing alone, writing a lengthier constitution is not a blunder, though Yugoslavia proves it right. They wrote a much lengthier constitution than that of India, and then now it is not there in the political map of the world. So there is no relationship between the length of the constitution or the breadth of the constitution and the excellence in which the government has to perform its obligations. In the light of this lengthy constitution, the second Himalayan blunder is we have not read it. I'll just ask the audience present here, how many of you have read this constitution from We the People of India to Article 395 and then all the 12 schedules at least once, right? Maybe you are not teaching constitutional law subject, that may be an excuse, but constitution is not for only the teachers, it is for every common man of this country, every citizen, right? Because it starts with the term We the People of India. And so therefore, how many of us have read the constitution? Is a question. Reading is the first one. Understanding is the second one, right? If we have not read it meaningfully, I think understanding is very, very difficult for us. We understand something rightly or wrongly through what the court says as right, authoritatively, right? We don't even care to look into. I'm also saying this because even the Chief Justice of India is on record, who said that no one can understand, no one can remember every aspect of it. So ignorance of law, I think even it applies to the Chief Justice of India, right? If it has to come from him, then an ordinary common man, you realize how it can happen. I can prove the second point very precisely because if you have taken earlier statistics of more than 60% as illiterate, and today literacy rate has increased enormously, thanks to the online mode, offline mode, all types of degrees and certificates issued by the universities and institutions. If at all you call that as education, fine, it's all right. How many of them have come across the constitution to understand this is once again an issue. Let me come to the third point, the second one itself. Assuming from ordinary law student of all law colleges put together, all the lawyers, all the law teachers, all the judges from subordinate court to the Supreme Court, all of us put together in the legal field, legal domain, I don't think we constitute even 1% of the total population. If it is true, and even among the 1%, we have not read the constitution properly, and I think that is the place where the practices overtake the written provisions of the constitution. And therefore, ultimately what is required is a seal of approval from the court, and once the seal is given, then I think everyone behaves the way that they want to behave. So this is the second one. Let me just put it once again. We have written the lengthiest constitution. That is the first Himalayan blunder. Second blunder is after writing down the lengthiest constitution, we have not read it. And the third Himalayan blunder is whenever you try to challenge the written provision of the constitution somewhere in the court, automatically we go to the English constitution, right? See the agony. When we have to interpret the written provisions of the Indian constitution, we go to the English constitution and take the practices, right? Saying and calling them as conventions under the constitution. Now that becomes what you call it as the third Himalayan blunder. The written words of the constitution are not respected, regarded, and then looked into. I would like to just deviate a little. With these three blunders coming into picture, I would like to just cite one judgment of the Privy Council, right? This is in Attorney General for Ontario versus Attorney General for Canada. This was decided by the court in 1912, right? 1912, it is now almost 110 years old. because the Canadian Constitution is also one among the Commonwealth constitutions, written constitutions. Now, this is what the judges had to say in the Privy Council. What is it? Please carefully listen to me. This I quote: in the interpretation of the completely self-governing constitution founded upon a written organic instrument, such as the British North America Act, that is the Constitution of Canada, if the text is explicit, this is the most important part of it. If the text is explicit, the text is conclusive. If the text is explicit, the text is conclusive, alike in what it directs and what it forbids. What a beautiful statement given by the Privy Council way back in 1912, right? If the text is explicit, the text is conclusive, alike in what it directs and what it forbids. These things, I hope we have not even respected, forget about following it, right? I'll just give you one or two examples in where we have gone wrong. When the House was dissolved, Lok Sabha was dissolved, Indira Gandhi continued to be the Prime Minister. Somebody went to the High Court of Madras, challenged her continuance as the Prime Minister, because he specifically looked into the case that I am referring to is UNR Rao versus Indira Gandhi. Now, see, he was a practicing lawyer, he is no more. He was a practicing lawyer in the Madras High Court. He challenged her continuance as the Prime Minister. He cited Article 75, Clause 3, right? The Council of Ministers shall be collectively responsible to the House of the People. When the House of the People is dissolved, to whom is the Prime Minister responsible? What a wonderful question that he asked, right? But again, the High Court, for whatever is the reason, because I don't have the privilege of more time to discuss all these nuances in detail, the Supreme Court, the High Court of Madras, in its own interest, enlightened self-interest, I would rather say briefly, accepted that we follow the British parliamentary system. And in England, even after the dissolution, the Prime Minister continues till the next House comes into picture. Neither the High Court has understood the British parliamentary practices properly, right? And nor it recognized the written phrase in Article 75, Clause 3. And therefore, they use the British constitutional conventions to override, it is a sort of gimmick, right, to override the written provisions of the Constitution. And the appeal went on to the Supreme Court, and the Supreme Court has simply endorsed the views of the Madras High Court and upheld that there is nothing wrong in the Prime Minister continuing as the outgoing Prime Minister, irrespective of that accountability, is something which I don't think we have understood the ABC of the Constitution in the proper perspective. Now, coming to the relationship among the three branches of the government, I think the conflict began in the very first year itself, and then slowly but steadily the conflict between the executive, right? Let me very briefly, before getting into the dimensions of this, the problem in this country is we have not understood what is meant by executive power. Article 53 very clearly says the executive power of the Union shall be vested. I want everyone to carefully listen to this. The executive power of the Union shall be, it is not maybe, shall be vested, right? The term vested is used only to denote the powers given to the President and the Governor in two specific constitutions. It is not in favor of the Legislature or the Judiciary. They have not used the power. So what is vested in the President, right? I once again repeat, the executive power of the Union shall be vested in the President and shall be exercised by him either directly or through officers subordinate to him in accordance with this Constitution. That is what we have to understand, right? And then what is vested, right? Now I have given you two extreme examples. What the Privy Council said in Ontario, Attorney General Ontario versus Attorney General of Canada, right? 1912. If the text is explicit, it is conclusive. That is what they said. And look at the other extreme, the Supreme Court and the High Court of Madras, both of them saying that there is nothing wrong in the Prime Minister continuing, and there need not be any sort of collective responsibility because it cannot be there, right? So somewhere, what is vested in the President, the executive power, I think we have divested the executive power right from day number one by saying that the Constitution of India is nothing but parliamentary form of government. I can only assure you, I would like to recall what Professor Devidas used to tell in the classes, right? The moment we have adopted the Fundamental Rights Chapter, Part 3 into the Constitution, the parliamentary form of government goes out by the nearest window. These were his words, right? So the Parliament cannot make any law taking away or abridging the rights granted under this part, that is Part 3 of the Constitution. And there is no such prohibition in UK. The Parliament still today, if it wants to do anything, it can do it. There is no limit. And the Parliament in India cannot say that it is all powerful, even higher than the Constitution itself. I think that is a folly in which we are living. Right. Having said this, who is this executive and executive power? Let me tell you, it is my understanding. I would like to be proved that I am wrong. The executive power, the notion has not been defined properly and effectively. Till I came across a book written by a lecture delivered by Justice P.B. Mukherjee, The Critical Study of the Indian Constitution. Every student of constitutional law, for doing some research, must read this book at least once, right? And I am putting that in the soft copy because the books are not available. The book published by the Bombay University, they are not available. I myself purchased more than 30 copies because the cost of the book was 30 rupees. And I gave it to all the judges and the other colleagues whoever wanted to read. Particularly for C.S. Patil as head of the department on research, I think you should at least read and make everyone read this book once to understand on what areas we can do research. There are many things which I would like to flag, but I think the best thing is to read a critical book. Why I am saying this as a critical book is, any student of constitutional law will say Sirvai was the classic book, right? Today, I see that many teachers also don't take the name of Sirvai. And all other books, they only repeat whatever has already been said, right? There is no independent thinking. There is no critical evaluation of these provisions. And as such, the students mug up and pass the examination, right? And that is the end of it. So the critical thinking of the provisions of the Constitution, which is very, very essential in this country, with 99% of the population not even students of law, right? So it is very crucial for us to propound a new theme, to understand, to make people understand that whoever commits the mistake, be it legislature, be it executive, or be it judiciary, we need to stand up and say that what you have done is wrong. And then only the Constitution can, sustain itself with all the changes that are taking place in the years to come. The first few years of the commencement, I think we had a conflict, the relationship, if at all I have to mention, and the Hindu Code Bill. If we see from 1954 to 1956, President very clearly said that he is not going to sign the bill. And Nehru had to, dismantle that into 2-3 different pieces of legislation, get it approved at a later point of time. And the president was left with no choice because he consulted the Attorney General. The Attorney General also said, no, we have British parliamentary system working. We have no other go but to sign it. So he signed it, right? And even the Congress party was not willing to field him for the second time as a presidential candidate. And against the wishes of the Congress party, he contested won the election. And I think the problem continued thereafter as well, right? I always jovially tell the Indian Law Institute, which stands in front of the Supreme Court, the foundation stone was laid by President Rajendra Prasad. And while laying down the the foundation stone, he asked the lawyers, law teachers, and researchers to find out the status of the president, the powers of the president, do research and then come out. And then in the evening, the Prime Minister spoke on the same occasion. He said, if you do the research, this building will stand only with the foundation stone, nothing will come up, right? And then they had to balance their own, and then ultimately you have the building. But I think we have lost the research as to what is the constitutional status of the president, right? Dr. K. Munshi, one among the members of the Constituent Assembly, right, who also believed in the parliamentary system during the deliberations, right? In 1964, he came out with an independent, a separate book, 53-page book, right? President under the Indian Constitution. This book is published by Bharatiya Vidya Bhavan. I think the cost of the book is only 50 rupees. I think ASLU can, I have purchased about hundreds of copies to be given to the students also, right? If it is not available, please let me know. I'll give you the soft copy, which I have done and kept it for my record. It is also, see, within 13 years, what compelled this stalwart who was in favor of parliamentary form of government to say the president is not a dummy anymore. He has to play his meaningful role, right? By the time I think things have gone wrong, then the conflict, between the legislature and the judiciary took over, right? I'm talking about Golaknath versus state of Punjab, right? In Golaknath's case, when the Supreme Court said the parliament has no power to make any law to take away or abridge the fundamental rights, right? Then I think the tussle was obvious. And I want all of you to listen to me a little carefully. Now, this judgment was delivered in 1965, right? Now, then the Congress party, what happened, I hope you know, I don't want to get into the history. Nehru died, Lal Bahadur Shastri came, he went to Tashkent, he also died. And then there were, divisions within the Congress party, the elections were held. And then in 1967, when Indira Gandhi took over as a Prime Minister, the first thing that she wanted to teach a lesson was to the judiciary, right? She wanted a review of this Golaknath's case. And before the review, she also wanted to remove and teach a lesson to the then Chief Justice of India, Justice Subba Rao, right? It was very obvious because it was in 1968, early 1968, a very smart bill was introduced without any proper consultation. It is called as Judges Inquiry Act, 1968. And within 1 year, Judges Inquiry rules were also adopted. So the things were very clear, made known to the Chief Justice. If he had to continue in the office as the Chief Justice, he will be the first person in the history of India to be removed from office using this Judges Inquiry Act and the rules made by the Parliament. Look at this, the Parliament slept over for almost 18 years. It never passed, it never thought of even making a law, right? But all of a sudden, when the judiciary gave a judgment, which is in tune with the Constitution, to remove the Chief Justice, the bill has been adopted, introduced, passed, signed by the President, right? And then somehow, this gentleman, the then Chief Justice, realized the issue. He spoke to, the opposition leaders, became a leader, the opposition, nominee to contest the presidential election. He politely resigned from the office of the Chief Justice of India to contest the election. He knew that he is going to lose and he lost the election, but he had a dignified exit rather than the removal, because with Mrs. Gandhi at the helm, I don't think a 2/3 majority, unanimous opinion can also be taken by the party. That was the strength of that party at that particular point of time. They had almost, there was no opposition to Congress party, right? Now, this was very beautifully identified by Ira Selian. I want you to please carefully listen to what Viras Alian, the member of the DMK, noted sometimes ago, right? He says, sometimes I think as a member of the parliament, this is what he has to say, not as an individual, but as a member of the parliament. Sometimes I think some of us even feel, why have a parliament? Why have a parliament? Why should 500 members come here to take a decision which one person can take? Which one person can take? That was what Hitler thought. Right? Now he cites this, and I think coming from a member of parliament, I think we need to introspect and find out whether there is an iota of truth in this. Right? So when Justice Subbarao resigned and left, right, to avoid what you call it as a process of removal against him, the conflict somehow subsided, but still Indira Gandhi was not very happy. In 1973, I hope all of you know, when the Chief Justice retired, she had to appoint A.N. Ray as the Chief Justice of India, superseding 3 senior-most judges. She wanted to very clearly say, because the judges who superseded were all in the party to the majority in Golaknath's judgment, right? So she wanted to choose a person who was not a party to the judgment, and a 4th person in seniority was made the Chief Justice of India, and the 3 senior judges resigned and left, and one more left was in 1975. Khanna was superseded by Beg, and these 2 supersessions very clearly toned down what you call it as the autonomy and the independence of the judiciary to a great extent, right? Till 1980, this continued, and that is why I tell my students that whatever judgments you read between 1971 to 1980, you have to see the political scenario, the environment in this country. Otherwise, you will not understand. There was emergency from 1971 to 1975. Second emergency imposed from 1975 to 1977. So almost 8 years we have spent in emergency, and many of these judgments need to be looked at it, right? Maybe after my retirement, I would like to do some work, the emergency judgments, right? Review that and find out to what extent the judiciary played a card or a role in strengthening the office of the Prime Minister, which Viras Alian says that it is only the Hitler who said this, right? If one person can take a decision, and that is what is happening today. Whether it is DMK or ADMK, is there a second voice? Whether it is BJP or Congress, is there a second voice, right? So these are the issues that we need to look at it. And then till 1980, through Maneka Gandhi versus Union of India, the Supreme Court reinvented its own way of asserting that judicial review is a basic structure, right? And therefore, slowly but steadily, it gained its own status from 1980 onwards. And when one authority becomes more powerful and the other 2 authorities sleep, right? Then I think the one authority which is becoming prominent can become arrogant and can function with disrespect to all the written provisions of the Constitution. And that is what has happened to the court also. In 1991, this is once again bringing the relationship between the legislature and the judiciary. If the Supreme Court, if the Lok Sabha and the Rajya Sabha had worked together in removing Justice Ramasamy, right, for what you call it as the practices that he was involved very clearly, then I think things would have been little different. There would have been some element of, proportionality in the powers exercised by the court, but that did not happen. And then the judges got all the courageous, right, that is required. When Soumitra Sen also got escaped by submitting a resignation, right, and Justice Dinakaran also escaped even without a procedure being initiated, right? So they thought this is the best way. And then they said in 1993-94, the first Skora judgment, consultation means concurrence, right? And that is the place where the Supreme Court asserted its superiority over the political bosses, the Prime Minister, and also the executive, the President of India, who is supposed to nominate them. I'll come to that situation a little later, right, if time permits. Otherwise, I think I'll keep on blabbering for some time, making people think, right? So in Scora judgment, they said consultation means nothing but concurrence. I don't know which dictionary they followed, right? And I have written a 9-page note and sent to the Supreme Court that the Supreme Court has committed a blunder, which is also part of my PhD thesis, right? And in that judgment, the Supreme Court spent almost 10 pages, printed pages, in describing what is meant by constitutional convention. But they did not follow those conventions at all, right? So therefore, we look at the judiciary becoming all-powerful, entertainment of public interest litigation, and this is what the law minister was also mentioning, right? I fully appreciate the example that he has taken. I had also written down the same example, right, to inform you. The Supreme Court will not decide on policy issues. The Supreme Court once in a while says, no, we don't want to introduce, poke our nose in the policy matters. But what it does is, day in and day out, using the contempt power, telling what the executive should be doing, right? He gave this supply of oxygen during COVID pandemic, right? Where was it? Do they understand what it is, right? I really do not know whether the judges had any knowledge about how the oxygen is produced, where it is produced, where it is bottled, and how it is being transported. And simply saying that Delhi should get 100 tons of oxygen from nowhere, it is not from thin air you can collect and give it to the hospitals, right? And you cannot. The executive is trying to do the work, the bureaucracy is trying to do the work, health workers are trying to do the work, and the Supreme Court, in my opinion, became a backseat driver in telling them what they should be doing. And again, the politicians prevailed. They said, if due to COVID somebody dies, we will give some compensation, right? And when the compensation is not given, the Supreme Court once again says, no, it must be given to all people. You don't verify this. No, don't you think these are all policy matters, right? So the Supreme Court is slowly but steadily becoming, and ultimately, in my opinion, the Supreme Court's certificate in MP Lad scheme, right? The judgment delivered by the then Chief Justice, headed by a bench consisting of 3 judges, Justice Sadasivam, right? And they were performing purely executive function as members of parliament. When they allocate that 5 crores to the development of the constituency, they were using the public fund to say that this bus shelter is given by so-and-so MP or so-and-so MLA, right? And the Supreme Court gave the final seal of approval saying that it is valid. I think it can go to highs and lows just like this. And it is because that we don't write critical articles saying where they have gone wrong. And therefore, I come back to the same point again. We are not able to understand what is meant by executive power, right? And I think if you hold a symposium even for 30 days, it will be difficult, because Justice P.P. Mukherjee in his book says it is very, very difficult to define what executive power is. It is all encompassing from the beginning till the end. It is all encompassing, and therefore it cannot be trusted and given to the elected representatives. And that is why the president has to play some role. That is not happening. Let me also make a mention about a couple of things, right? Are we talking about tyranny of numbers in a democracy like ours, right? Tyranny of numbers, because you elect a body, the legislature. If there is no majority, then coalition, then floor crossing. I think these are all things which British Parliament has never experienced, right? We say that we are following British parliamentary system, but I don't think we seldom follow the good practices of the British parliamentary system. The other conflict which I would like to flag is between the judiciary and the legislature. The first case decided much earlier in 60s, mid-60s, if I remember right, 64, Indri Keshav Singh's case, right? Where freedom of speech and expression was involved in that, which the Supreme Court ultimately said it is. And the judges who protected the who issued the writ of habeas corpus, the lawyer who represented the, petitioner, all of them were also sentenced to 30 days imprisonment by the House, by the Speaker. And all these things became a reference in the Kerala, in the UP Legislature, Indri Keshav Singh, whatever name you call, right? So therefore, you can see that once the fundamental rights is to be respected, then I think the power exercised by the lawyer as representing the petitioner, the judges discharging their function as the judicial function, and all of them can be bulldozed by one single person, the speaker, which was ultimately, brought down to some extent, diluted by the reference made by the president. So like this, there are number of references I can keep on speaking, but my opinion is today, the power of the executive is taken over from the president and is now vested with the prime minister, and for which the Supreme Court itself is responsible. Please refer to this judicial decision, Shamsher Singh versus State of Punjab, 1974, Supreme Court. And I think you should read the judgment, right? I come across many phrases which are not part of the Constitution at all, right? But it is a 7-judge bench judgment which continues to remain as the binding law, and until and otherwise we just change this, modify this. A little bit of variation was found by Justice Hegde in Madhya Pradesh State Special Police Establishment versus State of Madhya Pradesh 2005 Supreme Court, which is also a Constitution bench judgment, where the 2 cabinet ministers who are involved in land scam, right? They have made money. Everything was done by the Lokayukta here in Madhya Pradesh. They said these 2 ministers are responsible squarely, right? Apart from others. And they were still serving as members of the cabinet. The governor wrote to the chief minister, they must be prosecuted. Now the Lokayukta has given the report. They have asked for sanction. Should I give the sanction? Right? Quick came the reply, no, you are bound by the advice of the Council of Ministers. You cannot allow them to, give the sanction. You cannot give the sanction. But the governor took courage and granted the sanction, right? And that is how the case went to the Madhya Pradesh High Court, from Madhya Pradesh High Court, which said S.S. Shamsher Singh is a binding precedent. And then the matter went to the Supreme Court, and they said, in such cases, the president, the governor, whosoever are exercising the executive power, and whatever they have done is constitutionally valid, right? So therefore, we need to look at these options and see. Otherwise, which the law minister also mentioned, the Lord Acton statement, power corrupts and power corrupts absolutely. If you think all these 3 branches can work together for the betterment of the people, I think they have to work together, not fight with each other, not saying that, something which is not palatable by the other 2 branches, right? And if that happens, I think no democracy can survive. Only what Aristotle said, mobocracy will take over, and that will become a perverted form of government, not the constitutional governments, right? With these few words, thank you very much for inviting me to share some of my thoughts. I'm sorry I've been in a hurried manner summing up many things. I have lot many things. Maybe at some other seminar, we'll discuss these things in detail. Thank you very much for your patient hearing.
Thank you, sir.
Thank you, sir, for sharing with us your immense knowledge on the subject. I now request Professor P. Ishwar Bhatt, Vice Chancellor, Karnataka State Law University, Hubballi, to deliver presidential address. Please, sir.
Yes. Honorable Vice Chancellor Professor Vijay Kumar, Sri J.C. Madhuswamy, Honorable Law Minister in absentia, Professor C.S. Patil, Professor G.V. Patil, Professor Ratna Brahmagowda, Professor Sri Venkatesh Naik, all the faculty members and students, invitees, resource persons. It gives me great pleasure in participating in this inaugural session of a 2 days national webinar on evolving relations between legislature, executive, and judiciary. When I had a discussion with Professor C.S. Patil about the topic that can be taken for a webinar, we are in agreement in the importance of this particular topic, because the relations among these three important institutions under the Constitution are ever changing. They are evolving. They are not a constant. They are evolving. For example, introduction of a Human Rights Act in England and a Constitutional Reform Act of 2005 in England brought a big change in the relation between executive and the judiciary, or between a legislature and the judiciary. Until 1998, English judiciary has no power of review on the legislations enacted by the parliament. But after 1998, it has a jurisdiction. It has a power to declare any of the laws enacted by the parliament as inconsistent with the European Convention on Human Rights. And once there is that declaration, then it is the responsibility of the parliament to amend the law and to upgrade the law in order to conform to the requirement under the international legal principles. In the same way, about the constitution of the Supreme Court of England, that also underwent a big change. What shall be the relation between Lord Chancellor and say the legislature, Lord Chancellor and the judiciary, and how the judges of Supreme Court have to act when they perform a legislative function, or when whether they can participate in legislative functions. About all those things, new principles have been evolved. This evolution is something reflecting the dynamic development of the Constitution. Ever since the idea of relationship among these three organs of government had been contemplated or discussed or analyzed by the great thinkers from the times of Aristotle to the present times. There is a emphasis on the purpose for which these relations are to be put into service. Evolving relations among these three bodies. For what purpose? When a text of the Constitution is explicit, then it becomes conclusive. That's what Canadian Supreme Court, when the Privy Council said, Professor Vijay Kumar made that point very clear, that textual interpretation of the Constitution becomes imperative in many circumstances. Yes, silence of the Constitution is also providing an opportunity for the court to interpret. But when the text of the Constitution or silence is also inadequate, then relations among various institutions within the Constitution are to be used as resources of meaning. Relations become resources of meaning. That's why in the evolution of relations, we come across some possibility of finding solutions to various questions in the development of the Constitution. Why Constitution is to be interpreted in one way or the other. About that, the relations play quite a significant role. Let me tell you that Montesquieu's idea of a separation of powers, which was partly based upon the Aristotelian view about a good governance, arrangement of self-discipline and self-limitations, and also the French experience that it is for the purpose of controlling the abuse of power, that the relations among various organs of a government shall be put into action. These ideas which influenced Montesquieu made him to come out with a great theory, the theory of a separation of powers. Yes, he said that when the legislative and executive powers are united in the same person or in the same body of magistrates, there can be no liberty, because apprehension may arise lest the same monarch or senate should enact tyrannical laws to execute them in a tyrannical way. So protection against tyranny and protection of liberty, these were the purposes with which the relations among these three organs of government are to be put into action or put into work. We find that ancient Indian thinking about control over the power of the king was referring to the role of sabhas, samitis, or the courts, so that the king, however omnipotent, however politically powerful or powerful in a military means he might be, still he shall act according to dharma, and he shall act according to the judgment of the court. All these principles contemplated that there were mutual checks and balances. There is a formal aspect of separation of powers, which simply refers to the features of various facets of power. Just on the basis of characteristic of power, it is possible to say that a particular power ought to be vested only with this specific body and not by the other body. And jurisdictional encroachment, violation, will be resulting in invalidity of the actions. That was the aspect of a formal facet of separation of powers. Functional aspect of this theory of separation of powers is quite important, because politically it has a lot of advantages. It provides for checks and balances. Our honorable law minister has said about the way in which the abuses of power occur because of not confining the jurisdiction or not confining the actions of the concerned organ of government to the jurisdiction that is vested to it, or the jurisdiction conferred upon it. See, this interjurisdictional care with which all these bodies have to exercise power, or the interbranch relations with which ought to be taken into account in the course of exercise of power, all these factors become quite important. We have seen how the judicial usurpation of powers of the executive or powers of the administration has some disastrous effect. Just one day prior to the examination, the court may issue a stay order stalling the starting of examination, or a court may go to the extent of formulating a timetable for the university, thinking that the university is not competent to formulate its own say timetable or such a thing. See, this kind of usurpation of the power belonging to another organ of administration is something which causes a disturbance in the power relations. We have to take into consideration all those aspects. We have to be quite clear about the way in which the structure of power is properly understood by holders of those powers. And the structure of power provides some guideline about the way in which the power relations are to be interpreted or put into action. Thus, we come to the role of structuralism in interpreting the relations among these three important organs of government: legislature, executive, and judiciary. Between these three organs, how the power relations are to be properly understood and how it is to be put into action. What is structuralism and what is its role? Whenever we understand the Constitution as a systematic organ of the polity, or a structure which speaks about the organization of power, we should understand about various components out of which that polity is made up. The structure of the state should be taken into consideration when a structure of the Constitution is something reflecting the existence of various organs of government, and those organs of government are vested with the specific types of powers, responsibilities, or functions. Then because of a specialization in those areas, or because of a justification arrangement of a democratic sanction, etc., they have the unique opportunity of exercising that power. Legislature has that power of making law, for the reason that it is an authentic body of the democracy consisting of popular representatives, and the public opinion shall be the basis for exercise of this legislative power. And when a law is enacted for a promotion of a public good and general utility, it is the experience, wisdom, and representative ability, competence on the part of the legislators, which can provide certain legitimate justification for making of law. When that lawmaking power is conferred upon, or when it is delegated to the executive because of enormous functions in the hands of the legislature, or because of the technical nature of the subject, or because of the social needs or economic circumstances, then the executive, which is vested with the legislative power, shall exercise that delegated power of rule making in the same way as that of the legislature. At least the democratic character should be there, deliberations should be there, and promulgation shall be there. Generality of action shall be there, and the executive shall comply with all those requirements which are to be followed by the legislature. Thus, functionally, although that power might be vested upon the executive has to act as a representative of the legislature. Thus, we have to understand what is the structure of legislative power. There's it is divided between the sovereign power or the main power, core power of making laws within the constitution. That is vested with the legislature. And not so essential power, which is not amounting to essential legislative policy making power, but which is a subordinate, or which is a supplementary, or which is providing for a elaboration or filling the gap. That power will be exercised by the executive. So the power which is delegated to that representative body is a limited power, and that power shall conform to the power that is already exercised by the parental body, and that shall be in conformity with the constitution. Thus, when we speak about a structure of a legislative power, we have to take into consideration these factors, and structural interpretation that was applied first in the Delhi Laws Act case, that points out how the legislature shall perform essential legislative function, and the executive may be vested with the rule-making power subject to certain limitations. It cannot make modifications of the parental legislation in such a way that it alters its essential legislative policy. And relating to, say, inclusion of any entries into the schedule, or imposition of a tax, or taking any other appropriate action of, say, imposing a penalty or collection of a tax, etc. The executive shall act in accordance with the wishes that are expressed in the legislation itself. Thus, these structural limitations are operating, and evolution of the relations between legislature, executive, and the judiciary is to be understood in the light of changes that are taking place in the area of delegated legislation from the times of Indra Delhi laws to the present day. There is a much change, and of course, relations have undergone some change, but still the essential policy laid down in a Delhi laws case is not yet altered. But judiciary pays that respectful regards to the observations made in a Delhi laws case, and proceeds to analyze. And according to HM Roy, it is a waste of judicial time to engage in any discussion about the delegability of legislative power. To what extent delegation of legislative power is appropriate, whether in any particular case there is an excessive delegation or not. These are issues of useless debate according to HMCY. But still, those structural limitations continue, because in some circumstances, these limitations may come to the help of judiciary, and judiciary will provide certain remedies. Of course, about judicial intervention in case of public interest litigations, there also we find that usually about the policy matters, the judiciary does not intervene. The High Court of Karnataka recently, and Supreme Court in several cases has said that when universities take administrative policy or academic policy decisions, the judiciary shall intervene in a least manner. In other words, it shall not intervene. That shall be its the general policy. But when there is a need to intervene in order to safeguard the interest of students, faculties, or say interest of professional legal education, then intervention may be appropriate, but there also consultation, discussion, and acting in accordance with the policy arising under Part 3 and Part 4 of the Constitution. All this shall be taken into account, and it should be outcome of that consultative process and not a imposition as such. See, in various areas we come across impact of structuralism on the relations between a legislature, executive, and judiciary. About the very existence or about the very prevalence of this theory of separation of powers in the Indian Constitution, the courts have used a structural method of interpretation. Article 50 of the Constitution says that a state shall take measures for a bifurcation of judiciary from the executive. It is only one aspect of theory of separation of powers. There are other dimensions of relations among these three organs. Article 50 is confining only to one aspect. Between a legislature, between a executive and judiciary, there shall be bifurcation. How exactly that is to be done? Of course, when the issue is relating to, say, grant of a pay scale, or a grant of a pension, or economic privileges, or some other advantages by the state, then it is a matter of executive action, and a judiciary cannot intervene, and a judiciary ought not to lay down for the policies about either a pay scale appointment or say matters relating to pension, etc. We come across a number of judgments on that. Again, structural interpretation. But about structural interpretation adopted in a Ram Javaya Kapoor case. See, there is no formal recognition of a theory of separation of powers in the Indian Constitution. But functionally, we come across specific relations between a legislature, executive, and judiciary. Autonomous character of the executive is implicit, because executive power of the union or state government is not dependent upon legislative sanction or legislative backing, unless there is a possibility of encroaching the rights of people. That's a very categorical principle. That's even in the absence of legislation, executive power can be exercised, because executive power is independent, and it stands on a separate footing, and it does not depend upon the legislative action. Further, the power is coextensive with that of legislative power. See, it is the understanding of the structure of executive power that made the judiciary to come out of that proposition that the executive is autonomous, independent of the executive, independent of the legislature, and it is only when some legal right is going to be violated, or when the existing law is going to be altered, then of course the executive ought to get the prior approval or prior authorization by the legislature. Otherwise, it shall not intervene. Again, structural interpretation. Then we come across a structural interpretation relating to the very exercise of power of a legislature to undo the judgments rendered by the courts. See, that is a practice adopted in a number of cases. number of circumstances. For example, in the Kaveri case, that attempt was done when there was a tribunal judgment, interim order by tribunal. Karnataka resorted to a legislation to stall the implementation of a tribunal's award. The Supreme Court nullified the legislation, stating that it amounts to legislative judgment, violation of a theory of separation of powers, and a legislature cannot undo a judgment, or it cannot obstruct the application of a judgment or adjudicative power. That was actually a statement made in an earlier case in Indira Nehru Gandhi versus Rajnarayan. Of course, there the court ruled that the changes are made through Article 329A of the Constitution, which deprives the power of a judicial review, or which makes such a substantial change in the adjudicative process relating to election, is a violation of a theory of a separation of powers. But in the same judgment, it was viewed that if there is a law which validates a particular legal proposition and rectifies some of the errors of the earlier law and goes for a different legislative policy, such kind of a law may be appropriate. There is that kind of observation. But what are the limitations on this power of validation? Again, we come across a structural interpretation. In a Bhagavat case and various other cases, we come across some judgments where the earlier judgments rendered by the high courts or even apex court were substantially altered because of the new legal proposition evolved by the legislature. There's by removing the very base of that judgment or altering the concerned proposition, the court arrived at a different conclusion. I'm not elaborating this particular issue, but it is a well settled proposition in a number of cases. Yes. The view expressed in one of the case is as follows. There's the latest position, Karnataka Pawnbrokers Association case. There, the court says that the legislature has the power to enact validating the laws, including the power to amend the laws with the retrospective effect. However, this can be done to remove causes of invalidity. When such a law is passed, the legislature basically corrects the errors which have been pointed out in a judicial pronouncement. Resultantly, it amends the law by removing the mistakes committed in the earlier legislation, the effect of which is to remove the basis and foundation of the judgment. If this is done, the same does not amount to statutory overruling. Again, it is a kind of a structural interpretation. Of course, we come across the famous Mulla Periyar case, where the legislation enacted by Kerala legislature was nullified by the Supreme Court because the legislation openly and directly went against the tenor of the Supreme Court judgment, stating that the Tamil Nadu government is permitted to raise the level of Mulla Periyar Dam, and the issue relating to infirmity of the dam cannot be regarded as appropriate, and the court in that case, nullified the legislation. Again, the court was using structural interpretation, because whether a legislature can exercise its legislative power in such a way that a judgment of the court can be stalled, or its implementation can be simply obstructed. The answer is no, because the structure of power on the part of the legislature is standing on equal footing with that of other organs of government, and conformity with the constitution is one of the fundamental principles. Of course, how a constitution is to be interpreted, or how a law is to be interpreted. About this, the final say is from the side of the Supreme Court. The Supreme Court decision is final, and there we come across the judgment which reminds about the limitations on the power of the legislature to undo the judgments rendered by the judiciary, whether a high court or a Supreme Court. Then structure of this power relations among these three organs of government becomes a basic structure itself. See, in Keshavananda case, we come across a majority judgment where all the judges were referring to the demarcation of powers between these three organs of government, or separation of powers, or the way in which checks and balances are to be ensured in this democratic system. One important idea emerging from this basic structure discourse in Keshavananda, or in I.R. Coelho, or Indira Nehru Gandhi, is that relating to theory of separation of powers, the court was pointing out that it is a principle which has a political advantage of providing mutual checks and balances, because through such a mutual checks and balances, ultimately the objectives underlying the constitution are to be promoted. What are the objectives, or what are the purposes underlying the constitution? Protection of liberty is the purpose. Then safeguarding the polity against tyranny is the purpose. See, Montesquieu's idea of separation of powers is based upon these two important objectives. Structuralists usually make use of purposive interpretation, whether it's in a Maneka Gandhi case, or say cases relating to division of powers between a central government and state government, in Pitt and Sultan's cases and various other cases, or in cases relating to say fundamental rights. There are also purposive nature of various clauses as well as relations are given a lot of emphasis. See, from the angle of purpose, the theory of separation of powers has undergone change, because earlier Montesquieu emphasized that liberty and protection against tyranny, these are the purposes underlying the theory of separation of powers. But today, the Supreme Court in a Mulla Periyar case and other cases points out that rule of law is the purpose underlying the theory of separation of powers. And in a Keshavananda case and other cases, yes, Indira Nehru Gandhi case, the court says that it is a constitutionalism which is intertwined with the theory of separation of powers. So the purpose of separation of powers is sometimes, yes, it is mainly linked with the purpose of constitutionalism itself. That's there is expanding horizons of relations among these three organs. See, in England, introduction of Human Rights Act and bringing of this constitutional reform, etc., provided a new dimension to this relation among these three organs of government. See, during Montesquieu's time, or even in 19th century, or even in 20th century, the relation between legislature, executive, and judiciary in England was just formally confined to the aspects of power relations in a cabinet vis-a-vis legislature. That is all. But introduction of this new element, there's a protection of human rights as a responsibility on the part of judiciary, as a specific power on the part of judiciary, changed the whole scenario. Because the court now examines from the angle of the purpose of ensuring the human rights. The consequences are totally different. Because earlier, it was just confined to mere political checks and balances. But now the objective of this theory is to promote human rights, to promote a rule of law, to promote constitutionalism, and to promote equality. In a Mulla Periyar case, there is that observation that a theory of separation of powers stands for equality. Why it stands for equality? It stands for equality because if there is a mixture of powers, uncontrolled exercise of power, resulting in a tyranny, then there is a violation of right to equality. Because arbitrariness and equality cannot go hand in hand. They are sworn enemies. In a E.P. Royappa case, that observation was made. If equality and arbitrariness are sworn enemies, and theory of separation of powers wages war against tyranny, invariably it promotes equality. Thus, even Montesquieu can also be given credit about using the concept of equality, but he was not explicit. But now the idea is becoming explicit. What is the impact of using theory of separation of powers as explicit principle in the Constitution itself? French Declaration of Rights of Man declares categorically that any society in which the safeguarding of rights is not issued and the separation of powers is not established has no constitution. See, there's a very important assertion made by the French Declaration of Rights of Man that there will be no constitution if there is no separation of powers, or if there is no safeguard of rights, then there is no constitution. So separation of powers takes the whole responsibility of protecting the human rights. French Declaration of Rights of Man became part and parcel of the French Constitution. Even today, it is a part and parcel of French Constitution through incorporation in the preamble itself. Thus, it is essential to interpret the French Constitution in the light of this theory of separation of powers. In American Constitution, we did not come across a specific or express provision that it stands for a theory of separation of powers. There are also executive power, legislative power, judicial power. These are stated in different articles, and various types of relations are contemplated. But the way in which a judiciary has treated it, that has undergone much change. See, in the early cases, we come across a very rigid approach relating to theory of separation of powers, because Madison's federalist view, or Montesquieu's views, or the American Declaration of War of Independence, all those views were used in the course of constitutional interpretation, and a theory of a separation of powers was given a very strict interpretation. I mean, a rigid interpretation in such a way that watertight compartmentalization of these three organs of government was indirectly suggested. But it is not workable, because the legislature has to exercise some of the executive functions or even adjudicative functions. In-house arrangements, appointments, and such things from the side of the executive by the legislature, or even intervention in the matters relating to making of treaties, because a treaty is also law of the land. And in that case, when an executive exercises that power, that check and balance from the side of legislature will be there. Then judiciary has its own inherent power, and it cannot be vested with a power by the legislature through an artificial means like a Judicature Act, etc., which recognizes a power of mandamus. When a power to issue writ of mandamus is an inherent power, the legislature has no business to recognize that power on the part of the Congress, on the part of the judiciary. And judiciary in Marbury case rejects that legislative recognition, because legislative recognition would mean that subsequently the legislature may take away that remedial right from the side of the judiciary. See, watertight compartmentalization was initially thought of, but gradually we come across the practice of devolution of powers or conferment of legislative power to the executive. See, in some of the cases where delegation of legislative power went riot, or when there was excessive delegation of legislative power. There's a Panama case and various other cases. The court interfered, and the court considered that the essential legislative policy is to be laid down, and all those principles were worked out, or they were articulated. And subsequently, about these propositions, some dilutions took place, because post-New Deal period, asking for a welfareism or a post-globalization, asking for a liberalization or say flexibility, needed new approach relating to the delegation of legislative power. Thus, relations among these three organs of a government have undergone change even in the United States of America. See, the purpose of providing for such a change was to ensure that ultimately there will be control over abuse of liberty, and there will be control over abuse of the regulatory power on the part of a state, etc. Thus, the relations are not say stagnant propositions. They are dynamic, they are changing. When the constitution itself is a product of a parallelogram of socio-economic forces, the constitutional forces demand that the relations among these three organs of a government should be put into work in such a manner that there will be better protection of liberties. This we come across with reference to some of the areas. For example, independence of judiciary. There we come across such structural controls. See, if appointment of judges is a privilege and exclusive power on the part of the executive, then it is quite possible that they may abuse and abuse their power. And constitution makers, especially Dr. B.R. Ambedkar, considered it as a very important requirement that in the appointment of judges, the primacy of voice shall be there on the part of the Chief Justice of India. It is on the basis of this particular proposition put forward by Dr. B.R. Ambedkar, a very important observation in the Constituent Assembly debates, that in a NJSA case and the first, second judges case, there's a Supreme Court advocates on record association cases. The court arrived at a conclusion that consultation is nothing but a consent in the context of appointment of judges, because a mere exchange of views cannot be regarded as appropriate. Whether the consent of Chief Justice of India is God, because we find that in the process of appointment of any constitutional functionaries, when an executive is vested with the power, we find that proper procedural safeguards are not followed, and the interest of judiciary, especially independence of judiciary, is not maintained. India has witnessed number of instances where judges were superseded in the context of appointment of a Chief Justice, or in the context of appointment of judges of Supreme Court. High Court judges are excluded sometimes, by through dilatory tactics. See, it is said that NJC judgment is a victory on the part of the judiciary. Is it really a victory? The post NJC position points out that through the process of delay and other tactics, ultimately it is the executive which has the last law, or which has the final voice. That is also not appropriate. There ought to be proper relation between the judiciary and the executive in matters relating to appointment. But independence of judiciary is one thing that is emphasized in the constitutional provisions by conferment of this contempt power, or by excluding any kind of a debate about the conduct of judges in the floor of the House, or about the requirements relating to, say, protection of their salary and other privileges. Then we find that in the context of administrative adjudication, quasi-judicial functioning, there again, the relations have undergone change. What is a quasi-judicial function? About this, there was much discussion, and post A.K. Krepak, we come across a different approach. See, administrative adjudication requires application of principles of natural justice, application of procedural safeguards. It is with this method that the core features of that particular organ of a government was ensured, or it was protected. In the field of parliamentary privileges also, we find that application of structural interpretation has protected the rights of people at large. In a Keshav Singh case, we come across that proposition, or in a Rajaram Pal and other cases, we come across ample development. There, the idea is that the individual members of the legislature shall be protected against arbitrary arrest, and they shall be given adequate procedural safeguards. Then about the speech made by the members of the House within the legislature, although they have a special privilege, it does not mean that they can abuse the position of others, or they can go to the extent of defaming the individual citizens. See, certain safeguards can be regarded as products of those relationships among these three organs of government. That's the dynamism with which the relations have grown points out that the constitutional development is in favor of absorbing all those structural implications within the constitution insofar as these three organs of government are concerned. Then these relations, like the explicit text or silence, should promote the basic objectives underlying the constitution. That is human rights values, multiculturalism, or say human welfare. See, theory of separation of powers is connected with the welfare, according to Justice Jagan Mohan Reddy and even Justice H.R. Khanna. In a Keshananda case, they make they link this democratic feature underlying the theory of separation of powers to the goals of welfare. Because in implementation of a directive principles of state policy, the power is conferred upon the state. What is a state? State is a legislature, executive, and judiciary for the purpose of Part 4 of the Constitution, according to Keshavananda case. See, the definition relating to the state under Part 4 is reiterating the definition under Article 12 by way of reference. But still, about the application, we find that all these three organs are to contribute towards a better implementation of directive principles of state policy. Between these three organs of government, there should not be quarrel insofar as the responsibility of implementation of directive principles of state policy. See, so many of the projects or welfare schemes or so many of the measures that are adopted by the executive relating to health, employment, education, or roads, or any other developments. There we come across first experiment is made by the executive. Executive does that. See, whether it is a Sarva Shikshan Abhiyan or a Janani Suraksha Yojana or say this Jawahar Rozgar Yojana, all these were first experimented by the executive. Then, of course, the legislature provided some formal shape to it and gave a permanent measure, permanent scheme for its implementation. It is a cooperation between the legislature and executive. And judiciary's interpretation of those schemes in a liberal manner, in a manner which gives emphasis on those welfare schemes, or that which makes it meaningful. All these have contributed to the success of this coordinated effort on the part of legislature, executive, and judiciary. Thus, from competition to coordination, there is a big movement. And when Professor C.S. Patil thought about this evolution of the relations among these three organs of government, perhaps he was thinking about the ever-evolving relations among these three organs. And this coordination is more in consonance with the basic purpose of the Constitution itself, because ultimately we have to use the Constitution as an instrument of social transformation. And the notion that Indian Constitution is a social document has some support from the view that Constitution has a sociological dimension. See, social embeddedness of the Constitution, that the Constitution is embedded in the society or social aspirations, and it is something which comes from the society, or which grows through the participation by the people. All this will be ultimately promoting the success of the Constitution, and relations are to be understood from the social dimensions as well. See, those social dimensions may have some cultural dimensions also. When an executive came with a policy about say a particular type of uniform in schools, and there is some social commotion, and the judiciary provides a remedy. See, that discussion, deliberation continues, it goes on, and how multicultural values are related to coexistence of different cultures, tolerance, harmony. All these principles shall become vital. About that, these relations contribute. Of course, today's inaugural session initiated by Sri Madhuswami opened up very important propositions about the way in which various types of corruptions, tyranny, and abuses are to be avoided, and proper relations become quite vital. And Professor Vijay Kumar has emphasized on the way in which the relations can be properly put into action or put into work. Yes, I think this provides a good foundation for the subsequent technical sessions, where meaningful discussions would be there. I congratulate Professor Chidambaram Reddy Patil for taking initiative for organizing this 2 days national webinar. Although we are in a hurry because of so many other works going on in the university, especially preparation for convocation, etc. Still, Professor C.S. Patil's enthusiasm and his systematic preparation is something that ought to be appreciated. I very much appreciate that, Professor C.S. Patil. Of course, he has taken all such efforts of contacting various scholars and organizing. With this, let me wish all the best to the whole of 2 days national webinar on evolving constitutional relations between these 3 organs of government. Since a technical session which I had to be handled tomorrow cannot be handled by me, because I'll be out of station. I'll be going to meet Honorable Justice Chandrachud for the purpose of inviting him for a convocation. I thought that the time that is available at this inaugural session could be used. Thank you, Professor Chidambaram Reddy Patil, for enabling all these things. Thank you very much. Thank you, Professor Vijay Kumar.
Thank you, sir, for your enlightening words. To conclude this inaugural session, I call upon Professor Ratna R. Bharamgaudar, Dean and Director, Karnataka State Law University, Hubballi, to deliver vote of thanks. Please, ma'am.
Thank you, Lavanya. A very good morning to everyone. Distinguished dignitaries, esteemed syndicate and academic council members, esteemed resource persons, invitees, faculty members, dear delegates, and dear students. On behalf of Department of Law and Parliamentary Affairs, Government of Karnataka, Bengaluru, and Research Center in Democracy and Constitutional Government, Karnataka State Law University, it is my utmost privilege to propose the vote of thanks. On this occasion, it is a great honor that esteemed Shri J.C. Madhuswamy, Honorable Minister for Law and Parliamentary Affairs and Legislation and Minor Irrigation, Government of Karnataka, and Pro-Chancellor, Karnataka State Law University has delivered the inaugural address. I express our heartfelt gratitude to esteemed Shri J.C. Madhuswamy for accepting our invitation and gracing the occasion. Sir has very eloquently shared his valuable thoughts that have been highly illuminating. In his absentia, on behalf of University, I express our sincere gratitude to Shri J.C. Madhuswamy. Thank you very much, sir. We are highly honored by the presence of Professor V. Vijay Kumar, Honorable Vice Chancellor, Bhopal National Law University, Bhopal. I express deep sense of gratitude to you, sir, for delivering the keynote address that has been an enriching learning experience. Thank you, sir. It's a great privilege to have esteemed Shri Venkatesh Nayak, Principal Secretary, Department of Law and Parliamentary Affairs, Government of Karnataka, as guest of honor on this occasion. I express our heartfelt gratitude to sir for gracing the occasion. Thank you, sir. Honorable Vice Chancellor, Professor P. Ishwar Bhatt, is the guiding light in all the academic endeavors of the university. I express sincere gratitude to Professor P. Ishwar Bhatt, Honorable Vice Chancellor, for his enlightening address. I must say that today it has really been a feast listening to two great scholars in constitutional law, Professor V. Vijay Kumar and Professor P. Ishwar Bhatt. Thank you so much, sir. I express heartfelt gratitude to our syndicate and academic council members for their gracious presence on this occasion. Our profound gratitude to Mr. Mohammad Zubair, Registrar of the University, for all the unwavering support. I express sincere gratitude to Professor C.S. Patil, Head of the Research Center, for the tremendous efforts in organizing this webinar. Our heartfelt gratitude to Professor G.B. Patil, Registrar Evaluation. We have eminent scholars as resource persons for this webinar. I would like to place on record our deep sense of gratitude to all the resource persons who have been kind enough to accept our invitation and who would be sharing their enriching knowledge. Our sincere gratitude to all the esteemed invitees, faculty members, delegates, and dear students. Last but not the least, it is the committed group of our faculty and our vibrant students who have put in a lot of efforts in coordinating and organizing this webinar. I express heartfelt gratitude to all of them. Thank you, one and all. With this, I conclude. Thank you.
Thank you, ma'am. With this, the inaugural session comes to an end. I invite Srishti, student KSLU's Law School, to take over for the first technical session.
So I can log out, may I?
Yes.
Yes, sir. Sir.
Thank you very much, sir.
Thank you
Thank
very
you.
much.
Thank you, Dr. Bhatt.
Yes, continue.
Professor Sunny. Good morning, Professor Sunny.
Sir.
Manoj Kumar sir also is there.
Good morning, Professor Patil.
Good morning, sir.
Good morning.
Good morning, sir. Good morning, sir.
Good morning, Manoj Kumar Sinha.
Good morning, sir.
Morning, sir. Manoj
Your
sir.
video is not on, sir.
Yes,
Ah,
available, sir. Now.
Yeah, now it is there.
Good morning, sir. Good
Yeah, now
morning.
you
Good
may
morning,
start.
sir.
Good morning, ma'am. Good morning.
Welcome back, everyone, and warm afternoon to you. I, Srishti, on behalf of the entire KSLU fraternity, welcome you all to the first technical session of the national webinar on evolving constitutional relationship between the legislature, the executive, and the judiciary. This platform is also an opportunity to welcome our resource persons for the afternoon tea. We are honored to have with us Professor Manoj Kumar Sinha, Director, Indian Law Institute, New Delhi, and Professor K.S. Sunny, Vice Chancellor, University of Advanced Legal Studies, Kochi, as the resource persons of this session. Ladies and gentlemen, may I now request Ms. Shraddha to introduce our first resource person, Professor Manoj Kumar Sinha, Director, Indian Law Institute, New Delhi, to our esteemed audience.
Thank you very much, Lavanya. Respected Professor Ishwar Bhatt, Honorable Vice Chancellor of KSLU.
Sir, Professor, sir, you will be introduced to our audience by Shraddha. Shraddha?
Can you hear me?
Yes, sir, I'm here.
Yeah. Sir, I can hear you. You will be introduced to the audience first, sir.
That's fine, sir. That's fine, sir. Introduction. No, Lavanya, don't worry about that. I think it's perfectly fine. No introduction is better introduction than proper introduction. All right, sir. Patil, sir, let it be there. No issue, sir. It's good. Thanks, sir, Lavanya. She has introduced me briefly, and that is like, no, I think adequate. Honorable Vice Chancellor, Professor Ishwar Bhatt, sir. Honorable Vice Registrar, Professor C.S. Patil. Honorable Vice Chancellor, Professor Dr. K.C. Sunny, sir, from Nuals, Kochi, and all respected honorable members present here, and those dear participants. Indeed, it's a great honor for me that I have been invited by Honorable Vice Chancellor of the University, KSLU, and also by Professor Patil to share my thought on the idea of freedom in 75 years. I have like structured. So after hearing Professor Ishwar Bhatt, so I had an opportunity to hear Professor Ishwar Bhatt in the end of the session, and he emphasized again on the very important aspect, the separation of power, and how freedom, in particular in the constitutional freedom, and the current development which we are seeing for last 3-4 years, which is happening, and we see that there's a growing tendency to assert that freedom is absolute. Like, you know, people are started asserting, and there. So, like when we talk about the separation of power, we confine to the executive, legislature, judiciary, and when we talk about the success of a liberal democracy or democracy and good governance, we focus on 4 or 5 things: separation of power in one hand. Then we also think about the participation of people, common people in the in the entire process. And of course, media is there, one of the elements. And this demarcation has been respected by each institution. Of course, sometime like what we have been witnessing, which happened in number of occasions, and recent one in the last year, where in one of the cases which Supreme Court of India has taken suo motu, that is the case related with the vaccination and distribution of the oxygen in the last year, in the same time, more or less in the beginning of April, by the Supreme Court of India in the suo motu. And in that case, Solicitor General of India vehemently opposed. He said that the Supreme Court should respect the policy matter, should not be in the policy matter, court should avoid to intervene or something, because distribution of vaccine is a subject largely in the domain of the is the policy related, and executive has to enforce. The court, I don't want to name the judge, but court has clearly said that court will infringe, court will look into the policy matter, court has a jurisdiction, but court also clearly stated that they strongly believe in the separation of powers. There's no interest or intention on the part of the judiciary to encroach upon the demarcation. But if necessary, if any policy matter which infringes the enjoyment of the fundamental rights, court will also, court can examine, court can look into. So if infringement of the fundamental rights takes place, court will not say this is the separation of power and this, so court has a power to look into the any things which infringes the particularly part 3 of the constitution, even part 4 of the constitution. Court can look into that, and that is there. Court, time to time, even in almost all the recent cases, if I take you to this Shiv Sena case when the Fadnavis government was installed for one day, then the Shiv Sena went to the Supreme Court of India. If you look into the judgment, separation of power was highlighted. If you look into the recent case in the 2020 Amit Sahni case, which was decided by the Justice Sanjay Kaul, Justice Anirudh Ghosh, and other 3 judges bench, every occasion court has highlighted about the importance of separation of power. So separation of power is there, and court has also clearly said that each organ has to respect the separation of power. But court has an power when it infringes fundamental rights, any policy or any step by the central government, that court can look into that. But the danger what we are witnessing today, the people's participation, reaction to the people in all matters, and particularly if I say in the recent case which High Court of the Karnataka High Court has delivered, which I'll discuss a little bit later. In that case also, people have started coming and criticizing openly to the judgments of the Karnataka High Court and others. So there is some kind of danger in a time in the 21st centuries where opinion, freedom of speech, and freedom of people's opinion expression can cross international border in a minute. It will not take much time to cross something from one jurisdiction to another. In a fraction of second, we pass through number of jurisdictions. And that danger what we are evolving. So people have to be restrained. Institution has to be respected. Institution has to be respected. We may not be happy. We may not be So sometimes even the judgment, so there's no harm in criticizing the judgment. But outrightly rejecting the judgment and saying that judgment is not, so means there is a threat to the institution by there. Even the next day, you see in the newspaper article, which also says it's not only criticizing the judgment, they go the further next step. They say how the Supreme Court should look into this matter, how Supreme Court has to look into the secularism. That kind of, so teaching of to the court has started in the in name of the freedom, which is a little bit dangerous trend we are moving in particularly. So what we see is the separation, a new institution, people's participation in a large scale is there. I'll take you another example where the Supreme Court of India in one of the case, which was decided in the 7th October in 2020, and it's a very famous case, Amit Sahni versus Commissioner of Police. That case was decided on the 7th October 2020 by the Supreme Court. There, the protesters, those who will, so this was basically a large number of people were agitating against the Citizenship Amendment Act, which was enacted in the 2019, and people have already in one of the location in Delhi, they have already occupied for almost for a quite long time, and that has created movement of the large number of people from one part to the another part, and people went to the Supreme Court of India. The court had said, on the other hand, the agitators started arguing the right to protest is absolute right. There's no scope. So right to protest is absolute right. And what we have seen in numbers, so this was the first case. But Supreme Court has clearly stated in the case of Amit Sahni versus Commissioner of Police, it's a very small judgment of 13 pages. If you look into the number of aspects, the court had said. Court had said, no, you have a right to agitate. So court tried to balance between the rights of the individuals, right of the groups, and same time the other groups also. We try to balance. So people have a right to agitate, but same time they have no right to obstruct a public way where it affects the movement of the people for there. Within 1 year, Then we have another case, very important case. So what we see, so this is the result of enactment of the Citizenship Amendment Act and also National Register for Citizenship. There are two important issues in 2019, which led to large number of agitations throughout the country. And subsequently, we see also, it's not only one side, we also see that government or state authority has invoked sedition law and particularly section 124A in number of cases. So extreme on the part of the state is also not good, which is danger, which we are witnessing in the recent time also. The another important which we have seen that Parliament has adopted. So Parliament adopts a law in its wisdom. It's not like Citizenship Amendment Act was adopted in a day, all of a sudden 2019. The process, Joint Parliamentary Committee, if you go into the search in the online, you'll find a Joint Parliamentary Committee has submitted around 400 pages report where all political parties or representative of the many political parties participated, discussed about the positive and negatives of the citizenship when it was in drafting stage. So there is a detail. It's not the Citizenship Amendment Act all of a sudden appeared. So there was a Joint Parliamentary Committee, and I encourage you go and look into the 400 pages where people have dissented also. It's not everybody has agreed. So there's a dissent by the number of opposition leaders, they dissented on there. But when the Citizenship Amendment Act it was adopted, people started lot of different kind of interpretation, and there people have a right to freedom is there, and freedom is guaranteed under the Constitution, and particularly Article 19(1)(b), which says people can assemble peacefully anywhere. So there's no harm. People can always oppose or there. But there is one important point which we have to remember. We have a right to assemble. We have a right to agitate, but that agitation has to be peaceful. And this is recognized not only locally, also in the globally. So one of the fundamental rights which we all have as a human being to agitate. It's not necessary we have to accept each decisions of the government or each act. So people have a right, but that agitation has to be peaceful. Of course, it was peaceful, but the moment we start obstructing, it creates some kind of problem, which is we started noticing. And we have to also remember these rights are not absolute the moment you cross. So when in 2010, if you look into the 2010, at the global level, what we see the change of the government in Algeria, in Egypt, and number of other parts, Pink Revolution started. Pink Revolution started in 2000, and a lot of governments have changed without causing any harm to the people. Lot of governments, including Libya, it took little bit violence, and finally we Syria, which ended in a very different way. So it was not successful. So Syria was in a different case, but all other earlier cases starting from 2010 to 2015, we see there was a support from the international community for people for agitating against their government, autocratic government or military government. This agitated and it was changed. So there was pressure, people have a right to peaceful assembly. So if assembly is peaceful, there is no harm. But the moment it's crossed this limit, there is a possibility of exercising power by the state authorities that is there. So what we have seen, so the point which I say that in the CA, the matter has gone to the Supreme Court and Supreme Court has clearly said. But when it comes to the implementation, even despite the judgment given by the Supreme Court, the agitation in Okhla was not ended. It continued even then. And it's because of the coronavirus pandemic, which entered in the beginning of 2020 March, and then gradually, the agitation ended in that particular context. The second important, which we see immediately after the 3 farms laws, which are the farmers agitation, and we all were parties. So it was very difficult for all of us to move from one part to the from Delhi to Haryana or from Delhi to UP. It was very difficult, for almost the road was completely blocked by the farmers. In one hand, we have a judgment of the Supreme Court of India, which clearly states that people have a right to protest, that right has to be respected by the authorities, and same time, people have a right to free passage also to travel the others, not to block. But non-implementation was there, that judgment. So even farmers' agitation ended in the negotiation and other parts. Last is in Karnataka, which is started with the Hisab issues, which I'll take a little bit later. So when I see that the understanding we all have today, a large number of people, we have fundamental rights under the part 3 of the Indian Constitution, no doubt about that. It's very clearly stated. And what in the case of Golaknath case, like, so sometimes we get confused what it means fundamental rights, what it means human rights, are they same or they have a different connotation or interpretation. But quote in the Golaknath case, and there's like, more or less it has been interpreted, and it's a synonyms, fundamental rights and human rights. When you talk about the fundamental rights, in a sense, we understand in the using the international human rights instrument what fundamental means. It means absolute. If I say the fundamental means absolute, there is no derogation, that those rights which are fundamental in a true sense, that cannot be derogated, that remains active in all time. So that fundamental rights means that no derogation. And this is like, and some way this aspect has been clearly stated under the international human rights, which recognizes derogation and no derogation. So no derogation, the rights which cannot be derogated in a true sense can be called as a fundamental rights. In a true case, others rights which can be derogated, they are not in true sense a fundamental, they are human rights, and those certain human rights can be suspended, certain rights can be suspended in a difficult situation in time of emergency, which we have under the part 18 of the Constitution, which will elaborate. But however, in a generic term, what we have a fundamental part 3 of the Constitution, which has been used. So the court in the Supreme Court of India in Golaknath versus State of Punjab case, which was AIR 1967 SC 1693, observed regarding this the term, that observed that fundamental rights are the modern name. So court said the fundamental rights are the modern name for what have been traditionally known as natural rights. So fundamental rights, you can say as a natural rights. What I mean is that the moment you're born as a human being, you have certain natural rights. The political implication of the theory of natural rights is that these rights being inherent in human beings, and it existed even prior to the birth of the state itself, and therefore it cannot be violated by the state. So what I have said, that court has also stated very fundamental rights, fundamental absolute rights. But when we look into the Article 19, when we look at the other rights also, we see that there are limitations, including Article 25, 26, and Article 19 of the Constitution and other articles, which says about certain limitations. It's not absolute. It's not an absolute. So what we see when we read the fundamental rights, part 3, when we read independently, when there's what I suggest and what I feel personally, when a teacher goes in the class, if he focuses fundamental rights independently, then interpretation will be entirely different. But when you read when you teach fundamental rights along with the emergency provisions, part 18 of the Constitution, so there's a need to correlate emergency provisions, particularly Article 352. There's a need to correlate because emergency provision Article 352 infringes fundamental rights. Article 352, when you look into it, says President has a power to proclaim national emergency on the ground of war, external aggression, and armed rebellion. In the 3 situations there. So national emergency gives power in that particular time, that suspension of the Article 19, that is 358, and Article 359, the suspension of enforcement of the entire part 3 of the Indian Constitution. The moment you read emergency provisions and then fundamental rights, then you start asking whether fundamental rights are absolute or not. And what we have witnessed, the national emergency in India had been used on 3 occasions. National emergency has been used on the 3 occasions starting from the 1962. The first one was the 1962 Indo-China War, which continued for almost 6 years, 1962, 1968. And then second occasion, we see from 1971, which continued till 1977. And in third, which came in the 26th, midnight of the 26th June, 1975, there on the third national emergency was imposed. That particular time, the freedom which we talks about. So real challenge to the 75 years, if I look into say, the real challenge of the fundamental rights or freedom, we have witnessed in the 1975 and 77, where all the fundamental rights were suspended. The entire fundamental enforcement of the fundamental rights were suspended, and which was upheld by the Supreme Court of India in IDM Jabalpur versus Sivkant Shukla. And all these subsequently, all the same judges start, except the Achar Khanna, rest of the judges, they all towed the line of the government of India and they accepted the fundamental. So time has come to the, so are fundamental rights truly fundamental? No. If I say in the 1975 and 77, it was not. So actually the part 18 prevailed over the entire part 3 of the Indian Constitution. Emergency provisions has prevailed over the, overshadowed the part 3 of the Indian Constitution. So the gap which existed in that particular time, in some way effectively addressed by the 44th Constitutional Amendment in 1978. What 44th Constitutional Amendment 1978 has done, it has identified that there are two articles under the Constitution which cannot be suspended. What I stated a couple of minutes back, there are two rights which cannot be suspended even at time of a state of emergency, and those two rights are Article 20 and 21 of the Constitution. Since then, we say in some way Article 20 and 21 acquired. So 20 is more a procedural rights and 21 become very fundamental right to life is there, and that particular constitutional perspective we see. So what we see, if we let the second aspect which I wanted to highlight, the emergency provisions, the suspensions of Article 19. So entire Article 19 can still be suspended in time of a state of emergency. Suspension of the part 3 in 359 has certain limitation now that Article 20 and 21 is there. The third point, which relates to the freedom of expression, freedom of speech and expression. Now you see how we react in today's when we have huge challenge. So there is some kind of restraint is required, and common man also. The recently, just I think 2 days back, when International Court of Justice delivered a judgment, not complete judgment, but it accused the Russia about it asked the Russia to stop the war, and also accused for the violation of international humanitarian law and other things there. The Indian judge, Justice Dalbir Bhandari, who is the part of that 15 judges of the International Court of Justice, he also sided against the Russia. We have to remember now, in the newspaper, you see everything. So in one hand, government of India voted always, either voted or in fact not voted, abstained from all the resolutions before the Security Council, General Assembly, Human Rights Council against the Russia. The government of India abstained. Government of India, because it has different relations with the Russia. So we did not come out openly against the Russia, and almost we sided with the Russia in all situations. We have been criticized for that. But a judge of the court has given a judgment which is not in line with the government's view, which is not in the line of the government's approach. But we have to also remember, media has also to be alert that the judge of the International Court of Justice is not representing India. It's not at the moment he has been appointed as a judge, he become a judge. He's not the judge of any specific country. He is a judge who will adjudicate even in his own country. So that is not the view. So his view should not be merged with, his view should not be merged and seen along with the government of India view. And that has compelled the government of India, the Ministry of External Affairs, to say his view is an individual capacity. What he said is an individual capacity. You see how people react, how people say, that is the like a danger we say. So freedom of expression, freedom of speech and expression, freedom of writing also to expressing your view, one needs to be very careful when it comes to there. So that reflects that there's a complete lack of understanding, those who write in the newspaper, those who speaks in the platform, sometimes which they totally mixed up, and that is the danger. So a judge is a judge, he's an independent, and he has to be kept separately from the state point of view or state representative. So he's not treated as a state representative in that particular context. There another important development which has taken, which is also important when we talk about the at the global level. I'll just take 1 or 2 minutes there, and then I'll come back to the other important part. So when we talk about the development which has taken place on the 15th of March 2022, what happened on the 15th March? Because sometimes when we have a freedom of expression, freedom of speech, freedom of expression, Article 19(1)(a), then what we see, there's a danger. What Professor Bhatt has mentioned, respect for the pluralism, respect for the multiculturalism, respect for other religions. That is a very foundation of the Indian ethos, Indian values, and of course on the constitutional values and constitution. So we existed. We have a very strong binding with all these things. But sometimes we by writing, by speaking, or something happens where it crosses. So there's a danger. There is a freedom has to respect each others, whether it belongs to the same religion, or same group. That is very important, and that is the duty on us. That is the duty on us to respect the culture, that respect of the religion. But what is happening? There's a hate speech on a particular religion. It's not confined to one country. It's confined to the globally for a particular religion. A particular religion is taking place not in India, not in only in India, in other countries. That has led to the forcing. So global community started thinking. You see that freedom, because this freedom has created a problem. So global, at the global level, it has been failed. It has been realized that there is a need to combat. The international community should celebrate a day. That is the 15th March relevant. International Day to combat Islamophobia. This date. So International Day to combat Islamophobia. That has become a global phenomenon. And this what happened in the United Nations General Assembly. So the resolution was adopted. So good. So now 15th March each year will be celebrated as a International Day to combat Islamophobia, that has been mentioned. And this resolution was sponsored by Pakistan. So Pakistan in the United Nations General Assembly, they did. And it has a support. It has a support of 57 members of the Organization of Islamic Cooperation and other countries, including China and Russia. They all supported the resolution. India and France little bit differed from the resolution, but they did not cast their vote against the resolution. So the resolution was adopted anonymously. So you see there is 75 years of the independence. What we see, there is some kind of locally or globally, both. There is some development which is taking place, which is very alarming, and which relates to the constitutional guarantees, which needs to be taken care of. Now come to the recent development which has taken place in the and that was also, I believe, on the 15th March 2022. So that 15th March 2022 is regarding the notification of the Kerala government in the February, for the dress code also that has been challenged in in the Karnataka High Court, and the Karnataka High Court gave a judgment on the Resam versus State of Karnataka on 15th, Resam versus State of Karnataka on the 15th March 2022. Court, there are 4 or 5 prayers were there, but we can look into the only 2 are very important. The first was whether wearing hijab is a part of essential religious practices in Islam. That was the main argument, like, the court has examined whether wearing an Islam, that question court answered to the constitutional guarantees. And there they said the petitioners argued not only Article 25, Article 19(1)(a) expression, attire, dresses, everything in the 19(1) and 21 also. So they cited about the expression 19(1)(a) and also about the Article 21 of the Puttaswamy judgment is there. But court, like, some way ended with saying, the court, it doesn't like restrict as such, like, there's no restriction. If we have to confine in a particular, like, in a school and colleges, if you are going, you are subject to certain kind of rules and regulations. So, like, if I see Bar Council of India makes it mandatory, the dress is necessary. So black and white, everyone has to wear and come to the class. So that kind of, like, regulation which prescribes and which all law colleges have to be followed. The rest of the time, people can wear whatever they want, whatever attire they say, they can express. But so court examined on the 2-3 important aspects, whether it's a, so court wanted to look into whether it's a essentially religious practice, essentially ERP. So ERP all of a sudden has become very important. Though, like, Surur judgment, 1960, but like old judgment where the Karnataka number of judgments related with the essential religious practice we have. But it became all of a sudden very ERP as a court, like, scholars have started essential religious practices. And then another important aspects, essential to religion and integral part of the religion. So court, like, some way differed or agreed with that. Court did not find anything wrong and says it's not like, if you are in school, colleges, that kind of attire, or they can put certain dress code has to be followed. So now that court case has come. So reaction of the people, petitioners' reaction was a little bit danger. So when you see that, like, the freedom we talk about, the freedom has a limitation under the Article 19, paragraph 2, which clearly states in the prevent reasonable restrictions are there under the Article 19, paragraph 2 of the Constitution on the ground of public order, decency, morality, or other grounds are there. So the state can impose certain restrictions. So the rights are not absolute. Rights are not absolute. Not all rights are absolute. That is the important point which we have to always think. So freedom in the, like, the moment we see if something goes, if Citizenship Amendment Act, people have a right to agitate, but the way it's, like, twisted, the way it has been interpreted, the way it has been for all sectors, it's not only by the scholars, by the other people also, the way it has been twisted, that said, this is particular legislations are targeting a particular community or particular something there. And that, so when they agitate, they say, they have a right to agitate, and that is the fundamental rights. But though all these rights are subjects of certain limitation, even writing is a subject of the detail. Now you see that a lot of developments has taken to regulate the contents or, like, subject matter in the social media. Also intermediary guidelines in 2021 has come. So we see the development is not absolute right. These rights can be suspended. These rights can be there. That is the very important point which we have to look into. As I said, then in addition to the grounds which are mentioned under the Constitution, one can examine this under the international human rights instruments also. The human rights instruments in the international level or even the regional level are clearly stated about the nature of the rights, whether they are fundamental or whether that rights can be suspended or that rights can be not suspended. What situations right can be suspended, what situations rights can be limited. It is much clearly stated in the international human rights law or regional human rights law, which says, if their state existence is in danger, state sovereignty is in danger, state can suspend the enforcement of a large number of rights, which include the freedom of speech and expression under the Article 19 of the Constitution, and even under Article 19 of the International Covenant on Civil and Political Rights. So those freedoms can be limited. So it's not the understanding that these rights are absolute. That is the wrong understanding. Of course, the Supreme Court of India over the years, one by one, we have president by president, made an attempt to strengthen the rights which are part of the Indian Constitution, the rights which have been strengthened. The interpretation, if we take note of the A.K. Gopalan versus the State of Madras and to the Maneka Gandhi journey, what we see over the years, the Supreme Court of India try to see that the procedure established by law become due process of law by the Maneka Gandhi. So court on its own have a very liberal approach. The court judiciary has a very liberal approach, or we can say judiciary is like guardian in promotion and for protection of the human rights. Promotion, of course, state has to promote the human rights, but the protection of human rights, when we talk about the Supreme Court of India and high courts, respective high courts, have been playing very important role in strengthening the content of the fundamental rights mentioned under the Indian Constitution. So that is the great relief. So what is important today? We need to respect the institution. We need to, our freedom is the moment you become law students or scholars, we tend to become judgmental. We have a right to criticize. You can criticize, you don't need to criticize the judges. You have a right to criticize the judgment. And in that process, what we are witnessing in the freedom level, it has gone in a very extreme extent, when each individual has his own way of looking at the rights, forgetting its own duties, not agreeing with the decisions of the court. Those developments are threat to the institution, not by the individual. So individual rights, we must respect the institution, even in the judiciary. Like political institutions are subject to their functioning are reviewed. Political institutions are subject of vote. Each 5 years, their performance can be assessed by the public, and public decide not. That is the beauty of the democracy. That is the beauty of democracy, where people have right, they can suffer, but they say in 5 years. So that was the duty which was reflected in 1977 general election. So court failed to do justice in 1976 when court has given a judgment in the ADM Jabalpur 70. But the same when at the time of voting, people have ousted Indira Gandhi and its entire Congress party was decimated in the 1977 general election. So we have, as I said, in the liberal democracy is not only the good governance, which is based on the separation of power principles on the executive, legislature, or judiciary, but it's also people's participation, people's political participation. So we have also a say. So if anything goes wrong, people can always decide on the vote. But in the judiciary, we have to respect. Judiciary keeps on correcting. So what has been said in the ADM Jabalpur has been subsequently overturned. So institution must be respected. Otherwise, there are occasions where we're witnessing honorable judges feel prone to abused on the social media and troll. And that is the reason they are very, like, it's a very difficult situation. So institution, we like, that is the point which I wanted to highlight in my speech. We have a judgment. If you look into the Sabrimala judgment, which was delivered on Indian Young Lawyers Association versus State of Kerala 2019 11 SCC 1. That judgment was like, you all are aware about the judgment. And then finally the judgment was for the review, which like in 2019 is pending in the Kantaru Rajivaru versus Indian Young Lawyers in the review petition on the there. So court also clubbed the number of cases like 2-3 like the entry of Muslim women in the mosque, then Parsi women married to the non-Parsi, and 367 issues are there. But if you look into the judgment, the Sabrimala judgment, which has ended a practice which existed for many years as a non-discriminatory. So some people have questioned whether courts should look into the religious matters or not, or it should be decided by the people like community itself. There are a number of issues which we see, but the beginning of the 21st century, or beginning of the, I think the second decade of the 21st century, have witnessed there are landmark judgments have been delivered by the Supreme Court of India towards empowering the individual, empowering the woman, empowering the right to like Puttaswamy judgment, Joseph Sain judgment, Saira Banu case there, Sabrimala judgment is there. So we see the judgment in the 2016 onwards, a series of cases decided by the Supreme Court, which has given much needed relief to the particular sections of the society and overall in the community. So I end with saying that we have a freedom. We have a freedom which has been guaranteed, but same time we have to acknowledge these freedoms have been certain limitations are there. We ought to respect the institution which is delivering the judgment. Otherwise, it will lead to the anarchy. Otherwise, it will lead to the disturbance, and which will become a big serious issue. The institution must be respected. With this, our freedom, we must acknowledge that freedom is not absolute. Freedom is there to enjoyment of the rights which are mentioned in the Constitution. Of course, respect the others' right as well, and then society will progress. With this, I end here, and I thank Patil sir and Professor Ishwar Bhatt. Thank you very much. Over to you, Patil sir.
Thank you, sir. Thank you very much.
Thank you, sir, for giving your valuable insights on the topic. I'm sure your address will help a lot in understanding the concept of the idea of freedom in contemporary times. May I now request Srimati Akhila Prabhu, Research Assistant, to introduce our second speaker for the session, Professor K.C. Sunny, Vice Chancellor, National University of Advanced Legal Studies, Kochi, to our esteemed audience. Please, sir.
Thank you, Sushri. Professor Dr. Sunny has 30 years of experience as a teacher of Kerala University and the Central University of Kerala, out of which 11 years as professor and 8 years as dean. After passing the LLM examination with first rank in 1986, he started his teaching career at Kerala Law Academy and Law College. Later, he joined for research with UGC Fellowship and secured PhD. Sir has joined Kerala University Department of Law in 1990. He had published the book Corrupt Practices in Election Law and more than 45 research papers. 17 students, including 2 foreign students, successfully completed PhD under his supervision. He was the international observer to Nepal Constituent Assembly election 2006 and Bangladesh parliamentary election 2007. He had delivered lectures in 16 foreign universities and had interactive sessions in 6 foreign universities, including Harvard Law School. For 7 years, he served as the program chair of International Conference on Law and Public Policy held at Singapore. Professor Sunny also sits as a member on various academic and other councils. He has also served as a member in 7 government committees. Presently, Sir is serving as Vice Chancellor of National University of Advanced Legal Studies, Kochi. on behalf of KSLU Center for Research in Democracy and Constitutional Government and Karnataka State Law University, I welcome you to the webinar, sir.
Welcome, sir, and thank you, ma'am. We are honored to have you with us. To commence with our second lecture now, I request Professor K.C. Sunny to address us on judicial interference in policy matters, its scope and limitations. Please, sir.
Honorable Vice Chancellor of Karnataka State Law University, Professor Dr. P. Isharfat, Senior Professor of KSLU, Professor Dr. C.S. Patil, respected Director of Indian Law Institute, Professor Dr. Manoj Kumar Sinha, other eminent teachers, and dear friends. I had the occasion to hear the last portion of the speech of Isharfat sir and the speech delivered by Manoj Kumar Sinha sir. In the speech, in the last portion, Pat sir highlighted the point that Indian Constitution is basically a social document. Sinha sir elaborately stated the new dimensions of the concept of liberty and the initiatives at national and international level for facilitating the individual freedom. My topic is also, to a certain extent, related to the points raised by Pat sir and Sinha sir. My topic is the scope of and extent of judicial review in the matter of policy issues. When we are considering the issue of policy in public law, policy is something related to governance. As all of us are well aware, the constitutional system of governance, we have elected representatives for the purpose of governance. And any type of governance, policies are essential because policies, programs, and priorities, these are the three essential things for governance. When we are discussing the issue of policies, we must take into account of the modern moral philosophy for governance, that is welfare state, at the first hand. Secondly, the approach of our constitution towards policy. Actually, during election, policies, programs, and priorities will be placed before the electorate in the form of election manifesto. So if one party got elected, they can claim that we have the mandate of the people for implementation of this policy. But in the constitutional system of governance existing in India, basic policy choices are incorporated in the constitution itself. We have part 3 of the constitution, the directive principles of state policy. Directive principles of state policy. So, basic policy choices are incorporated in the constitution itself. So, the policies formulated by political parties at the time of election for the purpose of submitting before the people, seeking their mandate, the policies should be in tune with the basic policy choices enshrined in the constitution. Then, coming to our issue, what is the scope of judicial interference in the matter of policy issues. When we are discussing judicial review, there are certain specific grounds for judicial review, like judicial review of legislation, like lack of legislative competency and violation of fundamental rights. What may be the policy? If it is violative of fundamental rights, definitely judiciary can interfere and declare that legislation which is enacted on the basis of a particular policy as invalid. That is one aspect. Coming to the administrative issues, for the purpose of administration also, government is formulating policy. That is why in Karnataka there is one institute that KILPA, Karnataka Institute of Policy Research, I think. Policy research. That is a very good thing. That is a very good thing, and we must appreciate the state of Karnataka for establishing such an institute. Anyway, coming to the scope of judicial review in policy matter in relation to administration, the first point is that there are so many policies which cannot be reviewed by the judiciary. Singhasa stated about some issue related to our foreign policy in the context of this war between Russia and Ukraine. There is a concept of political question. The concept of political question is that there are certain things, especially things related to policy, which are not subject to judicial review. For example, budget allocation, financial matter, that cannot be reviewed by the judiciary. Then foreign relations, whether India may continue the relationship with Israel or not, or what must be our policy, what must be our foreign policy in relation to some other issues like Taiwan or what may be. That is not subject to judicial review. So there are then whether India should declare war against a particular nation. Here, yes, war wherever may be is harmful and dangerous to human beings. Whether judiciary can issue the writ of prohibition, prohibiting the government to prohibition against declaration of war. That is not possible because all these things are political questions. That aspect is there. But there are certain areas where judiciary can interfere even in policy matters. And when we are speaking about these things, day before yesterday, there was one issue where Supreme Court mentioned about this policy issues. That is the legality of one man, one pension policy or something like that in relation to pension scheme of military people. Court stated that generally we will never interfere with the policy matters. But last year, there is one important decision. That is in redistribution of essential supplies and services during pandemic. That is a suo motu petition. In the issue is related to our vaccine policy. This issue came before the Supreme Court in the context of government policy of the central government at the time of second wave of the pandemic, COVID-19, maybe between January 2021, started in January 2020. According to the policy governmented by central government in relation to vaccination, the government adopted the strategy that the Serum Institute India and Bharat Biotech would allocate 50% of their production capacity to the center at the previously agreed prices. 50% to central government at the price previously agreed. The remaining 50% would be reserved for an other than Government of India channel comprising of state governments and private hospitals. So the ultimate effect is that state governments may bargain with these two institutions which are producing vaccine in the matter of price. Then private hospitals can charge huge amount for the purpose of vaccination, whether this policy is correct or not, because pandemic affecting all persons. Basically, there is only one government in India. India is a sovereign state. Then whether this sovereignty is divided between central government and state government, all these things are one issue. As far as the rights of the human beings, as far as the protection of rights, basic human rights of citizens, there is only one government. That is generally Government of India. That is a Government of India, which is competent to make policy. Maybe effective consultation with the state governments. That is another issue. Another issue. When a war is declared against a particular state, there is only one government, that is Government of India. So in certain contexts, we must say that there is only one government, that is Government of India. This Government of India is stating that 50% of the vaccines will be distributed in the concessional rate. Regarding the vaccination of others, that the persons who are not covered by the orders of the central government, state government may bargain. This was the issue raised before the Supreme Court. Supreme Court appointed an expert committee. Then the amicus curiae was also there. Then the contention of the government was that the current vaccine policy conforms with the Article 14 and 21 of the Constitution and requires no interference of the court, as the executive has, this is the point, executive has no room for free play in the joints while dealing with the pandemic of this magnitude. But Supreme Court took a different approach. The court cited two decisions. First one is decision by the Supreme Court of United States. During the COVID period, I think there are 3 or 4 decisions by the Supreme Court of United States dealing with the issues related to pandemic. One is related to the order which insists that the companies which are engaging more than 100 employees must ensure the vaccination and other things. The court stayed that decision. Here, Supreme Court, our Supreme Court stated that the Supreme Court of United States, speaking in the wake of present COVID-19 pandemic, that is Calvary Chapel versus Steve Siso, pandemic in various instances can overrule the policies by observing. In various instances, court overruled the policies by observing inter alia that members of this court are not public health experts, but we should respect the judgment of those with special expertise and responsibility in this area. But even in a pandemic, the Constitution cannot be put away and forgotten. And a public health emergency does not give the governors and other public officials carte blanche to disregard the Constitution for as long as medical problem persists. As more medical and scientific evidence becomes available and as states have time to craft policies in the light of that evidence, court should expect policies that more careful, policies that more carefully account for the constitutional rights. So even in policy matters, judiciary can interfere and say that policies should be in tune with the mandate of the Constitution, especially in the matter of protection of constitutional rights of the citizens. Then the court cited another decision, that is a decision from Supreme Court in Gujarat Mazdoor Sabha versus State of Gujarat. In that case, while speaking in the context of labor rights, the court noted that policies to counteract a pandemic must continue to be evaluated from the threshold of proportionality to determine if the inter alia have a rational connection with the object that is sought to be achieved and are necessary to achieve them. So in such a situation, whether doctrine of proportionality is followed, that can be examined by the court in the context like spreading a pandemic. I think the court is in the right direction in this regard, and here the court issued certain directions to the effect that a vaccination policy may be formulated, then proper mapping should be done. What are the actions to be taken by the government till December 2021, and we can see that central government changed its policy. And proper proper mapping was done, and India had achieved a target of vaccinating the people of nearly, I think, 82, such a manner that nearly 100 crores people have been vaccinated on that. Anyway, this decision clearly established that there is ample scope for judicial review, even in areas which is traditionally considered as policy matter. I think this is an activist role played by the judiciary. And earlier also, there are so many decisions where court had entered into the zone traditionally assigned to judiciary, having policy overtones by adopting the strategy of judicial activism. We may remember that in Vishaka case, court had gone further and issued certain guidelines, properly known as Vishaka guidelines, for protecting the women employees from the evil of sexual harassment, stating that this decision shall be followed till the enactment of a legislation. Fortunately, the government was willing to enact the legislation. Anyway, I think this decision, that is in redistribution of essential supplies and services during pandemic, is very important in the context of scope and limitation of judicial review. Now time is 1:10. I think the audience, I think there may be 120 participants, and most of them are interested to asking questions, most probably related to the presentation of Singha sir, because so many issues having contemporary relevance is raised in his presentation. I congratulate the Karnataka State Law University, especially Phat sir and Patil sir, for organizing this seminar. Thank you very much.
Thank you very much, sir. Hello.
Yes, we can hear.
Thank Thank you very much, sir, for your valuable information regarding judicial interference in policy matters. It will definitely help us in future. As we are at the end of this session, I thank everyone for being a part in making this session a grand success. I thank our legal luminaries, Professor Manoj Kumar Sinha and Professor K.C. Sani, for taking time off their busy schedule and enlightening us. Thank you, sir. Now we will be having a break of 30 minutes and the second session will begin at 2 p.m. I request all the presenters to join before the 5 minutes. Thank you, everyone.
Okay.
Thank you, sir. Thank you, Sunny, sir.
Okay, thank you, sir. Okay.
Bye-bye.
Okay. Oh, we can physically meet soon.
Yes, sir. Yes, sir.
Good,
Sure,
good.
sir. Thank you. Sir. Thank you.
Hello. Shraddha, can you hear me?
Yes, sir.
Yeah, bye. Yeah. Please ask questions if any participants, delegates, students, you may please ask questions. It is so nice of Professor K.C. Sani to volunteer to answer the questions.
I guess there are no further questions. So now I would like to thank Professor Manoj Kumar Sinha and Professor K.C. Sani for giving the valuable time for us. Thank you, everyone. Also, I thank C.S. Patil sir for guiding us.
Yeah. So thank you very much. The next session will resume at 2 p.m. Okay. I request all of you to log in 5 minutes before 2 p.m. Thank you.
Yes, sir.
Thank you very much, sir. Professor Sani sir and Professor Manoj Kumar Sinha sir. Thank you. Good afternoon, sir.
Good afternoon. How are you?
Sir, your blessings, sir. Doing well.
We will be starting in about 3 minutes.
Yes, sir. Yes, sir. In 3 minutes, we will start, sir. This is sir. Idhar. Idhar, this is sir.
Shall we begin, sir?
Yeah, you may start.
Yes. Good afternoon, everyone. I am Pratiksha Kulkarni, student of KSLU. Once again, I would like to welcome all the dignitaries and participants to the second session for the day. Of course, today on this platform, we have got this very opportunity to listen to Professor T.V. Subbarao, Professor Emeritus, VIPS, Delhi. I now call upon Shraddha Halapnava, student, KSLU's Law School, to kindly introduce our distinguished resource person.
Very good afternoon, one and all. Professor Dr. T.V. Subbarao, presently working as Professor Emeritus, VIPS, Delhi, started his career as a teacher of law in 1978. He is considered as a good teacher, able academician, and efficient administrator. Professor Rao has made marked contribution in rationalizing and strengthening the administrative reforms and systems in the universities which he worked. He held many academic, administrative, and supervisory in the university system. Amongst the many, few are acted as a visiting professor, director, Research and Development Council, chairperson, Postgraduate Council, National Law School of India, University, Bangalore. As a teacher, he is appreciated by his students for his ability to reach the slowest learner and develop passion for the profession, as also for his helping hand. In recognition of his valuable work as a teacher and professor, Professor Rao has been conferred with State Award for Teachers by the Government of Andhra Pradesh in the year 1999 to 2000. His services are highly sought by institutions and professional bodies. And he's a regular trainer for various officers. Trained in reputed institutes in the country, Professor Rao has specialized knowledge in constitutional law, international law, human rights, family law, ancient Indian law, and law relating to cyber crimes. Two key areas of women in law and research methodology continue to be his areas of interest. Professor Rao is known for his contribution to the development of curriculum in law in the capacity of chairman and member of board of studies in various universities across the country. He worked hard in implementing the component of clinical legal education in the curriculum. As a researcher, he undertook the task of judging the justices. He is a prolific writer, and his zeal for academics is evident through his works and publications. He has a good number of publications to his credit: 2 books, edited 6, co-authored 1, 25 articles, and 23 papers. His works are often quoted. He has organized 41 conferences and various seminars and training programs. His mission has been to strive for knowledge-based society through imparting appropriate academic and professional skills among the students in the field of law and to promote among them all the competitive and competent performance. Thank you for being with us here, sir. We are all eager to learn from you. Thank you.
Thank you, Shraddha. Now I request sir to
Thank you very much for a very lengthy introduction. I do not know, perhaps they have downloaded it from the internet from some other programs. The same thing I am hearing for several years. Okay.
Thank you, Shraddha.
Good
I now
everybody.
kindly request sir to address us on the topic constitutional morality in the context of separation of powers. Please, sir.
Good afternoon, everybody. Am I visible and audible?
Yes, sir. Yes, sir.
At the outset, my friends, let me thank Professor C.R. Patil and his team for giving me this opportunity to talk to you, and to the Vice Chancellor, Professor Ishwar Bhatt, and the other dignitaries. Firstly, let me say Happy Holi to everybody.
Yes, sir. Thank you.
When Chidananda Reddy Patil contacted me, I do not know why I have opted for this topic. The reason is that it has contemporaneous relevance. Whether the Supreme Court is justified in invoking constitutional morality or not is the debate that is going on. So let me briefly give the background of the Constitution as well as how the controversy between judiciary and legislature has arisen, and then we will go to constitutional morality. Friends, Greece, Egypt, and Rome have all disappeared from the surface of the earth. But the name and fame of India, our country, has survived the ravages of time and the cataclysms of ages. Surely there is an eternal element in us which had frustrated all attempts at our obliteration. These were the words of poet Iqbal. Indian Constitution has received several onslaughts, but it survived. It is a miracle, my friends. Yeah. 12 years ago, when the entire world was looking with keen interest at a newly born nascent India, we started our tryst with constitutional governance. Between 1947 and then till the Constitution came into force, of course, we were governed by the Government of India Act of 1935 with reference to constitutional principles. We have adopted our Constitution. We started our tryst with the destiny and constitutional governance to realize our dreams and aspirations. That is why always I used to say awareness of constitutional law is a reducible minimum for an Indian, not only for law persons, my friends. But if you ask me a question, how many of us know it, leave alone constitutional morality or transformative constitutionalism, the new expressions that are used by the Supreme Court. How many of us know the Constitution? And then how many of our representatives know the Constitution? It is $1 million question. The greatest of all the means for ensuring the stability of the constitutions, but one which is nowadays generally neglected, is the education of citizens in the spirit of the Constitution. Highlight that word, spirit of the Constitution, which the Supreme Court started using it from 1950 onwards. The Barker Ernest Politics of Aristotle, he has made this statement. The architect of the Indian Constitution, Dr. Ambedkar, opined that I feel that the Constitution is workable. It is a flexible and strong enough to hold the country together, both in peace times and in war times. He added, indeed, if I may say so, if things go wrong under the new Constitution, the reason will not be that we had a bad Constitution, but what we will have to say is that man was wild. A wonderful statement he has made. The experience for the last 72 years, my friends, shows very clearly that the men working on the Constitution may not be bad, but certainly they were not at their best or up to the mark. Constitution is like a live wire. If it is dead, our growth is stunted, we are undone, and the nation itself is dead. And one should know that it is not a plaything of anybody, whether it is a politician or a judge. It is for the people, we the people of India. India certainly requires a cautioning call or a guard against legislative lethargy, executive inertia, and judicial overreach. That is why I have pointed out, rather, this particular aspect we will discuss. The criticism is that, with reference to judicial overreach, reinventing constitutional morality recently with a different meaning and different interpretation in a different context is an example of judicial overreach. Some people say, let us see whether this is a justified statement or not. There is a growing practice on the part of the legislature, executive, to abdicate the constitutional values and questions leaving it to the court, casting upon the judges the sole responsibility and odium and unpopularity of enforcing constitutional restraints. As the Chief Justice Cullen once stated, of New York judge once stated, the greatest misfortune of the day is the mania for regulating all human conduct. Okay, conflicts between executive, legislature, and judiciary trying to assert supremacy over the other is not a new thing in India. Of course, legislature and executive, they are on one side and judiciary on the other side. If one scans through the historiography of relationship between judiciary and legislature, it is the history of conflicts, dissensions, disagreements, leading to catena of cases and series of nullifying amendments. How do you explain 105 amendments within 72 years? Within 72 years at the rate of 1.5 amendments per year. The Constituent Assembly itself, my dear friends, if you look back, acting as a provisional parliament, brought the Constitution, First Amendment Act, of course, as a result of the cases. If you remember, Ramesh Thapar versus State of Madras, Brijbhushan versus Delhi administration, Champake Roy Rajan versus State of Madras, Kameshwar Singh versus State of Bihar. So Constitution First Amendment Act itself was brought by the Constituent Assembly, who were well aware and who spoke about constitutional morality. They brought it. The serious inroad, of course, entering into the field of resolution of disputes, keeping certain things beyond the purview of the court by introduction of 9th schedule, my friends. The saga continued. 4th Amendment, because of Bella Banerjee's case. Of course, when 4th Amendment was brought, this was the effect of 4th Amendment was whittled down by the Supreme Court in its judgment in Vajravel Mudaliyar versus Special Deputy Collector. 7th Amendment was brought because of Punhi Commons case. 17th Amendment, in order to give umbrella to several enactments, placing them under 9th schedule, has given rise to the controversy. You know that it was tested in Sajjan Singh's case, which has judicially laid seeds even for basic structure theory subsequently. First, that expression was raised in this case itself. And you know, often stated judicial usurpation. Golaknath case, same 17th Amendment Act was again a question. As a result, we can see 25th Amendment Act, R.C. Cooper versus Union of India. And ultimately, Keshavananda Bharati versus State of Kerala, one of the principles of basic structure was evolved. Now people say, more than the basic structure, this invocation of constitutional morality later in the day is causing some suspicion. We know that after Keshavananda Bharati says what has happened, emergency and all those things, Constitution, 42nd Amendment Act, ultimately resulting in removal of right to property under Constitution, 44th Amendment Act from the head of the fundamental rights and making it as an ordinary constitutional right. The constitutional makers who brought comprehensive amendment touching every aspect of fundamental rights, they brought it first. Don't they know the constitutional morality? The result ultimately is that, hear my friends very carefully, the fundamental law of the country, we have wounded it several times, and now the certainty of fundamental law is lost forever. Are you certain about constitutional principles? What you say yesterday may not be correct tomorrow. Certainty is lost, my friends. Lost it forever. And amending the constitution has become fanciful. The Parliament amended Representative People's Act in 2002. Do you know one of the provisions that was stated in that was that the Parliament has no, rather, Section 33, referring to Section 33, if I remember, it provided that notwithstanding anything contained in any judgment of any court or any order of the Election Commission, no candidate shall be liable to rather disclose or furnish the antecedents and all these things. That case you must be knowing. PUCL versus Union of India. Of course, the court asserted once again the parliament has no legislative competence to direct the state instrumentality not to follow or disobey the court orders. And another thing, you know that judges acting as judges in their own cause, second judge's case, Supreme Court advocate on record association versus Union of India. I think you remember that according to judiciary, the primacy with regard to appointment of judges is the basic structure of the constitution. So primacy for the judiciary in the name of collegium is maintained, even though the word that was used was consultation. Subsequently, series of decisions, they have modified it. Now it's collegium. Whether it has propriety or not, that is different issue altogether. I am trying to show you the legislative and judicial conflicts over a period of time. Now let us see about separation of powers. One thing which you should understand, my friends, that the concepts of rule of law, the separation of powers, and checks and balances, they are related in complicated ways. As Jacob Levy has stated, they all form part of constitutionalism, which often is invoked as a part of constitutional morality. And then what one should understand is that the coordination between these organs of the government is the gist of constitutional morality. When thinking about executive, legislature, and judiciary, their coordination and functional separation, when you think about it, one should necessarily consider the idea of role morality. A slight distinction, the people say role morality or constitutional morality, and it is its place in constraining the power. It is for that it is required, not with regard to one wing of the government, namely executive, or namely the legislature, or not judiciary is not exempted. If Nehruvian speech, if you can see, after constitution was adopted and he wanted to bring in land reforms, he expressed the hope the judiciary will not interfere. Judiciary interfered. And First Amendment was brought in, 9th Schedule was brought in. My friends, half of the amendments would be unnecessary if right to property is removed. Major amendments were brought only to protect right to property, my friends. One should think of the constraints on power that stem from constitutional morality as an internal one, as opposed to external check. Hope you will be able to understand. So the constraint shall be internal, not external. The separation of powers is not merely checks and balances, my friends. It is also a vision of keeping lawmaking, law enforcement distinct so as to protect the rule of law. That is an important one. One more thing which I would like to tell you in this regard is that if one sees the evolution of doctrine of separation of powers in its elementary sense, in the 2nd century BC, Polybius in Rome has enunciated this one. In that sense, this concept of separation of powers, as you are telling, was a forerunner. Rather, that aspect is the forerunner to the 17th century theories of checks and balances and separation of powers. You know that John Locke's exposition of separation of powers was quite different. He was for discontinuous legislative power, that is one thing, rule-making power. Secondly, continuous executive power, both executive power and judicial powers he has included in that. And then federative powers. This was the division made by John Locke. This is not the model that we follow now or subsequently. The question of constitutional moralities and confusions thereof arose as a matter of check when the countries predominantly opted for Montesquieu's doctrine of separation of powers. As a law student, all of us, we know that the French jurist Baron de Montesquieu, 1689 to 1775, mainly he was rather bothered about his country's position compared to that of England. He has improved John Locke's theory of separation of powers and laid strong foundation for separation of powers. Separation of legislation, administration, and adjudication. And they should not be placed in one hand. And he has pronounced his own explanation for that, with which we are not bothered. This has influenced mostly the adoption of the American constitutional position under Article 1, 2, and 3, separation of 3 branches. Of course, there is an overlap. Strict separation of powers never existed anywhere. Then Madison has stated, combining all these powers is the very definition of tyranny. Usurpation of power of judicial review that was not known previously was articulated by Chief Justice Marshall, as all of us know, in Marbury versus Madison 1803 case. If you read the facts of the case, my dear friends, you will know that Marshall should not have rather sat as a judge to decide that case, because he was a judge in his own cause. He was the person who has signed that as a note file for the appointment of Justice of the District of Columbia. And he himself afterward decided, of course, in a negative manner. But the thing is that he was a judge. It will not happen now. Nonetheless, separation of powers along with rule of law was always considered to be a part of constitutionalism. Indian Constitution, coming to that, makes a tripartite classification of powers between executive, legislature, and judiciary. Nonetheless, it is not on the lines of Montesquieu's classification. Even one of the directive principles of the state policy under Article 30 requires only separation of executive from the judiciary, starting from British period. That was the demand, and that is why it is placed under directive principles of the state policy. And clearly, if you see the judicial opinion in Delhi, Indri Delhi Laws Act, Justice Patanjali Shastri clearly observed there is not least indication that the framers of Indian Constitution made American doctrine of separation of powers, namely that their absolute separation of powers and vesting in different hands lay the basis. And that was the observation. We did not follow it. Very clearly again, it was stated by Supreme Court in Ramajavaya's case. Indian Constitution has not indeed recognized the doctrine of separation of powers in its absolute rigidity. When these two cases are there, it is interesting to note, my friends, in Keshavananda Bharati versus State of Kerala, AR 1973 Supreme Court page number 1461, Justice Sikri, Sheelat and Grover, they said in their exposition of basic structure that separation of powers and demarcation of powers between legislature, executive and judiciary constitutes basic structure. We may not take it as a majority opinion, only 3 judges out of 13. Out of 13, there were 11 judgments, not one tallying with the other. That is different story altogether. The separation of powers is often blurred under the Indian Constitution with regard to distribution of powers, my friends. It is important to note one point before again we are going for conceptual exposition of constitutional morality. Constitutional texts, including that of Indian Constitution, are never comprehensive or totally complete. Let it be American Constitution or any other constitution, including Indian Constitution, they are never comprehensive or totally complete. Some matters of constitutional relevance are left deliberately unaddressed or underdetermined. For example, we have privileges directly we have omitted, or the provisions thereof are impacted or influenced by the then happenings, which may not be totally applicable today. I give you the reason, my friends. If you see specifically framing of Article 19 as well as Article 21, the banks of partition influenced the framing of Article 21 and Article 19 also. Diluted form of due process clause, procedure established by law under Article 21, and the restrictions even prior to Constitutional First Amendment Act, they were influenced by the happenings at that time. It was more than a lockdown in several places of India. No movement, fear to speak. So in order to protect the nascent republic, even we brought the preventive detention provisions. These things which are left unaddressed, we may call them constitutional silences. These constitutional silences, my friends, posed various challenges for constitutional designers, judges, politicians, even to the people. We are left confused. These are all we may term as constitutional confusions. Justice Chalameshwar, in that privacy case Puttaswamy versus Union of India, which was delivered on 24th August 2017, maintained that there is what is known as constitutional dark matter, constitution's dark matter, he said. And he went further to say that, to me it appears that Keshavananda Bharati was not on the dark matter. After amendment, this constitution should stand amended, that is Article 368. That is why they brought basic structure which was there in Sajjan Singh's case. Politically outside it was raised by Madhulimaye, and afterwards in I see Golakanath case also, when Attorney General, others, they were bringing about that to the notice of the court. He said the matter can be settled on other things. So basic structural theory was not invoked. In Keshavananda Bharati, they have invoked it. It is not clearly on the silences, my friends, or not the matter. But Justice Chalameshwar has pointed out that the basic structure of the Constitution cannot be abrogated, is the most outstanding and brilliant exposition of the dark matter and is a part of our Constitution. So the dark matters are parts of the Constitution. When it is the dark matter, for me it appears collegium is also a dark matter of the Constitution, and constitutional morality, now they are bringing out, is it a dark matter? The votaries of constitutional morality thought that constitutional silences are sought to be answered by conventions and culture in constitutional law. It is not by way of rather bringing in it as a doctrine and resolving the disputes like that. As a matter of conventions, why some matters may be more commonly left to the conventions, we know the reasons. Sir Ivor Jennings' book, A.V. Dicey's book, if you read the place of conventions, you can see. It is because of the difficulty in formulating textual propositions, or sometimes because the disputes seems to be unlikely, they are left as conventions. The Constitution is a framework for continuous political dialogue and negotiation. The amendments are brought for that purpose, not because of the things which you have noticed. The Constitution is an order of values, and the Constitution is a facilitator of an ever-evolving social order. However, in India, these constitutional silences are subsequently sought to be covered by the legislature, but always left to be filled by the judicial interpretation, my friends. And then I will give you one particular classification. Let us see. The concept of constitutional classification can be divided into three parts. The first one is deliberative role of the legislature. So the constitutional silences shall be supplemented by the deliberative role of the legislature, wherein judiciary should not interfere. Courts are not supposed to enter into it. The second is that second part. It relates to the value order. Moral dimensions of the Constitution requires that the judiciary, as a guardian of the constitutional values, you know what are the constitutional values? Or if time permits, I will discuss on that also. What are the instrumental values? What are the goal values of the Constitution? That is where the judiciary should interfere. The third one is administrative order conception, technical efficacy, key role of the executive in promoting the governmental agenda. That is another thing. These are the three things of constitutional silences. Problem arises when one wing tries to encroach into the other's provinces, either by judicial judgment, legislative judgment, or judicial legislations. Legislative judgment or judicial legislations. I think you remember that case. Indira Gandhi's case. Indira Gandhi or Rajnarayan's case. And administrative excesses constitutional morality as interpreted by the courts as jettisoned these three classifications. Thereby, what is happening is some constitutional irritants are started. That is why it has become a wide topic for discussion. Still, it did not percolate that much into the law schools. But the things are going on like that, my friends. Constitutions incorporate silences or deliberate gaps in order to permit time and experience to improve and complete their work. Everybody knows. If you see the comment, rather quotations of Pandit Jawaharlal Nehru or Ambedkar with reference to amending process of the Indian Constitution, you will know that they never wanted it to be a rigid one. They wanted to improve, to facilitate that certain silences, certain gaps, certain things are omitted deliberately. In fact, to condone and even cultivate constitutional ambiguity is also a strategy for resolving the conflict. If everything is made rigid, you cannot resolve the conflicts. So some flexibility was left out. It is true, my dear friends, that authoritative interpretation of the Constitution is a Sisyphean task for any branch of the government. Hans Georg Gadamer stated, the interpretation of any text alters according to the nature of the questions being asked. It varies. Different times and different circumstances. People, executive, legislature, judiciary, read the sources differently. And they do so because they are moved by different questions, prejudices, and interests. And they themselves may have the same. So, it is not a uniform interpretation by everybody. Two things you remember. Constitutional interpretation may be through dialectic of ideology and utopia. Ideological interpretation seeks to bridge the gulf between text and context, while utopian discourse requires subversively creative interpretation that accentuates ideals implicit in the text. This facilitates perpetuity of the constitutionalism and checks and balances within the various gaps of silences or loopholes that are left out. Constitutional text is thus improved through continuing reinterpretation by what one may call the reformative powers. Is it belonging only to judiciary is the question. On the part of the judges, in order to promote the legality, they try to confine the governmental bodies ostensibly to the bounds of their lawfully conferred powers. Ostensibly, but they are often critiqued for overreach while trying to fill these constitutional silences. After all, they say, who will control the guard? They are the guardians. Who will control the guard? In their overreach, in their over-enthusiasm, they are involved in political matters and political thicket. Now that is not a defense for anybody, ostensibly in the name of interpreting legality. Doctrines of non-justiciability, ripeness, standing, and refusal to determine moot questions are flouted. I have seen one of the topics on which I was talking to, I think ICFA University Tirupati branch. About pandemic, not to Chennai, I think. About pandemic. Initially, there was an element of delay. Subsequently, suo motu cases. Many questions did not reach Supreme Court, not that human rights are not violated. Every moment human rights were violated. But because of the situation, moot questions were tried. Exclusion of jurisdiction of the Supreme Court with reference to even cat was not accepted. L. Chandrakumar's case, you know that. And then, as I have told you, the political thicket as evolved in America in Baker versus Carr is no more valid. In the words of Israel's former Chief Justice, Aaron Barak, nothing now falls beyond the purview of judicial review. The world is filled with law. Anything and everything is justiciable. Super legality emerges because of this. My dear friends, the judiciary, as an interpreted, has effectively used constitutional morality to overcome the age-old laws which need to get reformulated or reformed with the changing times and evolution of the society. The court has applied different facets of this prerogative. Okay, I have told you, in the beginning of the Constitution, judiciary started interpretation as intention seekers, what the Constituent Assembly has stated. Except with regard to right to property, they did not cause much trouble. You take the cases of A.K. Gopalan to P.G. Rao, Brij Bhushan, Champakandurai Rajan, Ramesh Thapar, all these things are examples for that. After that period was over, Supreme Court slowly started Bela Banerjee and Vajravelu Mudaliyar's case, Balaji and Devadasan cases, and then ultimately reached climax in I.C. Gorakhnath and then ADM Jabalpur cases. The third one related to pragmatism, purposive, liberal interpretation in the cases of Keshavananda Bharati, Maneka Gandhi, and afterwards, and it is continuing even now. Whether you call it as golden triangle and all these things. Now, my friends, what is this? Till now, we have discussed several aspects relating to constitutional morality, without rather going into the conceptual framework of this particular one. The doctrine of constitutional morality in India is still in its nascent stage. In the recent times, as you know, the Supreme Court has invoked for striking down laws which could be termed as manifestation of popular morality. We are not bothered about popular morality. It is distinct from constitutional morality. The Constituent Assembly, if you see, there was only scattered and scanty references to constitutional morality. They did not refer to it, rather exposed it at a very length. It was only scattered here and there. Dr. Ambedkar referred to this in his speech of the draft constitution on 4th November 1948. At that time, he was defending the decision to include structure of administration in the constitution. At that time, he mentioned this. He quoted George Grote. According to George Grote, the diffusion of constitutional morality, not merely among the majority of community, but throughout the whole is the indispensable condition of government, yet once free and peaceful. Majority government is there. They cannot do whatever they want. They shall also seek minority. For that purpose, he said, even any powerful and obstinate minority may render the work of the free constitution impracticable without being strong enough to conquer ascendant for themselves. This was the quotation made by Grote. He also said, paramount reverence for the forms of the constitution, enforcing obedience to the authority, and acting under and within these forms of government, yet combined with the habit of open speech, of action, subject only to definite legal control and unrestrained yet censure of those very authorities as to all their public acts combined. That is the gist of it. That is the gist of forms of the constitution, forms of the government. So, it never stated it is for the obedience of the courts only. The purpose even for Grote's history of Greece was that to rescue Athens, to rescue Athenian democracy from its elitist critics like Plato and then Thucydides, all these people. He wanted to bring in commonality in their thinking. Ambedkar, drawing parallel to that, formulated understanding of the constitutional morality as an effective coordination between conflicting interests of different people and the administrative cooperation to solve those issues or conflicts amicably without indulging in any major confrontation or resorting to violent revolutions. That was the gist of it. Constitutional morality, according to Ambedkar, was the answer to the existing disparity in the society and the doctrine primarily translated to respect among stakeholders in the Republic of Constitutional Democracy as the accepted form of governance and administration. It is essentially implied a coexistence of freedom and self-imposed restraint. Now, my friends, his concern, Ambedkar's concern, arose out of his concern relating to democratic tradition in India, because he was of the opinion previously he has stated very clearly, top dressing on Indian soil, which is essentially undemocratic. So he was to bring in democratic traditions. And he lamented that our people have yet to learn constitutional morality. So he referred to that. He was using the expression constitutional morality, referring to the conventions and protocols that govern decision making, where the constitution vests discretionary power or where it is silent. It has not regarded it as an example of other things. Okay, now my friends, John Stuart Mill will take what happened to the other countries. He has used the expression positive political morality to prevent its different branches from exerting illegitimate power over one another. So clearly it is related to respecting the provinces of the division of power. And then A.V. Dicey has also stated about it, that in the absence of any written constitution, the constitutional morality implies established customs and conventions which supplemented of legal rules in regulating the exercise of political power and limiting the discretion of the government officials. For him, conventions are not really the laws. Okay, that much is sure. But if you remember Sir Ivor Jennings' words, conventions clothe the dry bones of the Constitution with flesh and blood and give them life. That was the observation made by Sir Ivor Jennings. Constitutional morality does not comprise of rules of law, but are of the customs or conventions of the Constitution, as stated by Frederick William Maitland. Matthew Flinders says that the constitutional morality is a glue of conscience or the accepted meta-constitutional orientation of polity. Moral constitution, according to the American understanding, emphasizes the fusion of moral philosophy and the constitution principles. Now you tell my friends, it can be taken to mean constitution that defines the fundamental political principles and establishes the powers and duties of each government, does so while being consistent with the moral code. That is the thing. The survey of the juristic opinion is that principles of constitutional morality are not for the promotion of interpretive intervention of the courts in the manner in which it is being interpreted now. It is not new thing. Only in few cases like Sabarimala, Joseph Shine are now this thing. Even prior to that, this expression was used. You must understand that Indian Constitution did not use the word constitutional morality. They did not define it anywhere. It is an open-ended meaning and left to the subjective interpretation, which is always dangerous. Which is always dangerous, my friends, if it is left to subjective interpretation in each case. Attorney General, when I was saying it can be interpreted differently, in Sabarimala case also, you can see how the judges have come to the same conclusion by different interpretations. Hindu Malhotra's dissent is another thing. She has used constitutional morality, pitting against societal morality. The Attorney General K.K. Venugopal described the interpretation by the courts about constitutional morality as a dangerous phenomenon to the country. He expressed that Supreme Court is slowly transforming itself into a third parliament chamber. He has used the expression slowly, but people say that it is not slowly, but speedily or swiftly. And it is more revolutionary than basic structure theory with reference to the Keshavananda Bharati's case or other things like Maneka Gandhi's case. During panel discussion in 2018, the Law Minister Ravi Shankar Prasad has also called for consistency in the application of constitutional differ from judge to judge. Chandana Reddy ji, I will take 5 or 6 minutes more, okay? The doctrine is that one should note that the doctrines that are evolved already are more than sufficient for this purpose. They did not bring in constitutional morality. They have brought in transformative constitutionalism from African soil, from an African scholar. Why they did not bring in living constitutionalism that is interpreted under American Constitution, we do not know. Transformative constitutionalism, okay, that can serve the purpose. But why did they refer to constitutional morality, the different doctrines that they have used? Even in doctrine of chilling effect that was used by Nariman in Shreya Singhal's case, that is also another angle, my friends. It is believed by the votaries of constitutional morality it is unfolding itself into a dangerous phenomenon. So a restraint or constraint should be used. I only quote few cases to complete my thing. Actually, it requires further discussion on constitutionalism and goals and values of the Constitution, but it appears time is up. I only tell you, there were isolated reference to constitutional morality till 2018. Till after 2018, series of cases. First, in Keshavananda Bharati's case, I think 2 judges have referred to, as a passing remark, constitutional morality. Justice Venkatramaya in SP Gupta versus Union of India has mentioned, but specifically, violation of constitutional conventions results in serious violation of constitutional morality. Patna High Court in Yugal Kishore Singh versus State of Bihar again referred to constitutional morality, but it has also referred to only as a matter of conventions for judicial wisdom. Delhi High Court in Nas Foundation in 2009 has referred to it. Popular morality as distinct from constitutional morality derived from constitutional values, it has stated, is based on shifting and subjecting notions of right or wrong. If there is any type of morality that can pass the test of compelling state interest, it must be constitutional morality, not public morality. Very clearly it has stated, my friends. And then you have in 2014 yet another principle, Manoj Narula versus Union of India. That is one case. I am not going into the details of this case again. Then Navtesh Singh Johar versus Union of India. These are all 2014. That case is over. Manoj Narula's case. And then Navtesh 2018. And then he started Justice Deepak Mishra. And then followed by D.Y. Chandrachud. In that case, talked about constitutional morality, testing it and evolving even fundamental rights. And then Joseph Shine versus Union of India, yet another case. And then government NCT versus Union of India, this is another case. Indian Young Lawyers Association State of Kerala, Sabarimala case, as I was discussing with you. These are the various cases, mainly D.Y. Chandrachud has articulated this one. In case Puttaswamy versus Union of India also, Chandrachud made a reference to it. That is in 2017, my friends. In Aadhaar case 2 also, constitutional morality is an essential component of rule of law, according to D.Y. Chandrachud. So these are the various aspects. I am leaving halfway through. A distinction between constitutional morality versus public morality is one aspect. And then we'll have to discuss about how constitutional morality as such involves constitutionalism, goals and values of the Constitution as reflected in the preamble of the Indian Constitution. That would take another 1 hour. Thank you very much for giving me this opportunity, Chandra Reddy ji, and then to our Professor Ishwar Bhatt, who has given me this opportunity. Wonderful. Thank you, Pratiksha. Thank you very much.
Thank you, sir.
Sir, thank you very much, sir.
Also, okay.
I will, right now I will request, because there are certain of the areas to be explored. From the research center, we also have a series of lectures, sir, in the area of constitutional law. I will be approaching you again with a request to address us in the form of a special lecture. You should be kind enough to accept that, sir. Thank you very much, sir. And please bless us with at least 10% of your energy. Your real,
Appreciative of you,
student,
sir.
sir. Thank you, sir.
Thank you everybody for your patient listening. Whatever I was shouting, you are listening. Thank you.
I also thank you, sir, for giving us your valuable presence, and I'm sure your words have definitely enlightened us today. As we are at the end of the session, I also thank all the dignitaries and participants for making this grand session and listening to everyone patiently. As of now, we are moving towards paper presentations for the day. I now call upon Pranali Ganachari, student KSLU's Law School, to carry out the presentation.
Pranali. Yeah, you may start, Pranali. Mike, you have to, you are muted. You have to switch on your mic.
Sorry, sir. Good afternoon, everyone. This is Pranali Ganachari, student KSLU's Law School. As we move ahead to our paper presentation, it gives me a great pleasure to introduce the chairperson for today, Professor Dr. C.S. Patil, Center Head, CRDCG, KSLU's Law School. I welcome you, sir. With this, I also welcome all the paper presenters for this session. Shall we let the session commence, sir?
Yes, start.
Without further ado, I now call upon the first paper presenter, Professor Dr. G.R. Jagdish, Principal, National Law College, Shivamogga, to present on the topic, Justiciability in Parliamentary Bypassing of Supreme Court Rulings. Over to you, sir.
Thank you.
Good afternoon, Professor Jagdish.
Thank you. Thank you. Good
So nice to
afternoon.
have you here. Yeah.
Am I audible?
Yes, sir.
Yes, sir. Fine. You know, listening to the great personalities from the morning regarding this very relationship between the organs of the government and what is that we could excavate. It is only the stock taking business that we will be doing here, and especially the decision that has been rendered by 2015. In fact, that has made me in ST Sadiq versus State of Kerala, where the Supreme Court has come out with that legislature has no power to directly annul the judgment of the court as it trenches upon the judicial power and is unconstitutional. But at the same time, the legislature may alter the very basis of the decision given by the court by making law retrospectively. So this is what the consent or whatever the court has other way paved the leeway for the legislature to make the law retrospectively operating, and they need not to go for the change in the law. For example, it happened with respect to the Pavitra case 2 in Karnataka. So instead of going for getting the signature from the governor or from the president, they would have amended the law to be made operative from the back date that never alter the basis of the decision they arrived at. So this is with respect to some of the decisions rendered by the Supreme Court that has denied the very opportunity for doing some social reform or social welfare for the people. In fact, if you could just go back with respect to this Champakam Dorai Rajan versus State of Madras, where we have come across with respect to this very provision for doing some justice or ameliorating the conditions of the backward class or SC, ST like that. When the Tamil Nadu government wanted to do some benefit for the suppressed class, that was not looked properly or by the judiciary, it was declared unconstitutional. Maybe that has made the people in the Union Parliament to think other way, to make a law so that we could help them. No, this has in fact made me to go through some other agrarian reform they wanted to do, or else some aspects related to the freedom of speech and expression like that. So these things require some change in the approach, even with respect to the trade and business. That's how the First Amendment came into existence. Even before the election to the first parliament, or even before the constituting of the parliament was in the pipeline. That is how the First Amendment made possible the change in the agrarian reforms, and to think in that way that we must have a separate clause where the judicial review power shall not be exercised at all. So the 9th schedule was carved in and it was incorporated into the constitution. And in fact, while delivering these things on the floor of the Lok Sabha, the then Prime Minister Jawaharlal Nehru has come out with this. I am a bit upset with incorporating this 18 land reform legislation into the 9th schedule. See, these things, when Parliament wanted to be the repository of the legislative power being elected by the citizens, they are reflecting the aspirations of the people and they want to do some social welfare or social reforms. Sometimes these have become, the decisions of the court has become an hurdle. So that's how they started doing these nullifying the effect of the decision by means of constitutional amendments. See, only the great hurdle that the Parliament has come across even today, what has been mentioned by the previous speakers, maybe the concept of basic structure that has been promulgated in Keshavananda Bharati case, or it may be the collegium that has been advocated in the post 1988 onwards. See, these are considered to be somewhat a limitation on the power of the Parliament, but still they want to do some changes. See, any constitution cannot be stagnant. Still water runs deep. In accordance with the changing needs of the society, even the supreme law of the land has to be amended. So social reforms is required, and that has made constitution to be changed, and parliamentarians did it. And in all these 70 years, and in the matter of 7 decades, more than 105 constitutional amendments have been carried out. And we could identify, in fact, one of the speakers, maybe that has been in the schedule mentioned, she is also concerned with the competition between the judiciary and the legislature and who is going to win there. This tussle or conflicting situation is always there between the judiciary and legislature, and especially even the judiciary and the executive also. What the minister has made a mention that Forest Department is continued to work as if under the Supreme Court, and Supreme Court is intervening too much in the matters of executive implementation, and these things annoyed both the executive and legislature, and we must have some structuralization with respect to the separation of power as advocated by Professor Ishwar Bhatt also. See, this giving of retrospective effect by the legislature. Recently, it is also with respect to this Airtel, Vodafone and Reliance Industries. When they were having such due to pay, see, that was declared unconstitutional, invalid by 2011 like that. See, this very amendments being carried out to the constitution, and that are to other ways circumventing the decision which have been hurdled to the implementation of social welfare measures, as well as this reformation the parliament wanted to do. But some of the circumstances, maybe what one of the speakers was mentioning about that farmers' agitation, where they could, the parliament itself could realize, are the members of the cabinet our Council of Ministers realize and repeal that legislation. So here, maybe we can go on quoting even the mentioning of constitutional morality or transformative constitutionalism. These are considered to be somewhat whether an hurdle for the parliamentary power to be exercised for the good of the community as such, that we have to analyze. Maybe in that sense, especially by post 2016 onwards, there is some liberal approach by the judiciary, especially with respect to this very privacy, information, and interpretation of the provisions is like that, which is bit encouraging, and we have to wait and see. And this very basic structure imposition is really limiting the power of the parliament, and slowly the parliament is also reasserting its power, especially in the area what have been empowered with through the constitutional provisions and many amendments being carried out. See, when the constitutional 42nd amendment was made during the regime of Indira Gandhi as Prime Minister, it was completely an overhauling of the constitution, and she tried to squeeze this very judicial review power of both the Supreme Court as well as High Court. And even the tribunals have been constituted having the power of reviewing the law. All these have been slowly dispensed by means of constitutional amendments only. And also this Chandrakumar case by 1997-98, like that. These tribunals have been again dispensed from the exercise of review power regarding the legislation. So this shows that this parliament is having such a power, even though this basic structure, collegium, or constitutional morality, or conformative constitutionalism, whatever these ideas being floated by the judiciary to discipline the legislature, but still the will of the legislature is nothing but the aspirations of the people. And wonderful they are doing. This 105 constitutional amendment is nothing but overcoming all these hurdles put before the parliament, I think. So in that context, this conflicting situation shall not be there, and we must have such type of constitutional council, what has been followed in France, to review the constitutional or the exercise of constituent power by the parliament. See, the law should be reviewed before being tabled on the floor of the house, whether they are in accordance with the constitution. If otherwise also are unconstitutional, we have come across in this Puttaswamy, Justice Puttaswamy's case like that. This very information leakage, or somebody is encroaching upon our information through data like that, that can be declared as void or unconstitutional. But maybe especially with respect to the execution of some of the program, what is with respect to executive, the judiciary is under the obligation to look into the infrastructural facility and the fund available, and is it possible by the executive to carry out the things in time. See, paucity of funds also to be taken into account. Time should be given. Then only these three chariots of the government can run that very chariot, and there can be somewhat doing together, and there will be really balancing of this power, and there can be mutual understanding in that context. As we are having, there cannot be any such type of concentration of power in one hand, and this very legislature, executive, judiciary is to perform the function in the respective arenas. I think this would be sufficient when compared to all the information being given to the audience, and maybe in that regard, this very executive should have some free hand, because they are the person concerned with the implementation. In terms of Carl Lowenstein, policy making is by the parliament or legislature. That has to be executed, policy implementation by the executive. If there is any such type of conflicting situation, policy controlling. This judiciary has to discipline on their own. What is their area? They should not intervene in the area of policy matters, especially in the fiscal policy, in financial matters. See, for example, in Balco case, the court has said we have nothing to do with that financial aspect or disinvestment policy. They have withdrawn from that range. So that range as such. So this shows that whenever they were not having expertise, they say it is none of our business, you take care like that. No, that should not be. They must be very vigilant in what area we can intervene, and we could also contribute for the good of the society or community. And in that regard, they should not be an hurdle for executive implementation or in the policy making business. So this is what I would like to place. I think this would be sufficient because many others may be on the same track and in the pipeline. And I thank Professor C.S. Patil for taking care of this organizing this great workshop or seminar, especially building this very relationship between the legislature, executive, and judiciary. Thank you, sir.
Thank you so much, sir. I now request Ms. Sunita.
Thank you very much. Really, you scared all of us with your summarizing in a very perfect manner. Thank you, Professor Jagdish.
Thank you. Thank you.
Thank you so much, sir. I now request Ms. Sunita, Assistant Professor, CMR University, Bangalore, to present a paper on the topic Judicial Outreach During Pandemic for Protection of Human Rights. Over to you, ma'am.
So good afternoon, sir, and good afternoon, everyone. And my topic for the presentation today is judicial overreach during pandemic and for the protection of human rights. And to introduce you to the topic, there has been a lot of arguments saying that the Supreme Courts and High Courts have been, intervening or stepping up, on the executive functions of the government. So this is due to the fact that the COVID itself was an emergency, and then the governments were not prepared. And nevertheless, there's an argument that, it dilutes the, sir?
We want you to adjust your camera so that we can see you.
Sir, can you see me now?
Half of you. No, other way. Yeah. Little more. That should be good.
Okay, sir.
Yeah.
So the argument, against judicial step up in times of COVID is that, it dilutes the basic structure, because the boundaries of each, branches of the different branches is clearly given in the Constitution. And when the Supreme Court is, protecting the human rights or the fundamental rights during the COVID situation, is seen as a overreach or a step up. So in this paper, I would like to basically see if, protecting human rights or fundamental rights, say for example, right to life, right to health itself is a step up or a overreach, into another branch, or is it a basic function of the courts, to step up and protect the fundamental rights or the human rights of the people. And also whether the courts have been consistent in protecting the fundamental rights, human rights, when they are trying to step up and protect the human rights of the citizens, and also see if there has been step up and in terms of protecting, are they really getting into sphere of other branches in protecting human rights or the fundamental rights given to us under the Constitution. And to start with the paper, I have a brief introduction which tells us, how each branches has its own role and responsibility to discharge. Like we all know, legislature has the function of policy making, executive executes it, and judiciary kind of validates these decisions made by the legislature and executed by the executive. And the only jurisdiction that the courts have is to see if these powers are transgressed by these legislature and the executive. And also the limitation on the part of court is the court is relying on the submissions of the advocate, and if the court has to suo motu examine these things, the court's decision would be selective and subjective. and it is unworkable for various reasons, like it does not have the scientific or the technical expertise or the administrative expertise to decide, taking up these things suo moto. So in this paper, I will basically examine some of the instances or the cases where the court has stepped up and it is validated, because it is the basic function of the court to protect the human rights or the fundamental rights, and instances where the court has not been consistent in protecting the human rights, and the instances where the cases where the court has does not have the expertise because of the technicality or the administrative nature of the circumstance, and the court still has stepped up to protect the human rights or the fundamental rights. And so this is about getting into the first section, where in the first section I have some of the cases or instances where the court has protected the fundamental rights. And one such instance is on equitable distribution of oxygens in the states. Several states were coming up to Supreme Court asking for oxygen supply, and the court appointed a task force committee to make sure that there is equitable distribution of oxygen to all the states. And so this is one one act of the Supreme Court which validates and protects the basic fundamental right or human right, to ensure that people are to ensure right to life or right to health. And the other thing is, the Supreme Court was considering a case law on penal interest on bank loans, because the economic activities were shut down during COVID times. The court was considering, the government was trying to postpone the payment of penal interest, but the court insisted that these penal interest would be exempted or exempted, and the directions were given in those lines. And this is another instance when the court is trying to protect the interest of the people. And the other thing is, the citizens were posting their concerns of lack of requirement of hospital beds and oxygens, and the police started filing a complaint saying that it is a wrong information that is posted by the people on social media. And the Supreme Court had to step in and say that people posting their requirements in social media for oxygens and hospitals per se will not amount to wrong information. And it is your basic right. Also you'll be denying freedom of speech and expression if you deny, if you prevent them from posting their concerns in social media. So Supreme Court had to step in and tell the police not to file any case against people who are posting their concerns in social media. And this is one instance where the court's action is validated in protecting the basic, fundamental rights. And the other thing is, these NGOs, because the many parents were killed in the COVID situation, there were NGOs were posting, adoption of these children in social media, and the Supreme Court had to step in order to protect the interest of the children and say that, that it has to be done under according to Juvenile Justice Act, and NGOs cannot be posting adoption of the children, and this was to protect the interest of the children. So these are some of the instances where the act of Supreme Court is validated in terms of protecting basic fundamental rights and human rights. But there are other instances where the court has not been inconsistent. For example, in case of migrant workers, because of the lockdown, the government was not able to address on the relief and rehabilitation of these migrant workers. And later point in time, when the government stepped in, it was too late, and the Supreme Court also did not decide on the payment of payment to migrant workers, saying that it's a policy issue which should be decided by the government. So see, there are instances when wherever it was a policy issue, the court has appointed a committee in order to look into the issue. But in this case, the Supreme Court withdrew itself and said that passed on the responsibility to the government, saying that it is it's a policy issue, it should be addressed by the government. So in this case, the court is inconsistent in protecting the basic fundamental right or human right. And the other thing is the court has not been, when different states were approaching the court for oxygen supply, the court was not consistent. It was, it was giving special privilege to some states and not to others. Like Delhi was given special privilege. I mean, they were allowed for supply of oxygen. And the fact that the court allowed supply of oxygen was, due to the fact that Delhi did not have oxygen manufacturing unit. Likewise, it was so in the case of Madhya Pradesh, but the court never made any such, gives any such privilege to Madhya Pradesh, whereas it was given to Delhi. So if you see, the court has not been consistent in protecting in these instances, the human rights or the fundamental rights during COVID times. And I have few more examples where the court has, really stepped up and ventured into the administrative and technical and scientific aspects where the court has no expertise and no means to implement these orders. And some of those examples are, the Madras High Court made a, remark saying that the Election Commission was solely responsible for spike in COVID cases, especially, and Election Commission approached the Supreme Court to set aside these remarks. And the Supreme Court cautioned Madras High Court saying that such remarks cannot be made because it is subject to misinterpretation. And also, these remarks could not be set aside because it was not in the written order. And the other example is, the court ordered for lockdown of Uttar Pradesh. And the government had to step in and say that it is the decision of the government and not the court to intervene in these matters. Especially lockdown is an decision, it is for the state to decide whether a state should go on a lockdown or not. And because the courts do not have that, expertise to decide on these things, the court actually stepped up to protect the human rights or fundamental rights. And the other case law is the court passed an order of ex gratia amount of 1 crore. The state actually announced 30 lakh rupees for people who were, working, who were on election duty during COVID times. And the state government had made an announcement of 30 lakhs, and the court actually increased the payment to 1 crore who were infected or affected due to their election duty during COVID times. And the court also, in one instance, fixed the hospital, private hospital charges for COVID. See, these are policy decisions which is for the government to decide, and the court actually stepped up to, in order to help or protect the fundamental, the basic human rights, to protect the fundamental rights or human rights for the people during COVID times. And there are other instances like, the state was held responsible for, for Kumbh Mela during COVID times and for not following the standard operating procedure. And the court also has given directions on black marketing on life-saving supplies to ensure that there was no black marketing for medical supplies. And the court also, in another instance, made an order for controlled opening of the city. See, the problem with this order again was, controlled opening for each of us is different. For a particular official, even a 10 could be, could be a super spreader, and for other person, 10 could be a, a controlled opening. So these decisions are a few examples where the court actually stepped up. And allocation of oxygen is another instance when the court, gave directions to central government to supply oxygen to few states, and other states had to approach, Supreme Court again, and it was very difficult for the government to function. See, these decisions are based on, it involves the administrative decisions and policy decisions, which is for the government to decide based on various factors. Because of the direction of the Supreme Court, it was very difficult for the government to decide on supply of allocation of oxygen to the states. And this is another instance when the court has stepped in. And there are instances when there's another instance where the court actually made a ruling on free testing of COVID testing. This again was challenged by private hospitals, and later the Supreme Court, later ordered that only weaker section will be given free testing. And the Supreme Court again asked central government to submit data on the purchase of all the vaccines. See, these are administrative decisions or which the government has to, but the Supreme Court has stepped in and then given directions on these issues. And also the Supreme Court actually gave directions on the increase on production of in the production of drugs and prevent wastage of drugs and things like that. And also the court gave directions to fix the MRP on medical equipment during COVID times. And also there are other instances where the court has given directions only to make sure that the fundamental rights or basic rights of the people are protected, or public interest or public health is protected. This is an immediate response on the part of the court. But then, like we all know, the court does not have the scientific or the administrative expertise to make decisions on these aspects. And there are few areas where the judiciary has very little scope for interference. And with a given, the circumstance or the case or the circumstance or the situation, the court can hardly come up with any innovative ideas, and also it hardly can implement these ideas, given the fact that the government had other things to do, and it was very difficult for the government also to implement these orders. So, but nevertheless, the courts have stepped in and helped the people, and in terms of supply of oxygen and management of the vaccination and other things. But then like I said, the courts do not have the administrative or the medical expertise to decide on certain issues. So therefore, there can hardly be any innovative solutions from the court. And so this is my submission on the paper, sir.
Yes, thank you.
Thank you so much, sir. Thank you so much.
Thank you, ma'am. I now request our next paper presenter, Dr. M. Jayashree, Assistant Professor, Department of Studies in Law, School of Law, Manasa Gangotri, Mysore, to present on the topic, Regulation of Executive Autocracy by Judiciary. Over to you, ma'am.
Thank you, everyone. Good afternoon. My paper is Regulation of Executive Autocracy by Judiciary. So what is the need of having the judicial regulation over the executive autocracy? Autocracy will come when there will be power conferred upon the executors, and executors are using discretionary power, as we know. But while exercising their discretionary power, executors, they are exercising their power ultra-viriously. So that is the thing where judicial regulation is needed. So judicial regulation, as I have gone through since the morning, that is, so judiciary is becoming, that is, overactive. So that is judicial activism, what we call. So when we hear this, that is judiciary, there is no way for the judiciary to interfere with the actions of either the legislatures or the executors. It has to sit. Whenever the case will come, then it has to decide. Then otherwise, it is not having any duty at all. But under the Constitution, there is in a democratic country, we are having three organs: legislature, judiciary, and executor. Judiciary, as we know, is the guardian, the part out of the Indian Constitution. So the judiciary is the body where it protects the rights of the individuals. So here, rights are conferred by that is the Parliament. So we, the people of India, having solemnly, that is the preamble of the Constitution. So okay, it is. Everything had been given in the preamble itself. So then why there is a violation of human rights by the executors themselves? So as we know, that is Parliament cannot sit 365 days into 24 hours in a year to make all the laws which are needed for the society. So society, that is, we are moving as a welfare society. So that is laissez-faire to welfare state, from cradle to grave. So that is, it is the duty of the government to take care of the individuals. So gone are the days where the legislatures or the executors were having only, that is, food, shelter, and clothes. They have to take care of the individuals. But nowadays, the individuals, They expect everything from that is the government itself. That is global village we call. So because the technology, scientifically and technically, we are so much developed that nothing is there in the hands of the individual. Every right has to be protected by the government itself. So that is the basic thing that we have to do. So that is why there is a failure on the part of the administrators or the executors. So they have to take care of the every need of the individuals. They are not taking care of. So that is, there is a need of having the judicial review of the executive autocracy. That is, they are exceeding their power. Somewhere they are exceeding their power. Somewhere they are not exercising their power. This is what's happening. So this should not happen. The power had been conferred on 3 organs equally. So that is equal protection of law. That is predominance of legal spirit. So this is what the rule of law says. That is Dicey's concept of rule of law. The law should rule, not the man. So that is law should rule, not the man means that is law, that is book law. It cannot govern by itself. The man who is sitting, he has to govern on the basis of that particular law. So this is what we have to tell. But what is happening? So many examples had been given during the corona situation. Who has to take care? Nobody knows what happens in the corona situation. Still, we are to have the preparation. If government is not having the preparation with regard to this, then who has to take care of? Where the people has to go? Can we, the people who have been elected through the people, by the people themselves, can the individuals, whenever their right has been violated, can they reach the representatives of the people? No, they cannot reach. So for that reason, what they will do? They will approach the judiciary. Judiciary is the organ where that is handy and the people can approach at any time. So that is the thing. So one side there is a violation of the individual's rights and another side the government has to take care of everything. So these are the things what is happening. So because this, there is a concept that the doctrine of separation of powers. So, okay, the doctrine of separation of powers is there. The legislature should not act the powers of the executors, and executors should not do the powers of the legislatures, and judiciary should not interfere with the legislative and executive powers. Okay, they cannot interfere. So they should not interfere. Many cases we have seen. So that is where judiciary has interfered, and judiciary had given the guidelines and directions, and so motor cases are there. Many cases since the time of the Keshavananda Bharti case. So that is, it has been decided in the year 1973. So the basic, what is basic structure of the constitution that has to be told by the Supreme Court to the executors and the legislatures. So what the executors are doing, the legislatures, they are delegating some powers to the executors. Within that power, only the skeleton they will give. With that power, the executors has to fill the blood and flesh. So whenever the immediate action they have to take according to their discretionary power. So for everything, for example, if there is a flood, if there is an earthquake, if there is a coronavirus, after some 10 years, some other virus will go. All of a sudden, something will happen in the society. So who has to take care? Executors has to take care. How they have to take care of all these? These guidelines will not be there. So the parliament is not defining all these things. So in the Daily Laws Act, so the essential legislative functions. So this is the duty of the parliament, that to define and bifurcate what are essential legislative functions and what are non-essential legislative functions. So executors has to do only the non-essential legislative functions, and the parliament has to do the essential legislative functions. So why the parliament has not done this? Why they have given a room for the judiciary to define what is legislative function and what is non-legislative function? So in many cases, the compensation had been announced by the Supreme Court. Why the parliament left the room for the judiciary to make such a decision, that is to give the compensation? Rudol Shah versus State of Bihar, Chandrima Das versus Eastern Railway Board, where rape victim, until the case will be decided, she will be given the compensation. So that is Bhim Singh versus State of J&K. So that is also a compensation case. Why there is a room made for the judiciary to give the decisions? This is what judicial review. So what we are calling. So when government fails, when administrators fails while acting their actions, so while making rules, regulations, orders, bylaws, when they will fail, then the judiciary will interfere with all this. Why? That is Environmental Pollution Act and environmental issues. MC Mehta case, many cases are there. Sunil Batra, 2 cases are there. So that is inhuman treatment within the prison. So inhuman treatment, that is by the executors, that is the administrators. Why they are doing the inhuman treatment? They don't know whether they have to do the inhuman treatment or not. They know that. So then also they want somebody else to tell these are the inhuman treatment. You should not do this. So this is what judicial review. So this is what all of us wanted to, that is the judicial activism we are telling, and judiciary should not interfere with all these things. And MC Mehta's case, what he is doing that is the pollution control. That's it. The Ganga river has been polluted like anything. Don't we have awareness? Our government is not having any duty, or the parliament is not having any duty to make a legislation. So they are kept quiet. So they kept quiet, judiciary has interfered. So these are all the things where that is livelihood. Article 21, numerous cases had been made. That is the judicial review. Under the judicial review only, under the judicial decisions only, so many cases under Article 21. Everything. That is, no person's life and liberty will be deprived except the procedure established by law. This is the only thing that is Article 21 is having. And other things somewhere they have come right to livelihood. That is for the payment, that is the footpath hawkers. So right to livelihood is the basic thing. The government or the parliament didn't know this, they know that. Then also, all of a sudden, that is footpath, the persons who are making food there, they have been shifted. So they went to the court. So where they have to go? Administrators only have done this. So parliament of courts. So they went to the court. So that is why the court held that is the livelihood includes under Article 21. Many things, that is right to legal aid, right to medical aid, without any inquiries. So that is every right has been right to unpolluted water, air, everything has been included under the Article 21 itself. After including all this by the judicial decisions, even today we are not having any legislation with regard to this. Are they are not fundamental rights? They are fundamental rights. They are basic rights. They are human rights. Then also we are not having any legislation. So we call this is judiciary is having, judiciary is overactive, judicial activism. So everything is okay. So why we are making a gap in between the judiciary and the other organs? Why we are making the judiciary we are making the judiciary into force, putting into force that to interfere with all these things. So this is what the judicial regulation of executive autocracy. So that is Maneka Gandhi's case. So without Maneka Gandhi's case, the executive autocracy will not go. So that is Maneka Gandhi's case, which has been decided in 1978. So the court has held that there is a violation of principles of natural justice, that is audio alteram quotum. So that is post-haste decision. So post-haste decision means that is a decisional hearing. So after decision has been made, there should be some hearing. So even by knowing that the executors have violated that is rule of fair hearing. So what it means, judiciary has to interfere. So that is rule against bias, AK type of case. So rule against bias means what? No one should sit as a judge on his own cause. So he should not sit. So being a member of that committee, he should not sit as in the selection committee. So but he was there. So when his name has come, he went outside. Then also there is
You may please conclude. Okay.
Okay, sir. Okay, thank you, sir. See, my conclusion is that judicial regulation for executive autocracy is very much essential. That executors, they are doing their acts under the delegated legislation. So because they are not having any bindingness, that is, it has been codified. So for that reason, judicial review of executive autocracy is very much needed. Thank you, sir.
Thank you. Thank you very much.
Thank you, ma'am. I now request Mr. Pramat Adiga, lecturer, MES Law College, Sirsi, to present on the topic, Judicial Adventurism, a Necessity or Exaggeration. Over to you, sir.
Am I audible?
Yes.
Namaskara, sir.
Namaskara, namaskara. Nice.
So, the topic which I have written is judicial adventurism, a necessity or exaggeration. And I don't want to go deep into it. And first of all, I come to what is judicial activism. So when we talk about judicial activism, it means that when legislature is inactive or executive is excessive or arbitrary in nature, the judiciary is required to take up its role and try to make them learn what they need to do in time. So usually when judiciary acts in a judicial activism manner, it tries to make them understand that you have failed to act as per the spirit of the constitution or the spirit of the statute. So thereby it makes them understand that your inability to act in time has been causing us a problem. Otherwise they would not have brought this problem to our notice. That is why we call it as a judicial activism. I give one instance. So before Maneka Gandhi case, we thought that personal liberty was just confined to the physical liberty. When the court had tried to expand the scope of the physical liberty to other part of the liberty, automatically we have understood that Article 21 cannot be confined merely to the physical liberty. It could also be extended to other types of liberty. And thereby the court has made them aware that if you try to make any legislation or if you try to act in excess of what has been permitted under the law, we have every option to regard your action as questionable under the constitutional provision or in a given statute. And if I take the example of right to life, here also we find that right to life is not just confined to the animal existence. So as a consequence of broader perspective of right to life, automatically we are in a position to extend the scope of the right to life even to environment, human right, and different parts of aspect that we find in our day-to-day life. So that is the appreciable thing of the court as far as the judicial activism is concerned. And when it becomes judicial adventurism, so here what happens when judiciary tries to cross this limit, even though it finds that legislature is well within his jurisdiction, it tries to encroach upon the area without giving a direction or without giving any type of guidelines that you need to act in this situation. So it itself tries to make out a legislation of its own. So here what we find, judicial adventurism, and thereby it tries to undermine the authority of the legislature or executive. Why should it try to undermine the authority of the legislature or executive? So when it knows that if someone tries to affect its independence, it definitely tries to harp upon them that you should not cross the limit. So as in the case of National Judicial Appointment Commission. So it has pointed out that it is not possible and it affects the independency. Therefore, we considered it as unconstitutional. Though this act has been passed in a proper manner by the parliament, why should it try to consider it as unconstitutional? So when someone tries to affect its independence, it tries to take up the cudgel against them that you are going to affect the independency. So here we find judicial adventurism. And what are the the positive effects of the judicial activism? The first one is it nips the practice of ultra virus to the women. So for instance, in Shaira Banu case, what had happened, the court has declared triple talaq in the form of talaq ul bidat as unconstitutional, and other talaq it didn't consider it as unconstitutional. So what we find here is that it has tried to point out what is not permissible under the constitutional morality. This is one aspect we should appreciate the court from the positive angle. And then another with this curb corrupt elements. I take up the Sachdev Dubey case because he was murdered because he had tried to give an information to the concerned authority that this type of practice being this type of activities being carried on in the petrol transfer and distribution. and he was not protected. So in that situation, the court had tried to lay down the guidance, and thereby the act was brought in the form of Whistleblowing Prevention Act or Protection Act. So what it indicates, presently in Karnataka, PCB is acting on different officers whenever it gets an information from the required source that someone is involving in the corrupt activities. So what it shows is that this type of decision has helped us to find out the corrupt element existing in the administrative setup, and then show prowess to reform religious belief. So in Shabarimala case, every woman knows that they are not required to go to a sanctorium places during a particular period. If they try to ban the woman from entering the temple from the age of 10 to 50 years, it means that the other authority or the customary authorities are so in a position to determine what women should do. Here, the court had tried to give its order in such a way that you should not pass the type of customary restrictions on women merely on the basis of they are undergoing some physical inconvenience during a particular period. So this is also appreciable one. And the another one aspect wherein we find the constitutional moralities upholdation of the Naj Foundation's case, that means homosexual, that means consensual homosexuality, and even in case of euthanasia, it has given permission only in case of vegetative state and in consensual homosexuality. Nowadays, we are talking about hijab, and someone is talking that the Karnataka High Court has given a decision neglecting the constitutional morality. But as Professor Subbarao has rightly pointed out, what we need to study is the scope of the constitutional morality. But he has compared it to the public morality. But now what they are saying is it is affecting the private morality or individual morality. So that means they are taking the constitutional morality into a different direction as the individual morality. That should not be allowed. The court must be guarded while taking that type of contention even before the Supreme Court. And the negative side of judicial advertisement. So the first one is lack of general will of the people. As we all know that the judiciary is not accountable as that of the legislature or executive, and they are not elected. So when they are not elected, they are not in a position to understand the problem being faced by the people. When it passes such an order, it will put the government and the people in inconvenience. So for instance, it has banned selling of liquor from any hotels or restaurant near 500 feet around highways. So the majority of the hotels and restaurants are run because they earn maximum source from the selling or distribution of the liquor. Once it is stopped, automatically what happens? It will affect the working class working in that restaurant. That means instead of passing such an order, it should have tried to pass or give a direction to the government in such a way that they could involve such a measure so that the interest of the working class should not get affected. So it happens mainly because of the reason that it is not in a position to understand the problem being faced by the people. As a consequence of order, it passes merely considering the societal interest. So it should also take into account the individual interest. The another thing is non-proficiency at the field work. The most of the time what happens, the judges who are in the bench, they are not aware about the technical problems that may arise as a consequence of passing of order. For instance, 2G case, what had happened? It had found 122 telecom operators license as flawed one and another 8 spectrum is as flawed one, and it had ordered to cancel all those licenses. The consequence is that they could not run their operation as a result of giving up that decision. So that they are not in a position to get the loan from the government. So what happened? The very industry which is in the budding stage has got affected as a consequence of passing this type of order. And then the practical difficulties in implementation. So here, what happens when it tries to pass some of the order, so it cannot be implemented in a proper manner. In case of Narayan Chokshi case, what had happened? It had ordered to play national anthem in every cinema hall. So what will be the emergent situation when they are singing national anthem, and it had ordered to close the door at the time of singing of the national anthem. But in the Upahar tragedy case, what had happened? It should keep the doors of the cinema hall open. So here it is contradictory in nature. And in Bijoy Emanuel's case, what it had, there is no such legal restriction that everyone should sing national anthem. So this is contradictory in nature. So there we find such type of judicial adventurism. And then the undermining the authority of other authorities existing in different branches of the government. The first is in Jolly LLB case, what happened was it had tried to cut down forcings of the film. So it truly knows that the Cinematographic Act, it was the censor board which had the power to use it and delete those scenes. It had specifically directed the censor board to delete four scenes. So what we find here is that the judiciary had tried to take the role of the authority which is required to perform its jurisdiction. So then the matter is overreaching itself in the area of others. So as you know, the committee was constituted in a PCI magistrate. So what happened when it had constituted the committee, he had given direction in that behalf. So when he had given a direction, he should have examined the fact that the very PCI was constituted under Tamil Nadu Societies Act. Instead of developing that matter, it had tried to take up that matter simply on the basis of protecting the interest of the cricket and the corruptions being carried on in the name of organization of IPL and other things. So it should not neglect the specific law under which a particular authority is functioning. And then the impact of judicial adventurism. So what type of impact that we are finding as a consequence of judicial adventurism? One is it increases the workload of the judiciary. So when judiciary tries to take every matter into its consideration, already it is overburdened, and it takes all these three matters into consideration in the name of protection of the social interest, increases the burden, and we are not sure that we are going to have the decision very soon. And then it gives scope for tyranny anarchism. It talks about the tyranny of the legislature or executive. When someone begins to talk about its own tyranny, then it gets hurt. So that should not happen, especially in case of a judicial adventure. Whether it was lethargy and inactiveness in discharge of the function entrusted to the legislature and executive. And most of the time, what happens when every matter is being resolved by the judiciary, they think that why should we make a legislation, let the judiciary say whatever it wants. Ultimately, it is the determiner, and everyone take up the matter before the judiciary. So thereby, it also creates a lethargic attitude in the minds of the legislature and the administrator. And then it is chaos in enforcement of the provision of the constitution of or statute. So most of the time what happens when it begins to give such an interpretation which cannot be implemented in the right sense, when we try to examine the scope of right to life or personal liberty or right to equality, and we just try to implement because it uses the contempt power holded by it. So that is the problem we face it, and it goes against the spirit of the constitution or the statute. When it tries to take up the role of the legislature or the executive, it is nothing but taking up something which belongs to someone else. Is it not a violative of the spirit of the constitution or the statute? And then it makes the judiciary to act as a legislature even in the absence of mandate of the people, as it should be aware that it is not accountable as in the case of the legislature or administrator. So when it tries to take up that matter to its consideration, then what happens? Someone who is not accountable is taken up the matter and resolving the matter, and then it entrusts a task to the authority which does not possess practical wisdom to understand the needs of the different sections of the society. So why should it take all the matters to its consideration? It should have guided them to take up the matter to the proper authority, as it has laid down in some of the cases that when there is an alternative remedy, you should seek it before the authority where it is required to be sought. So it itself has narrated in some of the cases, and it should follow the same even in its own case. And how should we curb this judicial adventism? The first thing is compel authorities to act and to pass appropriate executive order, but not issue administrative nature and administrative order. So most of the time what we find here is whatever order it passes, they are administrative in nature. It should not pass such type of administrative order. Then direct the authorities to discharge their duties properly. So instead of laying down its own guidelines or something else, it should make them to act properly. And the second one is command the authorities to follow its direction. Most of the time they try to foo-foo the order being passed by the court, especially when they find that it has crossed the limits, and they somehow manage by taking some other cases against it, and then not to create right where none exist. So when there is no such right, why should it create such right? And it is not going against the principles of the Constitution. And then not to make an order which is incapable of enforcement. Most of the orders being passed in nowadays are not at all enforceable. So when it is not enforceable, why should it pass it? It degrades the position of the judiciary. So why should it pass such orders? And then not to pass any order or direction that violates other laws and agreements. So most, as I was said, in case of Jolly Mukherjee case, it has tried to undermine the Cinematographic Act. So why should it pass such type of order which goes against the specific provision given in the Act? So these are all the flaws that we find in the judicial adventurism. So ultimately, what I want to say is that everyone should act within their constitutional structure. If someone tries to cross it, automatically it affects the other organ. So that's what I would like to say. I hope I have justified it.
Good. Thank you very much.
Thank you so much, sir. I now call upon Ms. Akhila Yogesh Prabhu, Research Assistant, CRDCG, KSLU Hubballi, to present on the topic, Contest for Supremacy between the Parliament and the Judiciary, with special reference to constitutional amendments. Over to you, ma'am.
Thank you, Pranali. Good afternoon, sir. Good afternoon, everyone. My topic for presentation is Contest for Supremacy between the Parliament and the Judiciary, with special reference to constitutional amendments. After independence, India has adopted parliamentary form of government, which consists of three important organs: legislature, the executive, and the judiciary. In England, parliament is sovereign, and in United States of America, judiciary is supreme. But in India, no organ is given supremacy, and they have to function on the basis of principle of separation of powers and mutual check and balances. The Constitution lays down the structure and defines the limits and demarcates the role and function of the Parliament and the judiciary and establishes the norms for check and balances. But in India, supremacy over each other between the Parliament and the judiciary is never-ending debate. The Supreme Court on one hand can declare the parliamentary legislation as unconstitutional or ultra vires through its power of judicial review. On the other hand, the Parliament can amend the Constitution through its constituent power. Need for amending the Constitution arose several times because of the changing needs of the society or as a result of judicial pronouncement. So whenever a situation arose to amend the Constitution to override the effect of judicial decisions, world has witnessed the tug-of-war between the Parliament and the judiciary regarding their supremacy over each other. The most serious disagreements between the Parliament and the judiciary is regarding amending power of the Parliament and judicial review of such amendments. Since from the first amendment to the Constitution till the very recent amendment, we have seen the tussle between the Parliament and the judiciary. Here I am discussing some of such contests between the Parliament and the judiciary for supremacy. After Constitution came into force in 1950, land reform laws were enacted by some states, and some actions of the executive were challenged in the court of law. Courts invalidated enacted land reform laws and had given decision against the executive actions. So altogether, annoyed by the unfavorable judgments, Parliament wanted to make changes in the Constitution so that they can implement their policies. Thus, the first Constitutional Amendment Act 1951 was enacted. The first amendment, in the first amendment, Parliament added the 9th schedule to the Constitution as a means of immunizing certain laws against judicial review. The first amendment and also the 4th amendment to the Constitution placed land reform laws in the 9th schedule of the Constitution, thereby effectively removing them from the scope of judicial review. The first and 4th amendment was challenged in the Supreme Court in the case of Shankari Prasad Singh versus Union of India and then Sajjan Singh versus State of Rajasthan, on the ground of curtailing the right to property guaranteed by Article 31 and violation of Article 13, Clause 2 of the Constitution. The Supreme Court, by adopting literal interpretation of the Constitution, upheld the validity of the First Amendment. The court rejected the contention and limited the scope of Article 13 by ruling that the word law in Article 13 would not include constitution amending law passed under Article 368. Regarding First and 4th Amendment, the relationship between the Parliament and the judiciary was harmonious and cooperative. After 16 years from the First Amendment, again, the question arose in LC Golaknath versus State of Punjab in 1967 that whether under Article 368, the fundamental rights could be abridged or taken away by the Parliament in exercise of the constituent power. The majority held that the fundamental rights were non-amendable through the constitutional amending procedure set out in Article 368, and Parliament could not amend any fundamental rights. Therefore, the Golaknath's judgment established judicial supremacy on the constituent power of the Parliament, and it started the Cold War between the Parliament and the Supreme Court regarding their jurisdiction. The result of Golaknath's judgment was that Parliament was considered to have no power to take away or curtail any of the fundamental rights, even if it becomes necessary to do so for giving effect to directive principles of the state policy and for the attainment of the objectives set out in the preamble of the Constitution. Thus, the Parliament enacted 24th Constitution Amendment Act. The main object behind 24th Amendment Act was to nullify the Golaknath's decision and to restore the Parliament the power of amending any provision of the Constitution. Within a few weeks from the enactment of 24th Amendment, the Parliament passed Constitution 25th Amendment Act to remove the difficulties created by the Supreme Court in bank nationalization case. The 25th Amendment Act added Article 31C, which provided that laws passed for giving effect to the directive principles specified in Article 39 Clause B and C cannot be challenged on the ground that it is inconsistent with the rights guaranteed in Article 14, 19, and 31 of the Constitution. With the introduction of this article, the Parliament had attempted to take first step to claim complete sovereignty, almost similar to the sovereignty of British Parliament. Then the Parliament enacted 29th Amendment Act. The main reason for 29th Amendment to the Constitution was that agrarian reforms laws which were enacted in the state of Kerala. 29th Amendment included the Kerala Land Reform Act in the 9th schedule to the Constitution so that they can have the protection under Article 31B. All these amendments led to the evolution of new constitutional principle, that is basic structure doctrine. The 24th, 25th, and 29th amendments altered the relationship between the Parliament and the judiciary within the constitutional framework. The amendments were challenged in Keshavanand Bharati versus State of Kerala. The main contention was that the power of the Parliament to amend the Constitution under Article 368 was of limited power, limited nature. This is a historic decision because through their basic structure principle, the Supreme Court changed the course of constitutional history by denying the assertion of supremacy of the Parliament in matters of amending the Constitution. The amending power was now subject to one very significant qualification, that is, the amending power cannot be exercised in such a manner as to destroy the basic feature of the Constitution. After Keshavananda's case in Indira Nehru Gandhi versus Raj Naren, Supreme Court again applied the ruling regarding the non-amendability of basic feature of the constitution. Indira Gandhi's government was not happy with the Supreme Court decision in Indira Gandhi Nehru case, declaring clause 4 of the 39th amendment as invalid. Because of this, the government desired that the court should not have the power to pronounce a constitutional amendment invalid in future. Therefore, Article 368 was amended by 42nd Amendment 1976. A justification in favor of an amendment was that the supremacy of the parliament must be asserted in the area of constitutional amendment, and that a constitutional amendment should be taken out judicial purview. Thus, the 42nd Amendment sought to ensure that a constitutional amendment may not be challenged before any court on any ground whatsoever. The 42nd Amendment to the Constitution by the Parliament is for imposing parliamentary sovereignty, but 42nd Amendment was challenged in Supreme Court in Minerva Mills Limited versus Union of India. In this case, the court again said that under Article 368, Parliament cannot amend Constitution as to damage the basic or essential features of the Constitution and destroy its basic structure. Presently, the position regarding constituent power of the Parliament and judicial review power of the Supreme Court is that Parliament has constituent power to amend the Constitution following the process under Article 368. The Parliament can amend any part of the Constitution, including fundamental rights, but it cannot amend the basic structure of the Constitution. The laws placed in 9th schedule after Keshavan and Bharati's case are subject to judicial review if they violate the fundamental rights forming part of basic feature of the Constitution. To conclude, in India, the Constitution is supreme law of the land. The three organs of the government get power from the Constitution, and their powers are limited by the Constitution. No organ is supreme than the Constitution, neither the Parliament nor the Supreme Court. Since from the first amendment to the Constitution, we have witnessed both organs wants to claim their supremacy over each other. But I feel instead of that, Parliament and Supreme Court should act within the specific space determined by the Constitution and should not interfere with each other's jurisdiction for maintaining the constitutional balance between the three organs of the government. So it is essential that the delicate balance between three pillars of democracy should be maintained for the proper functioning of the India's vibrant democracy and good governance. Thank you, sir.
Good. Thank you. Yeah, Pranali.
Thank you so much, ma'am. I now request our next paper presenter, Mr. K.S. Jaikumar, Assistant Professor of Law, P.S. Law College, Mandya, and Research Scholar, DOS in Law, University of Mysore, and Professor Dr. C. Basavaraju, Research Superintendent, Professor of Law, University of Mysore, to present on the topic, the Anti-Defection Law in India and Appraisal. Over to you, sir.
Thank you, madam. Can I audible, madam?
Yeah, you are audible, but you have to switch on your video.
Sir, namaste, sir.
Namaste, namaste. Start your video.
Yeah, okay, sir. Thank you.
Yes.
Good evening, one and all. The respected in this session chairperson, C.S. Patil, sir, and all eminent professors. My topic is the anti-defection law in India and appraisal. So one quote says that anti-defection law is a valid only till deterring the members leaving party. The forcibly added by whip provision kills a originally voice and opinion by the people representative. The quote says that is called as Nikhil Bhandari. So my topic is a main important of the five important component. One is background. What are the important of the background enacted by the anti-defection law in the 10th schedule of the amendment 52nd Amendment Act 1985. And second important part is what are the provision of the 10th schedule of the Indian Constitution. And the third important component is parliamentary privileges and anti-defection law. How can be related to the parliamentary privileges, Article 105 and 194 of the Indian Constitution. And the fourth important component is what is
You
the
can
main role of the presiding officer
switch off
in the
your video.
context of, sir?
You can switch off your video because you are somewhere, it seems. Yeah, continue.
Yeah, okay, sir. So the fourth important component is role of presiding officers in the context of the anti-defection law, and the last important component is judicial commitment. So first discussion for what is the main important component of the 10th schedule of the anti-defection law related to the 52nd Amendment Act 1985. Okay. So initially, the Constitution of India did not have any mention about the political party, and also the main important of the practice elected member switching the political side to get a office, also known as a horse trading. It is also known as a floral crossing in United Kingdom and carpet crossing in Nigeria. The person who does such act have been elected from the one party and enjoy the benefit from the other party, known as defector or fence sister or turncoats. There was uncontrolled horse trading, corruption being the privilege in the political party. So in order to retain such a practice in the Rajiv Gandhi government in 1985, introduced by the anti-defection law in Constitution. It was introduced by the 52nd by the amendment of the Constitution, which is started in the 10th schedule in the Constitution, known as anti-defection law. Okay. The second important component is background. How can be established by the anti-defection law in the 10th schedule of the Indian Constitution? So the first attempt analyzed by the Maladi Committee in December 1967, when the Lok Sabha appointed by the high-level committee to look into the problem and to make in the recommendation, the committee was constituted by the chairperson of the Union Minister Sri Y.B. Chavan and legal and political luminaries such as M.C. Setalwad, Jaiprakash Narayan, H.N. Kanzur, M. Kumarmangalam, and Madhul M. and others. So these are the committee constituted by the chairperson of the Y.B. Chavan. The committee mainly recommended by the four important of the component. One is political party should be arrive a code of conduct among the himself. Second one is in the case of the defection for the ideological reason, defector should be disqualified from the continuing the legislature, but allowed to the stand again. And third important recommendation of the committee is in case of defection due to the office or pecuniary gains of the defector should not only disqualified from the office, but also prevented from the specified period. And also important component of the provision of the anti-defection law, it's a deals within the parliamentary the provision of the 10th schedule. What are the important of the provision related to the anti-defection law? So the main important of the provision of the 10th schedule, 52nd amendment of the Constitution, a member of House is a disqualified the membership is a voluntarily give up into votes or a voting contrary direction given by the party. Second one is this qualification shall not apply in the case of split 1/3 of or more than the members of the party defect. And third important provision is the speaker, deputy speaker or deputy chairman are allowed to give one of their membership after being elected by the office. And fourth important provision is the speaker or chairman is the person to decide a question in the qualified or disqualified. And another important component of the third provision, the jurisdiction of the court regarding the disqualification of any member has been barred. There is a third important component. And fourth important component of my topic, parliamentary privileges and anti-defection law. So what are the important provisions related to the anti-defection law in the parliamentary privileges? Article 105 and 194 of the Constitution. So the freedom of speech of the member is not an absolute freedom guaranteed by the Constitution of the India. Secondly, the parliamentary privileges, which is guaranteed under the Article 105 of the Indian Constitution, are not violated as a provision of the 10th schedule, do not have the rise. Any proceeding, any court is a safeguard by the immunity. So these are the main brief of provisions of the parliamentary privileges and also 10th schedule of the anti-defection law. Next, what are the main role of the presiding officer in the context of the anti-defection law? There are the fourth important of the component in my topic. The 10th schedule provides a presiding officers of the legislature is the power to decide cases of the defection. That's a first provision. However, as been noted that a speaker is dependent upon the continuous support of the majority in the houses. And third important aspect in the role of the speaker, several expert committees and commission, including by the Dinesh Goswami Committee, 1998 constituted, Commission to the Review of the Constitution, 2002, and the Law Commission, 2015, have therefore recommended by the defection cases decided by the President or the Governor of the state in state or central is respectively. And deciding the question related to the disqualification of legislature on the grounds such holding of the profit or being the unsound mind under the Constitution. And the last important component is judicial commitment. So a number of cases in the related to the 52nd of the amendment of the Indian Constitution, briefly discuss on two important of the case laws. One is that is called as a Ravi Nayak versus Union of India, 1994, Supreme Court 155A. So in this case, the Supreme Court clearly interprets says that voluntarily give off is a membership. It's stated by voluntarily given of the membership are not synonymous with resignation. This clearly says that Ravi Nayak versus Union of India. And another important of the case related to the 10th schedule of the Indian Constitution, Rajesh Verma versus Sri Muhammad Shahid Akil BSP. The court is held that speech by the member in a public meeting that belong to the another party by earth with would amount to voluntarily giving up member of the former party. And last one, some important of the suggestion to related to the 52nd amendment of the Constitution. The first suggestion is Election Commission as a suggested it should be deciding authority in the defection cases. Second important is the law must be explicit, set out the means by word, voluntarily give up membership in order to avoid any confusion. And third important suggestion is the Supreme Court has suggested that Parliament that is set up in the independent tribunal headed by the retired judge of the higher judiciary to decide defection of the cases simply and impartiality. So these are the main important of the suggestion related to the 52nd amendment of the anti-defection law. And the last my concluded part, anti-defection law in India is a very important step against to the opportunity, political action, and the tendency of the horse trading. But as per the right to represent, a constituency is concerned that legislator should be given more freedom to the express there is a views and view vote. In case of legislator, is a deciding, is a voter or disabling the government, you should be punished more severely. Thank you, sir. I given my opportunity in the today is a paper presentation. Once again, sir. Thank you, sir. Thank you, sir.
All the best.
Okay, sir. Thank you, sir. Thank you.
Thank you, sir. I now request Mr. Sadashivappa MS, Assistant Professor of Law, Vivekanand College of Law, Bangalore, and Dr. MS Bijamin, Associate Professor, Department of Studies and Research in Law, University of Mysore, to present on regulation of executive autocracy by judiciary. Over to you, sir.
Good afternoon to all and respected chairperson of this program. This paper is jointly prepared by me and my research guide, that is regulation of executive autocracy by judiciary. Today, the role of government has changed. The expectation from the government is not only protect its people from the external aggression and internal disturbance, but also to take care of its citizens from the cradle to the grave. When India became independent, the philosophy of welfare state was made the creed of the Indian Constitution. The rule of law is the supreme manifestation of human civilizations and also culture. It is an external value of constitutionalism and an inherent attribute of democracy and good governance. All organs of the state could be created and exercise powers only in accordance with the Constitution and not otherwise. The whole of judicial review of administrative actions has been developed by judges on case-to-case basis. It may take the following ways. In case of legislative review, the court reviews the constitutionality of a law passed by the legislature or rules framed by the administrative authority. Or in case of judicial review, the court reviews the decisions of the courts, lower courts, and its own decision also. In case of constitutional review, the courts reviews the constitutionality of constitutional amendments. And in case of administrative action, in this case, the court reviews the constitutionality of administrative action and also examines its fairness, reasonableness, and justness. In a democratic society, the primary control on government is by the people. But experiences has proved that the weakness of this control, especially where majority of the people are disempowered, hence auxiliary control becomes imperative, and this auxiliary control is the judiciary with the power of judicial review. It is based on general principles of rule of law, separation of powers, federalism, and fundamental rights. Today, with the tremendous expansion of welfare activities of the state, the power of the executive authority to affect the lives of the people, various decisions of the Supreme Court emphasized on every instrumentality of the state is subject to the constitutional limitations. In judicial review, the court has power to declare the acts of the legislature and also executive as void if they are found in the violations of provisions of the Constitution. The judicial control denotes a much broader concept and includes judicial review. Within itself, judicial control comprises of all methods through which the person can seek relief against the administrative action through the medium of courts such as appeal, writs, declaration, injunction, damages, statutory remedies, etc. With respect to the constitution and judicial review, there are various provisions which provides the judicial review of the executive autocracy. Firstly, Article 32 empowers the Supreme Court to enforce fundamental rights when administrative action infringes the fundamental rights. And also Article 226, under Article 226, every High Court has power to give directions in way of writs against any person, including government, in case of abuse of power by infringing fundamental rights or any other legal rights. And also there is a special provision under Article 236. It confers special powers on the Supreme Court to review all such administrative decisions also. Apart from Article 299, there is a contractual liability expected to be made by the president or executed in the name of president in case of a union, and at the same time state legislature also. And Article 300, the tortious liability of the state, it may be union or state in such case also. And also Article 50, separation of judiciary from the executive. These are all the various provisions which specifically provides for the regulation of executive autocracy by the judiciary. With respect to the role of judiciary, the judiciary has played a pivotal role in respect of the abuse of power by the executive authority by compensating or by regulating the administrative actions on the various grounds. For example, in case of the ultra vires, abuse of discretionary powers, the proportionality and legitimate expectations, in case of unreasonable exercise of powers, law of estoppel, the illegality, irrationality, and in case of the procedural impropriety and jurisdiction without or excess jurisdiction and justifiability. These are the grounds under which the aggrieved person can approach the judiciary for the effective remedy in case of the infringement of the rights and freedoms of the particular individual. And also judiciary has played a pivotal role by regulating executive autocracy in various cases for the production of democratic norms and also constitutional framework. The Constitution prevents the possibilities of arbitrariness and tyranny. In plethora of cases, the Supreme Court has given the compensation to the victims by regulating the executive autocracies. For example, in case of Beam Singh versus state of Jammu and Kashmir, Rudal Shah case, in their case, compensation to the victims, and Neil Bati Behra case, here also compensation for contravention of fundamental right to life, and in various cases, the Angre versus Union of India, Ashwant versus Sandal, and in these cases, the court held that in case of the violation by the administrative actions, certainly there will be the remedy. And in also the Pravant Chandra Mohanty state of Odisha, the death due to custodial violence is abhorrent and not accepted in civilized society. The offences committed by accused persons is crime not against deceased alone, but was against humanity and clear violations of rights guaranteed under Article 21 of the Constitutions. And also one of the cases of Repak Kansal versus Union of India, is decided in 2021. The court held that ex gratia monetary compensation to affected families in various families affected by the COVID-19 pandemic. In such cases, the court awarded the various the compensation to the victims. Finally, I would like to conclude that the judicial review is a protection and not an instrument for under interference in executive functions. The whole of judicial review has been developed by judges on case-to-case basis. The doctrine of judicial review is the basic feature of Indian Constitution. The Constitution still provides for checks and balances of powers amongst the organs of the state. I would like to suggest that instead of vicarious liability, there shall be individual responsibility in case of abuse of power by the executive. In a democratic country, no organ is supreme. Every organ should act for the betterment of the society, and no organ shall interfere in the matters of others. There shall not be competitive separation of power, but cooperation amongst the organs of the state for the protection of the rights and the freedoms of the people. Thank you all.
Thank you.
Thank you, sir.
Thank you very much.
I now request our next paper presenter, Mr. Girish Casey, Assistant Professor of Law, KSLU's Law School, Hubballi, to present on the topic, Limits on Liberal Interpretation of Constitution. Over to you, sir.
Thank you, Pranali. Respected Professor Dr. C.S. Patil, sir. Good evening, sir, and good evening, everyone. The topic on which I am going to make presentation is liberal interpretation of the Constitution, and are there any limits on liberal interpretation of the Constitution? The theme of the webinar is focusing upon evolving relations between coordinated organs of the government. My topic is focusing on the relation between legislature with that of judiciary when I speak in terms of limits on liberal interpretation of the Constitution. Constitution is a legal document. It is not a political document. It is a legal document. And because it is a legal document with a special sanctity, it is also capable of being interpreted. And interpretation arises when there is ambiguity. In the morning session, in a keynote address, Professor Vijay Kumar sir was making a reference regarding to a case, AG Ontario versus AG Canada. That is where the court has made it very clear, when the text is clear, the text is conclusive. And we say, the express unambiguous provisions shuts the door for further implication. So whenever there is an ambiguity, interpretation arises. Now the first basic question which arises in our mind is, can principles of statutory interpretation be made applicable to interpret the Constitution? When we refer Article 367 of the Constitution, no doubt we can resort to statutory principles even to interpret the Constitution. The courts have made it very clear, even in Keshwanand Bharati versus State of Kerala, the Supreme Court has said, rules of statutory interpretation may have to be modified or supplemented in view of the fact that the Constitution is a legal document with special sanctity. We cannot interpret Constitution like any other ordinary statute. Constitution embodies in itself fundamental principles of governance of a legal system, wherein there is need to develop sui generis principles of constitutional interpretation. And we cannot interpret Constitution literally by resorting to a textualism or original intention theory. Constitution is required to be interpreted in a liberal and progressive manner, and it has to be interpreted by taking into consideration that it is a value-based document. And when we consider that Constitution has to be interpreted in a liberal and progressive manner, are there any limits on liberal interpretation of the Constitution? So if Constitution were not to be interpreted liberally, in United States of America, the powers of federal government would not have been enhanced by developing doctrine of implied power, necessary and proper clause. And even Francis Corali, Maneka Gandhi, many other judgments, even in India. And the very fact of the doctrine of implied fundamental rights, which has been developed by Indian judiciary, can be attributed to the interpretation. And even for that matter, liberalization of locus standi, which has paved the way for non-state actors to play an active role in enforcing the rights which have been guaranteed to the citizens as well as non-citizens of the country. Now, when I speak in terms of limits on liberal interpretation of the Constitution, the limits may arise out of various aspects. Separation of powers itself acts as a limitation on the judiciary to interpret the Constitution in such a liberal manner so as to rupture the structurization of power as ordained by the Constitution. And judicial deference is a very important aspect, wherein the judiciary itself will have a deference that it will not interfere with certain pure governmental policy decisions. And it's not going to interpret the Constitution whenever it is a policy decision. And the very incident of a written Constitution, that is, written Constitution itself acts as a limitation. The power of amendment is vested with legislature. The judiciary should not interpret the Constitution in such a manner as if it is resulting in an amendment made to the Constitution. So when I speak with regard to judicial deference, it is very much essential to look into some of the judgments where how the courts have delivered judgments expressing the view that there are certain limits on the power of judiciary also while exercising its power of judicial review and interpreting the Constitution. Day-bright lighting versus Missouri. This is a decision of American court where it says the courts have no authority to rewrite the Constitution just as they have no authority to rewrite a statute. In day-bright lighting case, the court says that the courts have no right to rewrite the Constitution. They can interpret the Constitution, but by exercising the power of interpretation, they cannot rewrite the Constitution. And Lachner versus New York. In this case, the court says in interpreting the Constitution, a judge should not modify the text of Constitution so that it may reflect his personal sentiments or beliefs or economic or social policy advocated by him. So in Lachner's case, the court made it very clear, when you are interpreting the Constitution, it should not reflect your personal sentiments and beliefs or economic or social policies. And Justice Black in Evans versus Abney makes an observation. The responsibility of this court is to construe and enforce the Constitution and the laws of the land as they are, and not to legislate social policy on the basis of our own personal inclination. Justice Black makes it very clear, judges, when they interpret the Constitution, they have to interpret the Constitution, they have to construe and enforce as the provisions are there in the Constitution. They are not supposed to allow the personal emotions to creep in. Even in S.P. Gupta versus Union of India, Justice Bhagavati in India has made an observation where he has rightly observed that we have to rid our mind of any preconceived notion or ideas and interpret the Constitution as it is. So we should not have any preconceived notion. We have to interpret the Constitution as it is and not as we think it ought to be. We can always find some reason for bending the language of the Constitution to our will if we want, but that would be rewriting the Constitution in the guise of interpretation. Justice Bhagavati says that if we wish, we can very well modify, alter, we can bend the language of the Constitution. But that would be rewriting the Constitution in the guise of interpretation. See, we can come across this tussle between legislature and judiciary in many cases when basic structure theory is being developed, when Constitution expressly has not imposed limitation on the amending power of the legislature. Can it be done through judgment? Wherein the court made an observation saying that we have not imposed a limitation by bringing an amendment to the Constitution, rather we have interpreted the word amend. So like that, when we look into the approach adopted by judiciary, we have come across that there is a liberal and progressive interpretation, and there are some criticisms which have been leveled against some of the judgments that judiciary has exceeded. To conclude, what I would wish to say is the textual provisions of the Constitution is put into operation through interpretation, and liberal and progressive interpretation is very much essential so as to realize the constitutional philosophy. But the interpretation should be done in such a manner so as to not to disturb the structurization of power as ordained in the Constitution. And the judiciary should exercise its power of judicial review while interpreting the Constitution in order to realize the constitutional goals without disturbing or damaging the fabric of structurization of power done by the Constitution. So with this, I would conclude. Thank you. Thank you very much, sir.
Thank you so much, sir. Moving on to our next presenter, Mr. Hoysal V. and Ms. Devika M.A., 7th SEM BA LLB, RV Institute of Legal Studies, Bangalore, to present on the topic Media and Judicial Proceedings.
Ma'am, I need to correct. It's Mr. Hoysal V.
Okay, Mr. Hoysal. Sorry for that.
Yeah, that is done. That is taken note of in a powerful manner, Mr. Hoysala.
Thank you, sir.
And the other lady also is there.
She's there, sir.
Yeah, both of you can switch on your videos and make your presentation.
So, good evening, sir. My topic is media and judicial proceedings. Media is considered as one of the pillars of democracy with legislature, executive, and the judiciary. Under Article 19, subsection 1(a) of Indian Constitution states about the freedom of speech and expression, which is also applicable for media. Trial by media is also known as investigation journalism or parallel investigation. By the media, when a case is ongoing in any court or adjudicatory body. Further, media trial may violate the privacy of the parties to proceedings while exercising its freedom of speech and expression. In media trial, media itself does a separate investigation which builds a public opinion against the accused even before the court takes up to decide its case. By this, sometimes judges gets influenced and they convict the accused though if he's not guilty. So the freedom of press should be exercised within the mentioned boundaries. Similar to other rights without going off limits. Further, when this freedom is exercised outside the set of boundaries, then there is a chance of inaction of privacy of victims, accused on suspense and influencing judicial proceedings. Like fair trial is considered as the important aspect of the judiciary. But media trial may cause harm to the case of the parties, or it may also influence the opinion of the judge, because no person can completely impartial or unbiased. Media portrays that that the judges are corrupted if they give judgment against the media trial. So in most of the high profile cases, judges give the judgment in favor of media trials. Another factor affected by the trial by media, it might also be the accused to have fairy trial. There are few major impacts of the media trial on the ongoing proceedings, and there are some factors: risk of a witness going hostile, invasion of privacy of parties involved, tarnishing the public image of the accused, an ineffective test identificate parade, polarization of public statement, and influencing the judge's opinion. Media trial hinders the fair trial of judiciary. In recent days, few media-driven cases includes like Nirbhaya case and Sunanda Pushkar case. In this case, one can observe how media has interfered in the proceedings. In the whole case, I would like to brief about Sunanda Pushkar murder case. She was the wife of former Union Minister Shashi Tharoor. She was found dead in a hotel in Delhi under mysterious circumstances. So the circumstances will be like a day before her murder, she had a dispute on Twitter with a Pakistani journalist who is known as Meher Tarar. The dispute was regarding the tweets of the journalist, which hinted at a possibility of an affair between the journalist and of Shashi Tharoor, husband of Sunanda Pushkar. Further, police stated that he was poisoned and murdered, but there was no suspect. In this case, media claimed that Tharoor had committed the murder when the case was still under investigation. The trial was not started in the court of law. Yet Shashi Tharoor had to face a lot of controversy through he got acquitted. There are few laws which governs media trials, such as Press Council of Media Act, Cable Television Networks Act 1955, Section 3 of Police Act 1922, and Article 14 and 21 of Indian Constitution. Unfortunately, these measures are inadequate to prevent the encroachment of civil rights. The 200th Law Commission report deals with trial by media, free speech versus fair trial under criminal procedure. In this report, Law Commission elaborated the positive and negative aspects of media trial. In this report, Law Commission recommended for many amendments, that is to address the damaging effects of sensationalization news reports and accused, victimization by media on the administration of justice, and measures of some postponement of proceedings. International jurisprudence in media trials has tendency towards free and fair trials. As we can see, many conventions, reports, and acts can be seen at international level. Few are as follows. Article 6 of UN Basic influencing the judge's opinion. Media trial hinders the fair trial of judiciary. In recent days, few media-driven cases includes like a Nirbhaya case, where in these cases, one can observe how media has influenced the proceedings and diverted the whole case. Like I explained, she was the wife of the former. So coming, one second, sir. So by this, I would like to conclude, media without a doubt plays an important role in a democratic country by informing their people about what's going on in the society. But when media crosses their certain extent, it becomes unjustifiable. Sometimes media trial creates prejudice to such extent wherein which is said by the channels and papers, media has the right to criticize and have their opinion upon the judgments given by the judges, but not on the trials of an ongoing cases. Thus, in my opinion, no new laws should be formed in order to avoid interference of media in judicial proceedings, and should stop confuse the people by creating their own narratives and polarize them. This is the conclusion. So thank you, sir. Thank you so much.
Thank you, sir. I now call upon our last paper presenter, Mr. U. Shivkumar Gowda, 4th year BA LLB, RV Institute of Legal Studies, Bangalore, to present on the topic Media and the Judicial Proceedings.
Shivkumar is there. Mr. Shivakumar.
Sir, I think
No.
he's not there, sir. In the participants list, he is not there here. Those
He is not there. He is not there. Okay. No issues. If he turns up or approaches, we can provide him a chance tomorrow. That's all right. See, at the outset, let me thank all the paper presenters for preparing their paper, bearing with us till late in the afternoon and make their presentations. First, let me compliment the student paper presenters from the third year LLB. It is a great beginning for you students. Keep up this habit of participating in higher academic activities, professional activities. God will bless you. In this session of paper presentation, we had papers on various subjects, straight touching upon the theme of the webinar and falling within the purview of the sub-themes that we have given. Professor G.R. Jagadish, Madam Sunita, Madam Jayashri, Shri Pramat Adiga, Srimati Akila Prabhu, Shri Jayakumar, Shri Sadashivappa, Shri Girish Keshi, Mr. Vaisala and Ms. Devika. All of you have presented well. I do not want to make any observation on that because it is live. People have appreciated your presentations. When these papers are revised, finalized, and submitted, the Karnataka State Law University has thought in terms of bringing out the proceedings of this webinar in the form of a book. And if it goes into that book, then that should be a lasting contribution made by all of you who have undertaken this research. I thank all of you and compliment all of you for participating in this webinar. I also thank all my faculty members, all the officers of the university, statutory officers of the university, and also the students who have coordinated this activity very well. Back to you, Pranali.
Well, this session comes to an end. I thank all the paper presenters who came up with wonderful topics. Thank you for capturing the audience so well. I also thank Professor Dr. C.S. Patil, Center Head CRDCG, KSLU's Law School, for chairing this session. Thank you so much, sir. The session has adjourned until 10 tomorrow. I kindly request all the participants to join the next session tomorrow at 10 a.m. Thank you so much.
Thank you. All the best.